Open this hearing of the Senate Economics Legislation Committee for the inquiry into the Financial Accountability Regime 2021 and Financial Services Compensation Scheme of Last Resort Levy Bill 2021 and related bills. On 25 November 2021, the Senate referred the provisions of the bills to the Senate Economics Legislation Committee for the inquiry and report by 15 February 2022. The committee has received 33 submissions which are available on the committee's website. As this is a public hearing, a Hansard transcript of the proceedings is being made. However, the committee may determine or agree to a request to have evidence heard in camera. Information on procedural rules governing public hearings and claims of public interest immunity has been provided to witnesses and is available from the Secretariat. Any witnesses called to answer a question for the first time should state their full name and the capacity in which they appear. To assist Hansard with recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I remind any media representatives listening to follow the media guidelines and any instructions of the committee secretariat. I ask everyone to ensure that they have their mobile phones switched off or turned to silent. I would also like to advise witnesses that answers to any questions on notice should be sent to the secretariat by close of business Thursday, 3 February 2022. I now welcome representatives from various consumer groups represented by Choice. Thank you for appearing before the committee today. I invite you to make a brief opening statement should you wish to do so for the Hansard record. And at the outset, could you please state your name and the capacity in which you appear? Thank you.
Thank you, Chair. I'm Alan Kirkland, CEO of Choice, and my colleague.
It's Patrick Verrey, Head of Policy at Choice.
Welcome. Would you like to make an opening statement?
Thank you. I shall make a brief statement. I'd like to outline some key areas of concern in relation to, firstly, the financial accountability regime as proposed, and secondly, the compensation scheme of last resort. And in doing so, I want to make it clear that we strongly welcome the action on these two issues. We consider them to be two of the most important recommendations of the Financial Services Royal Commission. And if we get them right, they've got the ability to make the system work more fairly for everybody, all players in the future. But that's also why it's so important that we get them right at this stage. I'll start with some brief comments on the FAR. We've obviously made a number of recommendations in our submission that we'd like to encourage the committee to consider, but there's one that I'd particularly like to underline, and that is the lack of any civil penalties for executives who breach their accountability obligations under the scheme. When the government first consulted on this scheme in January 2020, it proposed civil penalties in effect of up to $1 million. That would bring those penalties, bring penalties under this regime into line with the new maximum penalties that the government has introduced under the Corporations Act, the ASIC Act, the Insurance Contracts Act, and the National Consumer Credit Protection Act. So it would put the FAR on the same footing in relation to consequences and penalties as the other core pieces of legislation that govern the financial system. We welcomed that proposal from the government back in 2020 because it just made sense. Obligations without consequences, without penalties are worthless. And we were therefore shocked when that provision was deleted from the bill that was introduced to Parliament. So we strongly encourage the committee to recommend that the bill be amended to include penalties in line with the government's original proposals. Turning now briefly to the compensation scheme. Before highlighting a few key points, I just want to put the scheme in context. The government's commitment to addressing the gap, the lack of compensation for many people in the financial system dates back to August 2016 when the government established the Ramsay Review to look at dispute resolution and compensation in the system. A compensation scheme with some characteristics similar to what's in the bill was then recommended by the Ramsay Review in September 2017 and backed in the final report of the Financial Services Royal Commission. And the government, of course, accepted the Royal Commission's recommendation in February 2019. There is broad support, not just within the Parliament, but also among industry groups and a range of professional bodies for putting a scheme in place. And that reflects, I think, an understanding that one of the key reasons that we found ourselves as a country need to have a Banking Royal Commission was because people were losing large amounts of money due to misconduct in the system, and that was considered by the community to be manifestly unfair. As a result, the community had lost trust in the system, and to this day, that trust is yet to be restored. So putting in place a broad, fair compensation scheme is really fundamental to restoring trust. There are a few key things that we think need to be improved in the bill in order to achieve that. The first is to expand the scope of the scheme so it covers all financial services covered by the Australian Financial Complaints Authority, or as an absolute minimum, managed investment schemes, funeral insurance policies and debt management firms, as highlighted in our submission. To ensure the scheme covers both court and tribunal decisions as well as AFCA decisions, as originally promised by the government, and to align compensation caps with the compensation caps that apply at AFCA. Ultimately, this scheme is about who bears the costs of misconduct in the system. And unless Parliament improves the scheme proposed by the government, we'll continue to see individuals, people with the least resources in these matters and the least capability to recover from a significant loss. Those individuals will continue to bear the cost of misconduct, as we saw in the years leading up to the Royal Commission, which is why we think it's absolutely critical that the scheme proposed by the government is improved in those key ways. Thank you, Chair.
Thank you, Mr. Kirkland. Before I go to our Labor senators, I've just got a few questions to ask you. And just the context, I used to be a company secretary of an ASX 200 company. And so the world of remuneration reports and remuneration schemes was something I knew nothing about before I did that. And then I got an intensive course in it. So in relation to the remuneration issues, if the civil penalties were reintroduced, isn't it the case that potentially the executives, the authorised persons, could get an indemnity from the company anyway, or insurance to cover the cost of those civil penalties? So in effect, if that is the case, the individual executive wouldn't be meeting the cost of the civil penalty out of their own pocket, would be covered either by insurance or by through an indemnity from the company, which means the cost is really borne by the shareholders. But how do you, if you're proposing civil penalties, how would they dovetail with usual practice, which is that a senior executive or a director gets indemnification from the company with respect to any exposure they have in the course of their employment, or gets insurance?
I can't comment in detail on that, but if that's, I suspect essentially you're in a better position to comment on the detail of the insurance arrangements than me. But if that is the case, I would argue there's still a significant deterrent effect from having individual civil penalties. The fact that an individual executive, and bear in mind this would only occur in the case of significant misconduct and breach of accountability obligations, but to have a court make a decision or that an executive has breached a legal obligation and has an individual penalty, regardless who ends up paying that, it's still a significant mark against that, black mark against the name of that executive, and rightly so if they're found to have breached these obligations. So I think regardless of who pays, there'd still be a significant individual deterrent effect.
Okay, and I should say, Mr. Kirkland, that the law, the Corporations Act at the moment does have carve-outs with respect to how far those indemnities can cover, but it is a material issue. Then in relation to remuneration, you make a number of suggestions around variable remuneration, delays that should be in place to before a senior executive can access it. And again, I'm looking at this through all those discussions I had between senior executive teams and board members with remuneration consultants, that wouldn't it, some of the unintended, there are unintended consequences, in my view, of what you're proposing in good faith, but couldn't some of the unintended consequences be that senior executives seek more base fixed remuneration rather than variable remuneration? Because they're going to argue that the value of my variable remuneration is much less because there's far greater uncertainty as to whether or not I'll access it. And then there's also the time value of money. Therefore, instead of, say, 40% of my remuneration package being base remuneration, I'm going to want 75% of it to be base remuneration. And that means, in my view, that's a negative development, because I think short-term incentives and long-term incentives are there intended to drive the right behaviour and also align the performance of the senior executive with the performance of the company overall, which of course is impacted by these prudential issues you're concerned about. Do you have any concern that you might simply, in an unintended way, just have an impact on the remuneration mix?
We may see some changes in the remuneration mix, depending on the final nature of this bill. But I think if we go back to what are the fundamental problems that the BEAR in place now and the FAR were trying to address and that were highlighted by the Banking Royal Commission, I think it's that particularly short-term incentives can encourage behaviour towards short-term metrics or outcomes that may be contrary to the longer-term interests of the shareholders and indeed, and more importantly, to the interests of customers. So the idea is that if you do have those short-term incentives in place, and of course, the FAR doesn't seek to ban them, you just have provisions that allows for them to be deferred and clawed back where there is misconduct that breaches accountability obligations. And obviously we'd like to see those obligations expanded to include, similar to what's in the UK, an obligation to consider the interests of customers and treat them fairly as well.
Okay, and now I'll move on to the other topic in terms of the compensation scheme of last resort, because I do want to share the call. You were actually on the sorry, I've just gone blank in relation.
The Ramsay Review, Senator.
Sorry,
the Ramsay Review panel.
The Ramsay, of course. How could I forget the famous Professor Ramsay? So you're actually on the panel for the Ramsay Review, and it actually, I was having a look at it last night. It actually proposed a compensation scheme of last resort that was more narrow. On my reading of it, and please correct me if I'm wrong, Mr. Kirkland, than what you're proposing, wearing your choice hat. And the point that was made, one of the points made in the Ramsay Review, as I read it, was that you could expand the compensation scheme of last resort over time. And I must say that principle had some attraction to me, because it's a bit of a common theme through the submissions is around data and what do we know about claims, where they're coming from, the quantum. You've got a moving regulatory landscape. So the starting out on a reasonably narrow basis, though it seems to me it's broader than what the Ramsay panel proposed, and then perhaps looking to increase it once we know how this is all working, had some attraction. From my perspective, I just want to give you an opportunity to respond to that.
Thank you, Chair. Yes, I was a member of the panel for the Ramsay Review and was pleased to help the government with thinking through some of the gaps in compensation in the system at the time. I guess in relation to just the premise for that question, there are several really important ways in which the bill that's before the Parliament is in fact narrower than what the Ramsay Review proposed and the Royal Commission endorsed, and we understood the government to accept in its response to the Royal Commission. For a start, the Ramsay Review recommended that court decisions should be covered, and the government explicitly committed to do that. And the Ramsay Review also recommended that compensation caps be aligned with those of AFCA. So in those really important respects, the current bill is narrower, in fact. I think the point you're highlighting, though, is around which types of services are covered by the scheme. And I would say the Ramsay Review report was handed down, I believe, late in 2017. So that's a long time ago, before the Banking Royal Commission. Since then, I guess we've seen further evidence of harm in some other key sectors, such as the managed investment scheme sector. The Sterling First collapse has obviously highlighted ongoing problems there, and some of the terrible individual cases that arise where you don't have a last resort compensation scheme where people are victims of misconduct. And also the collapse of the Aboriginal Community Benefits Fund, or UPLA. So it's highlighted some risks in some other key areas. And the other thing that's happened, I think, I guess, to respond to some of the concerns we sometimes hear about the potential cost of a scheme, is that the overall regulatory regime has been significantly strengthened since we completed that report. So we now have the product intervention powers, we have the design and distribution obligations. So there are a number of other measures that should in fact be reducing the flow of, if you like, of cases that might lead to compensation, which means this would genuinely be a last resort scheme in those other sectors that weren't recommended for coverage in the Ramsay report back in 2017.
Okay. All right. Thank you, Mr. Kirkland. I want to share the call. Senator Pratt or Senator Chisholm, you're seeking the call?
Yep, I'm happy to go because Louise didn't respond to my text.
Okay.
Yeah, no worries.
On.
Thanks, Chair. Senator Chisholm here, and thanks for appearing, Mr. Kirkland. The sound cut out for me just as part of your opening statement, so I didn't hear it all. But I just want to check: how does the proposed compensation scheme of last resort that's proposed in this bill differ from what the government promised in February 2019 in its response to the Hayne Royal Commission?
I would highlight, thank you, Senator. I would highlight three key areas in which this is different to what we understood to be the government's commitment. The first, so it's important to say the Ramsay Review recommended a compensation scheme. The Royal Commission recommended the compensation scheme as designed by Ramsay be implemented. It didn't recommend any changes to that. And the government accepted that recommendation and made a few additional comments. So based on that, the natural understanding was that we would have a scheme where the compensation caps would be aligned with AFCA's. That would mean the compensation cap for most matters would be $542,500. Instead, the government has recommended $150,000 as a cap for the scheme, or as proposed in the bill, $150,000 cap. Ramsay recommended, the government explicitly committed including court decisions in the scheme. That's been omitted from the bill. And the government committed to a scheme that goes beyond financial advice. So in fact, the government already agreed to go beyond what was recommended by the Ramsay Review in relation to coverage. We understood that to mean a broad scheme, whereas what's proposed in the bill is pretty narrow. It doesn't go very far beyond financial advice. So we've got lower compensation caps, court decisions excluded, and pretty narrow coverage, contrary to what the government had committed to deliver.
Okay, so just following on from that, so as part of your submission, consumer groups outlined concerns around the exclusion of managed investment schemes from the proposal. Do you have any estimates of the number of Australians who might be affected by this exclusion?
It's difficult to estimate the numbers of people that might be affected, but it is worth noting that in the Ramsay Review report, if you bear in mind, the only matters that get to a compensation scheme are those where compensation has been ordered and then the firm is unable to pay. And so at the time the Ramsay Review report was done, the Ombudsman scheme, the main one was the Financial Ombudsman scheme, and it had data on the categories and the numbers of unpaid determinations. And after financial advice, managed investment schemes were the next most significant category of unpaid compensation claims. So I can't put a number on it. I would say it's not as big as financial advice, but it's probably the second biggest category based on that earlier data.
Okay. So one of the major examples of a failed managed investment scheme in recent years is the Sterling First collapse, which is predominantly centred on WA, which this Economics Committee has been having a look at, and Senator Pratt's been part of that. In Choice's view, would the inclusion of managed investment schemes in the proposed legislation help the victims of Sterling First?
It would assist many of the victims of Sterling First, but I think in a way, the Sterling First example probably highlights the way in which this scheme would also be tightly constrained, contrary to some of the kind of criticisms of it. Because if we look at the matters that have gone to AFCA before AFCA stopped hearing claims in relation to Sterling, there were some where AFCA found that, in fact, there was a claim for compensation against the managed investment scheme, and some where it didn't. So it turns on the particular circumstances, but certainly a large number of those victims of the Sterling First collapse would have access to compensation if managed investment schemes were included in the compensation scheme.
Okay. The inclusion of managed investment schemes could create a moral hazard issue, although this was identified as being a minor issue as part of the Ramsay Review. Could you talk us through why you don't think this is a significant issue?
Certainly. Firstly, I mean, one of the observations that the Ramsay report made was that there were a number of measures in place that were being implemented at the time to strengthen the system, which would reduce the risk of moral hazard, and that has indeed happened with some of the legislation like the product intervention power legislation and the design and distribution obligations. So they have reduced that risk significantly. But I think the bigger reason for really discounting moral hazard is that it requires consumers to make a fairly significant leap at the point that they're deciding to engage with a financial product or service provider. Now, having spoken to many of the victims of Sterling First and other collapses over time, these are typically not people who spend their spare time reading the Corporations Act or the other legislation that governs the financial system. For moral hazard to be a real risk, you would require those people at that point of entering an arrangement to be actually thinking through and understanding that this is a matter where if something goes wrong, I might be able to go to AFCA. I've got a good chance of having compensation awarded by AFCA. And then if the firm collapses, there'll be a compensation scheme that will step in. I just think that's a fanciful proposition that that people will be thinking in that kind of way. And then if we think about the behaviour of firms, if there is a concern that firms might market their products, their supposedly risky products, on the basis that people will have access to compensation if something goes wrong, then I think there's a simple solution to that. I think the committee could recommend the bill be amended to make it an offence for firms to advertise that their products are covered by the compensation scheme.
Okay. Consumer groups also called for the inclusion of debt management firms in the scheme. What are the impacts on consumers of excluding debt management firms?
Debt management firms are typically firms that target people with very few financial resources. They target people in financial trouble. They promise to help them. They charge exorbitant fees and they do very little to help. So the impact is, if you looked at it in dollar terms, they're going to be much smaller dollars than we might see in relation to managed investment schemes. They might be in the tens of thousands of dollars or even a little bit less for some of these clients, as highlighted by the case study in our submission. But for the people involved, these are very significant amounts of money. To actually charge $15,000 to somebody who's already in deep financial trouble, having trouble paying their rent, having trouble paying their utility bills is terrible behaviour and has a deep impact on those people, and giving them access to compensation will make a big difference in their lives. But more importantly, I think it'll also encourage the industry as a whole to actually behave better and be less predatory in the way in which it targets those vulnerable consumers.
Okay. The Ramsay review noted that improvements to regulation and industry behaviour should occur alongside the establishment of the compensation scheme of last resort. What improvements need to be made?
I think a number of the improvements that were contemplated at the time have been made in the years since, but the critical one, the other missing piece, as highlighted by the Royal Commission report, and indeed the matters before this inquiry, is the financial accountability regime. Unless we have clear conduct obligations and accountability obligations on executives and senior managers, with consequences for breaching those obligations and consequences for acting in a way that treats consumers unfairly, then we won't have completed the full suite of measures we need in order to reduce risk to consumers engaging with the system.
Okay. And just as a follow-on, do you think the implementation of the product intervention power and the design and distribution obligations in relation to managed investment schemes has been an improvement?
It has been an improvement, but it's important to note that despite while the product intervention powers do help to reduce risk, as I've highlighted, they are still tightly constrained. So they can only come in effectively after the fact, where ASIC has enough evidence to form a view that there is significant harm being caused to consumers. So they can't really be used proactively. They wait for harm to be caused, and some of that harm might be to people who would then miss out on compensation. And the design and distribution obligations are a really important reform, but we're yet to really understand their effects. So it's too early to comment on how effective they'll be.
Okay. The Consumer Affairs Forum, which existed prior to the government's decision to abolish this ministerial council, was considering the issue of debt management firm regulation according to its penultimate communique in 2019. Are you aware of any progress on this matter since then?
We are aware that this is an ongoing matter of concern to a number of the states and territories, and that's because they typically help many of the consumers who are targeted by debt management firms, and they often can't help them. They get inquiries, but they can't help them. So it's still a matter of concern, but we're not aware of any current work to address that problem.
Okay. And this will be my final question, Chair. Has the abolition of the Consumer Affairs Forum impacted consumer policy?
We would say the abolition of the Consumer Affairs Forum has had a big impact on consumer policy, bearing in mind that a number of the key pieces of legislation that govern consumer protection are cooperative. They depend on cooperative legislation and regulation by the states and territories in the Commonwealth. So it's a huge gap in the system not to have a formal forum where governments get together and talk about how they're working together and how the legislation needs to be improved.
Thanks, Chair.
Unmute. Senator McDonald, do you have any questions? No. Senator Bragg?
Thanks very much, Chair. So I guess I just wanted to understand in my own language how this will work in terms of the scheme. So if I walk into a financial planning organisation and get some bad advice, the first port of call is the professional indemnity insurance of the advisor if it is bad, and then the next port of call is that licensee compensating that individual for that bad advice if there was any wrongdoing, or they could also have additional regulatory action. So when could you imagine this particular scheme could be used? Is it most likely to be used when there is a sort of a phoenixing of a planning firm? Or, I mean, could you just, I mean, it is a very dense area of law and I'm not always the sharpest tool in the shed. So would you mind just walking through that a little bit?
Certainly, Senator.
You're not the bluntest either, Senator Bragg.
Time will tell.
From the perspective of the consumer, their first port of call will be to make a complaint to the firm, and if they're not happy with that, go to AFCA. So the process for them, they wouldn't go near the professional indemnity insurer normally. But I think you're asking about who funds any compensation. So first, the scheme will only kick in if the consumer has actually got an order of compensation that the firm is unable to pay. Now, at the firm level, the regulatory regime requires the firm to have adequate provisions for providing compensation. So if a compensation order, or as often happens, a number of compensation orders are made against the firm, the first port of call is actually the firm's own resources that it's required to have under the Act. Second port of call would be for the firm to draw on its professional indemnity insurance, but that's a process that's largely opaque to the consumer. And then the scheme would only kick in if the firm is unable to pay, and typically that's because the firm has ceased to operate. Now, sometimes that's because it has gone into voluntary administration or become insolvent. In other cases, it's because the firm just sort of disappears. So yeah, I guess all of those situations fall under the broad description of phoenixing.
Okay, so effectively there'd have to be an AFCA determination, and then there would have to be a firm unable to make provisions or unable to meet its AFCA determination. Okay, and then that money would be drawn from the scheme, which is funded through industry levies. And is that quarantine between each part of the sector, or is it one big pool?
So the way it's been designed, as I understand it, is broadly one big pool, but the way in which the levies are collected is different based on industry. So there are different higher risk industries will make greater contributions to the compensation scheme as is appropriate, and that then helps to create the incentives for those sectors of the industry to lift practice overall in order to reduce the costs of levies.
All right. Well, thanks for that, Chair.
Thank you for that. Senator Pratt, do you have any questions you want to ask?
Yes, thank you. Just briefly, if there's time, Chair, I wanted to deepen the questions around insurance. In terms of the Ramsay Review's understanding, what role might insurance play when a company does become insolvent?
It depends on where the company is in the insolvency process, but look, with insurance in general, from a consumer perspective, the consumer doesn't know who the insurer is. It's often difficult to find out who the insurer is or gain access to their insurance policy.
Yeah.
Their claims then may be subject to excesses and limits within the insurance policy. So insurance isn't a solution to compensation for consumers. When firms become insolvent, often that means then that the insurance cover terminates, so it can be even more difficult to access for the firm or the administrators or whoever's trying to pick through the pieces of what's been left to actually access the insurance.
And one example I'll provide
Okay, so
is
it is, yeah.
with a witness who appeared before the committee last year, Alan Fardeau. He had an after determination made of $130,000, and the excess on the professional indemnity insurance was $100,000. So he would only likely see $30,000, and he never got an option to read the contract. It was all very confusing. So I think that's a really strong example of why PI insurance really isn't suited to consumers.
So in the case like that, where if the committee and the parliament were to determine that managed investment schemes are included, one of the AFCA rules is that you can't, if you've already had a determination, you can't have another one. Do we need to fill that gap in later to change the rule so that under those kinds of circumstances you can come back to AFCA, or does it point out an underlying problem with insurance overall? It would seem ridiculous, and a similar situation came out with the Fair Entitlement Guarantee, that people who were paid out under industrial relations law could get less than if they were paid out under the FEG. So what happens if a consumer is eligible to more because there's no cap because it was paid out under insolvency, versus how do we fill in? I'm assuming that the compensation scheme of last resort, it's not last resort if the company is still trading, but you've got insurance that was not paid up to that same level. Has Choice thought about how we fix those issues?
So we have recommended in our submission, the joint submission, that there should be a broad definition of what's meant by a firm being unable to pay, which is one of the tests that the scheme would look at when working out whether the consumer has access to the scheme. And we would say if there's a broad definition, then it should allow the scheme to step in a situation, for example, where a consumer where compensation's been ordered by AFCA, a consumer has received part of that, but they haven't received all of that compensation order because of an excess, for example, in the firm's professional indemnity insurance policy. The other thing I would say is that AFCA did, of course, start hearing some of these matters on the understanding that a scheme would be implemented as promised by the government, and then it ceased doing so. It sort of suspended doing so. I imagine it will go back to those. But if there were any matters that AFCA determined based on a prior understanding of this scheme, and the scheme that's ultimately legislated is different to what AFCA was contemplating at the time, then we think it would be appropriate for AFCA to go back and re-examine those matters and consider whether a different compensation order is appropriate.
Okay, thank you, Senator Pratt. Mr. Kirkland, just in the few minutes left, and I want to get this on the record, can I just thank you for all the service you provided in relation to this area, both through the submission you provided, but also through your service on the Ramsay review. I read the material and it really is very impressive. So at the outset, thank you for that, and let us put that on the record. I have a concern when looking at the numbers in terms of the increase of the cap from 150,000 as is proposed in the bill that we're reviewing here today, up to the AFCA limits, which I just jotted the figure down. It's $542,000, is it?
Yeah, that's for most cases, yes, Senator.
Okay, and then if you combine that with another recommendation from the consumer groups that the cap on the maximum annual levy across the whole of the industry, or $250 million, should be able to be lifted, it does concern me that you're looking at what becomes an open-ended scheme rather than a scheme which has clear barriers and parameters around it in relation to its cost. And a consistent theme coming through quite a number of the submissions from the various associations is that they're concerned that their sectors of the industry are going to be incurring costs to cross-subsidise other subsectors of the industry which are maybe doing the wrong thing. And even within a subsector of industry, there's a concern, well, we're going to be bearing the costs for the rogues within our subsector. How do you respond to that concern of, first, that your recommendations would tend to lead to the scheme becoming more open-ended, I guess, in the first case, and secondly, that participants in the scheme who, or in a subsector or in a different sector who have high rates of compliance will end up cross-subsidising the rogues who've disappeared from the landscape and not meeting the liabilities which they should meet?
It's important to note the scheme is, of course, subject to caps. And within the AFCA caps, the majority of awards made by AFCA are significantly below those caps of, in general, $542,500. So we're not talking about a large number of matters that would hit that cap. And of course, as you've highlighted, Senator, in the question, there is proposed in the legislation a cap of $250 million a year for the scheme as a whole. We've simply argued that the minister should have the ability to vary that, including upwards. And I think that if a decision to vary that upwards was going to have a significant impact on any part of the sector, that would be something any minister would take very seriously. I think the submissions to the committee highlight the sort of degree of industry advocacy around any measures that might have an impact on the industry, and that would be what you'd see if a minister was considering increasing that cap. It is, however, important, as argued in the Ramsay Review report, to create incentives for industry sectors to improve overall standards of behaviour. And the model where sectors or subsectors of the industry that are causing greater calls upon the compensation scheme will have higher levies will do that. It creates a financial incentives for parts of an industry to work together to improve standards of practice overall, and where necessary to go to government for the good players within that sector to go to the government and say, we think you need to legislate in order to lift the floor of behaviour. I think that's that's a really fundamental part of the scheme. It's always been, I think it's been recognised for some years now by some of the bigger players in the scheme that there are benefits that all firms receive if you have fair compensation in the system. So during the Ramsay Review process, the major banks, most of whom were still owning financial advice firms at the time, said, we believe there should be a compensation scheme covering financial advice that we will help to fund, even though we're probably not going to result in many matters going to that scheme, because we tend to ultimately cover compensation anyway. So those major firms at the time actually recognised there is a benefit to the industry overall of having fair compensation. That's one of the biggest reasons, going back to my earlier point about restoring consumer trust, for ensuring that we've got adequate compensation caps.
Okay. All right. Well, thank you very much, Mr. Kirkland, Mr. Verrett, for appearing today. Much appreciated. I would ask that you now disconnect from the video conference, but you can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. Thank you very much.
Thank you, Chair.
Thank you, Chair.
Okay, I now welcome representatives from the Association of Super Funds of Australia. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions on notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. I invite you to make a brief opening statement should you wish to do so, and for the Hansard record, could you please state your name and the capacity in which you appear?
I might go to my colleagues, Julia and Helena, to read into the Hansard their name, and then I'll start with a brief opening statement.
Okay.
Thanks, Glenn.
Please.
Julia Stannard, Senior Policy Advisor with ASFA.
Thank you, Ms Stannard.
Helena Gibson, Senior Policy Advisor with ASFA.
Thank you, Ms Gibson.
Glenn McRae, Deputy CEO of ASFA. I want to thank the committee for the opportunity to appear today. ASFA is a non-profit national organisation whose mission is to continuously improve the superannuation system so all Australians can enjoy a comfortable and dignified retirement. We focus on the issues that affect the entire Australian super system and its 3.4 trillion in retirement savings. Our membership is across all parts of the industry, including corporate, public sector, industry and retail super funds, as well as associated service providers representing almost 90% of the 17 million Australians with super. On establishing the financial accountability regime, ASFA appreciates government's consideration and incorporation of industry's feedback on the FAR legislation, particularly the clarification provided in the explanatory memorandum that the regime does not apply to ordinary salary and wages, which in some cases may be the only form of remuneration received by individuals. However, we are concerned that the definition of significant related entities may be too broad and inadvertently capture parent companies even when they are not APRA or ASIC AFSL regulated. In the absence of a carve-out, the FAR regime may potentially apply to the telecommunications industry and the aviation industry, which we don't consider to be within the policy intent of the draft legislation. We also remain concerned with the current misalignment between the requirements of the FAR legislation and APRA's CPS 511 and consider this needs to be actively addressed. On establishing the compensation scheme of last resort, the committee's inquiry is also examining the bills that will establish the Financial Services Compensation Scheme of Last Resort, which collectively establish the framework for the regime as well as the levy that will fund it. The scheme's introduction involves a difficult balancing act, addressing the plight of consumers who have been able to secure compensation that is due to them from a financial services provider, while not overburdening the industry, requiring other providers who are unrelated to meet these costs. There are no simple solutions, and the model adopted in the bills is a result of an extensive process of consultation across many years, many inquiries, and many reviews. In this context, ASFA considered the proposed model to be appropriately targeted and supports its passage through Parliament. We welcome the implicit recognition that many subsectors have never contributed to the issue of uncompensated losses in a historical sense and are highly unlikely to ever do so. We've noted in previous submissions in relation to the scheme, APRA-regulated super funds operate under prudential regulation and extensive legislative constraint. We are unaware of any instance where a determination made by AFCA or its predecessor, the SCT, against an APRA-regulated super fund has ever gone unpaid. There is also an established mechanism to address eligible losses suffered by APRA-regulated funds as a result of fraud or theft. Whilst we support the models outlined in the bill, we consider that the accompanying regulation should be released as soon as possible, and the proposed power to impose a special levy should only be used after further consideration at the time of any black swan event. ASFA welcomes this inquiry by the committee, and we welcome any questions you may have.
Okay, thank you. Thank you very much, Mr. Cray. I might kick off. I just want to, in the first instance, cover your concerns with respect to the ambit of the FAR regime, perhaps extending too far, and excuse the pun, which is may well be unintended. So there are particular corporate, foreign, and investment-only entities which, in your view, you do not think should be covered, or it should be made clear are not covered by the FAR. Can you walk us through each of those, and in each case give us the rationale for why it should not fall within the ambit of this legislation?
I might turn to Helena and then add anything if needed.
Okay.
Thank you.
Gibson.
Thank you, Senator, and thank you, Glenn. What we have done in reviewing the legislation is looking at the intent, and we don't believe it's the intention of the legislation to capture directors and executives in organisations that are in industries outside those that were identified in the legislation. So when we look at the parent companies, we're looking at organisations that don't operate in banking, insurance or superannuation. And the examples that were provided in the opening statement were telecommunications and the aviation industry. And so what it would do is go beyond what we believe the drafting of the legislation was. And that is to look at the financial services industry. And it would capture unintentionally, potentially these other industries. And so that's one example with the corporate ownership. The second example around foreign entities can be quite complex when you consider organisations that invest in Australia, a parent company who doesn't have any perhaps operational control over the activities of the RSE licensee, and all of that sits within Australia. We feel that by extending it beyond to foreign jurisdictions, it's actually going to create a lot more complexity, and also dive into the area of consideration of the home jurisdiction and how that would apply with the domestic jurisdiction. And I think a good example of that is around when we look at international tax, and how when we've got situations where there's tax applied both in Australia and in their home jurisdiction, we always typically have a double tax agreement with that country. And in majority of instances, the home domicile country will overrule Australia and our requirements. So I think we're really going into a territory that hasn't been charted before, and it's very much in its infancy, and it really is opening up our industry to complexity that we do have with international tax, and that's probably a big concern of ours as well.
And then the third category is this this category of investment entities.
Absolutely. So yes, so we also have a lot of superannuation funds actually have structures set up purely for the holding of investments, and there's no operational trustee responsibility within that ownership structure. It's purely an investment structure. So what we are trying to ensure is that we are keeping it all at that trustee level, and ensuring that any of the requirements extend just to that trustee operational organisation and not into any affiliation. And if you go into, and I'm not claiming to be a trust expert, but it's very common practice in Australia to have a trust structure to hold investments in multiple different types of lines of industries and companies. So that's all we're trying to do, just to apply the same logic.
Okay. And then the second issue that's raised is this issue of deferred remuneration under the FAR and a potential misalignment between APRA's CPS 511 and what's proposed in the legislation. Is that correct?
That's right. Yeah. So CPS 511, I understand, will be reviewed at some point this year. But if you look at the drafting of the legislation, the actual legislation takes one takes a backward-looking approach and one takes a forward-looking approach. And we're just hoping to have that consistency. And there are a couple of other anomalies between the two, and one in particular is around the deferral of 40% for CEOs, It's quite a significant amount and doesn't align between the two. So there is quite a bit of detail within that, but we're hopeful, and our preference would be that the CPS 511 comes into line with the legislation.
Okay, and the last point I wanted to provide an opportunity to get some evidence from you on the record is in relation to this certainty which your organisation or association is seeking with respect to, I guess it's the quantum and methodology of calculating the quantum of levies across your sector to support the CSLR. So is it the case that what you're seeking is release of the regulations which provides those mechanisms, the mathematics, if you like, with respect to the calculation of the levies, so you can actually get an appreciation of what it means for the members of your association?
Yes, absolutely.
Okay,
Yes,
and
Chair.
has there been any, and I'm not across, obviously I'm prepared for this hearing, but I'm not across all the other discussions and consultations that have taken place. Have there been models which have been discussed, presumably in relation to the funding, which allows you to have some sort of appreciation of what it means to your members in terms of quantum?
Chair, to be honest, no. The last round of broad consultation on the scheme was the Treasury discussion paper from December 2019. There were some roundtable meetings with industry in the early months of 2020, but that discussion paper didn't propose a specific model. It was quite a broad discussion paper. It was asking questions about what potentially could be put in place rather than presenting industry with a specific model that it could analyse and then comment upon. So there were some questions around potential funding models kicked around during that consultation, but they were not attached to a specific model. And so it's not possible to translate them directly to this proposed model we have in the bills before us. So the bills set up, as Glenn mentioned in his opening statement, the overall framework for the scheme and the levies, but they leave all of the detail for the methodology for the levy and also indeed for which subsectors might be called upon to pay the levy. That will be covered in regulations. So what we're really asking is that we see a draft of those regulations as early as possible so that industry can receive some clarity and certainty around what their potential exposure may be.
Okay, so the message for this committee is the regulations are extremely important in terms of the methodology of calculating the levy, and stakeholders are going to be intensely interested with respect to those regulations, and I can imagine all the different subsectors and sectors having their particular views. So there needs to be sufficient time for a fulsome consultation in that regard. Is that correct?
That's
Yes.
right, Chair.
Okay, thank you very much. Senator Chisholm, you taking the call?
Thanks, Chair. Yeah, I just had one follow-up question, which was from the first part of your questions, just around ASFA's concern around the inclusion of some related entities. And I think you talked through sort of broadly why you're concerned about that. But I suppose what I was just interested in is what would be the potential impact of members of affected funds?
So I might jump in here, Senator. So I think what it's adding to is the complexity of adhering to the regime. So if you're in a fund, potentially a corporate fund or a fund which is owned by a foreign entity, you as the trustee are then going to have to deal with your parent company and try and obviously adhere to the regime. So it's adding unnecessary complexity and compliance when that is not the intention. And as you can imagine, trustees and CEOs of funds are extremely busy at the moment. There's a lot on their plate. And the last thing they probably want to be dealing with is dealing with parent companies or other entities that are completely unrelated to their fund to ensure compliance with this regime.
Okay. Thanks, Chair.
Okay, we've got some additional time available. So, Ms. Gibson, I'm going to tease out this issue of remuneration with you, if I can. And the concept of you have a total remuneration package, which typically includes base remuneration, a short-term incentive, and a long-term incentive. And you made the comment about whether or not the APRA instrument is backward-looking and this legislation's forward-looking. So there appears to be a disconnect. When the bill refers to 40%, a minimum of 40% of variable remuneration, is it looking at variable remuneration opportunity or variable remuneration target? And the reason I say that is typically, as I understand it, when a remuneration package is put together, if the senior executive's performance is satisfactory, if you like, then perhaps they might get 75% of their short-term incentive. If they outperform, they might get 150% of their STI. And if you go to remuneration reports, you'll see the variabilities in terms of that performance. And the same thing can happen in terms of LTI. So variable remuneration by its nature, you're sort of looking at opportunity rather than a fixed amount. How does the proposal work in terms of this 40% limit? How does it work under the APRA instrument in terms of what does the 40% apply to? The target or the opportunity or the maximum? Do you understand my question?
Yes. No, thank you. Look, it all comes down to the use of the words as well, being quite different between the two instruments. And so I think we need that clarification. So when we're looking backward-looking versus forward-looking, as you described, it's what is agreed in the contract. But when you're looking in the Prudential CPS 511, you're looking at what's actually received and then how you need to defer that. So it's actually in principle a different approach. And I think that's our key issue.
Okay. So if okay, well that's an important point. I think that that's made.
And that's why we've called it out in our second submission, because we wanted just to focus on what we really felt were the key issues, as opposed to really tinkering around the edges. Yeah.
Okay. All right. Well, look, I think I understand that point now. Thanks for that. That was very useful for me, at least. Mr. McRae, I wanted to ask you this question in relation to parent companies. If a parent company does have within its group a superannuation company or some other entity that might wholly owned subsidiary, it might well be, in the space which is covered by this bill, why shouldn't the senior executives of the parent company have some sort of responsibility in relation to what's happening in the subsidiary?
Look, ultimately, accountability for a fund is on the trustee, and the government has introduced a lot of legislation in particular to really clarify that and ensure that there is accountability. But historically, there has been arrangements for large corporates where they would have a super fund sitting there that would be providing services, and then obviously members of that bigger corporation would then be putting and making contributions to that fund. The issue of whether the parent company CEOs and executives should be accountable, starting to get into a realm of you would want to be consistent across the economy. And so therefore we would be looking at the heads of supermarkets. You'd be not only aviation, telecommunications, you'd be looking at pharmaceutical companies. I don't think that's what the government wants out of this, to have a regime where, in terms of remuneration, the government was controlling remuneration for people from big corporates and that way they are structured. My understanding of the intent of this legislation is to target and ensure that whilst there may be incentives, people are not provided appropriate remuneration when perhaps their fund has not done well, and they're subsequently left, because super is a long-term prospect and you need to look at sustainability. So I think at the end of the day, Senator, why it's not appropriate they are dragged in is I don't think that's what this legislation is trying to achieve. If you wanted to think about that economy-wide, then you would introduce an economy-wide piece of legislation But I mean, that's gone beyond my current scope, but as a former Treasury official, I don't think governments of either persuasion want to look at controlling the way remuneration arrangements are structured, as long as they meet basic corporate governance principles and are approved by boards and by shareholders.
And so I guess, Mr. McRae, just extending your logic, you talk about the intention of the legislation, but in terms of the objects of the legislation, if we can lift it up to that, in order to meet the objects of the legislation, there is either A, no need to extend it any further, and B, the consideration really comes back to those areas where we should be careful that it doesn't unintentionally extend into, because that is neither necessary to meet the objects of the legislation, nor is it probably the intention of the legislation. Is that a fair comment?
Yes.
Okay. All right. Well, thank you very much for your evidence today. I do appreciate it. So if the committee appreciates it, I should say. So I'd ask that you now disconnect from the video conference. You can continue to observe the hearing, should you wish to do so, through the live stream on the Parliament's website. Thank you very much.
Thank you.
Okay, so we're running a bit ahead of time, which is quite unique in my experience as a committee chair. I'm not sure that's a reflection on me or just as the way these things run, but we're waiting. Our next witnesses will be from the SMSF Association. So I think Mr. Moroney's there.
Yes, both of us are here actually, Mr. Chair. Hopefully the video is coming through now.
Yep, it is. So Senator Chisholm, are you happy if we proceed with the next witnesses now?
It's Louise here. I'm happy for us to.
Oh, okay. Thank you, Senator Pratt. All right. So I now welcome representatives from SMSF Association. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear?
Thank you very much, Mr. Chairman. I'm John Moroney, the Chief Executive of the SMSF Association, and I'm joined by my colleague Peter Burgess, who's our Deputy CEO. I'll ask Peter to make our opening statement.
Thank you.
Thank you, Chair. The SMSF Association welcomes the opportunity to appear before today's Senate inquiry. The SMSF Association is the peak professional body representing Australia's SMSF sector. We provide SMSF investors with access to independent education materials, and we set education and professional standards for a diverse range of professionals servicing SMSFs, including financial planners, accountants, auditors, lawyers and actuaries. The SMSF Association is committed to leading the professionalism, integrity and sustainability of the SMSF sector. The SMSF Association supports measures which strengthen consumer protection. We have been a long-term advocate of the need for a compensation scheme of last resort for the financial services sector, and we are pleased to see legislation to give effect to such a scheme now before the Parliament. However, it is critically important that the scheme is a genuine compensation scheme of last resort, and to ensure the sustainability of scheme funding and the confidence of consumers is broad-based. It's important the establishment of a compensation scheme does not in any way distract or disincentivise AFCA from taking action and appropriate measures to generally seek and obtain payment from a financial services entity once an AFCA determination has been made. In our view, to ensure the scheme operates as a genuine scheme of last resort, the expected level of APCA endeavour and action to chase down unpaid determinations and fees should be clearly stated and defined. Similarly, many claims that seek to be remediated via this scheme could be adequately addressed by professional indemnity insurance if the requirement to hold such insurance was upheld by stronger regulation and oversight. We note the government has recently commenced a review into professional indemnity insurance for the financial advice sector, and we fully support this review. The SMSF sector is deeply concerned that the scheme does not adequately incorporate all market participants. Of particular concern to the SMSF sector is the exclusion of managed investment schemes. Over the years, SMSF investors have suffered substantial financial losses because of the misconduct and subsequent insolvency of managed investment schemes. Trio Capital, a responsible entity for 28 managed investment schemes, was one such example. The Trio case exposed a significant gap in the compensation options available to many investors and highlights the need for an alternative mechanism to protect both advised and unadvised investors. This is particularly relevant to self-managed super fund investors who, unlike members of APRA-regulated funds, are not eligible for compensation under Part 23 of the SIS Act. We believe all investors, regardless of the financial product they choose, should have a genuine opportunity to seek financial compensation if they suffer losses because of the misconduct of others. In our view, the scope of the scheme should be broadened to include any financial services classes under APCA jurisdiction. This would include operators of managed investment schemes. The escalation of compliance costs and ASIC levies in the financial advice sector and the difficulties faced by financial advisors in providing affordable financial advice have been well documented. Given the exclusion of product providers from this scheme, it's inevitable the spotlight will be on financial advisors for the allocation of fault. Therefore, limiting the scope of the scheme to the financial advice and other specified subsectors is very likely to result in a disproportionate share of the cost of compensation being apportioned to the financial advice sector. Broadening the scope of the scheme and ensuring the determination of levies payable by each subsector is made with regard to each subsector's recent history of unpaid determinations will result in a more equitable contribution from all financial services classes under APCA's jurisdiction. We are happy to respond to any questions the committee may have. Thank you, Chair.
Thank you very much, and thank you for the work that you put into the submission that was made. I did read it very carefully and do appreciate that. I might kick off with a number of questions if I could. Firstly, in relation to this issue of professional indemnity insurance and the importance of professional indemnity insurance, and you refer to a report, the St. John report in 2012, which looked at this issue. Some previous witnesses have made mention of the fact that, and take the Sterling investment case as an example, where one of the people impacted by that awful affair, and I say that having served on a committee with Senator Pratt that's actually looked at that episode. One example was given of someone who pursued a claim and found that the excess on the professional indemnity insurance was $100,000. So in terms of their claim for $130,000, $120,000, at the end of the day, they only received $20,000 or $30,000. The majority of the claim wasn't satisfied because of the excess level in professional indemnity insurance. Given that the terms on which professional indemnity insurance is provided is market driven, what can the government do practically, or what should the government and/or regulator be doing in terms of the availability of professional indemnity insurance and the terms and conditions on which it's offered?
We would certainly like to see a more active regulatory response, I guess, to PI insurance cover. So making sure that licensees have adequate PI cover and that those policies are fit for purpose. So addressing those issues that you referred to. So I think that would be our first comment, is making sure that there is proper regulatory oversight of licensees and ensuring that they have the proper policies in place.
Right. Can I just, sorry, I'm just going to interrupt you there because I want to drill down into each of the elements of this so we can try and come up with fact. So I have a series of questions I can put to the regulator in this regard. So it does help me. So it's a question of ensuring that the providers of the financial services actually have for example, the professional indemnity insurance that they represent they have, because I guess they could go out and get the cheapest professional indemnity insurance possible, or have all these exclusions, or have a huge excess. So in reality, the professional indemnity insurance isn't going to provide the coverage for consumers when they seek to access that insurance. Is that the concern?
That's right. I think one way that this could be addressed is by requiring licensees to make an annual declaration that they have appropriate PI cover in place. We see something similar in the Tax Practitioners Board and in the obligations that they set for their members, that they are required to provide an annual declaration that they hold sufficient professional indemnity insurance. So that's one way that we think it could be applied to the financial advice industry.
And then presumably it's a question of what's happening in the market in terms of the provision of this sort of insurance. And typically as claims increase, the cost of the insurance increases, and that's passed on to consumers, and or access to insurance on terms such as excess and exclusions can become more narrow, or can have a negative impact on ability to access the insurance. Isn't that right?
That's correct. That's why we support this review that the government has recently started on the PI insurance cover held by financial services industry or financial planners. And part of that review is checking to ensure that there are policies in the market that are fit for purpose. And if not, what changes need to occur to ensure that that we do have these insurance policies that are fit for purpose.
Okay.
Perhaps if I could just add on there, it may be something where it's worthwhile ASIC having a review of how it goes about ensuring adequacy, both at the time of licensing ongoing, as Peter has mentioned, but also looking at the way that APRA sort of monitors reinsurance arrangements generally for the insurance sector. So I think there are sort of models around in other parts of the regulatory framework in Australia and other jurisdictions where the use of professional indemnity insurance as a key mechanism to ensure that those that are taking the risks are paying for that directly, because that's a better approach than compensation scheme of last resort is having all the other market participants sort of paying. So having a more functional professional indemnity market that's closely monitored by the regulator and in conjunction with looking at best practice, both within the...
Chair, I've got a supplementary question to that.
Yes. Sure. Senator Pratt, over to you.
Could the scheme not deem that, yes, you're required to have professional indemnity insurance, but that I'm not sure the extent to which we regulate insurance for this to be the case, but that once a policy is provided, it will be deemed to have coverage, and that therefore the exclusions will be avoided, and an insurance company will have to assess the product properly as to whether they're prepared to insure it without the kinds of exclusions that might affect determinations in this case. I just can't see how you can say we'll have an insurance policy that covers this and you're required to have it without very real oversight of what's in it with those carve-outs, and that therefore the policies themselves should be deemed to be adequate and suitable, and that's where the liability will rest with the insurance company.
It's a very complex question, Senator, and we certainly believe that's an area that the Treasury review that's Peter has mentioned that's underway should be looking at what's the optimal mechanisms for reducing the risk that the professional indemnity insurance doesn't deliver what it's set up to do. And I don't think there's a simple solution there, because if the requirements are made too strict, most of the professional indemnity insurance is sourced outside Australia, that you would potentially have an exit of suppliers from the marketplace. So you want suppliers to offer good, fairly priced and comprehensive cover, but at the same time, that needs to be paid for directly or indirectly. So I think it's a matter of reviewing, and it's a dynamic market that as conditions change around the world, as with the reinsurance sector, you do have peaks and troughs in availability, pricing, etc. So I think they're all really good questions for the Treasury review to consider.
Is insurance in that context even relevant, therefore, in the context of a compensation scheme of last resort? I can see it being, because there's no real line as to what's in and what's out. Why wouldn't insurances just exclude financial collapse from protection and put the onus on the levies in this system? I find it very difficult to see this legislation before us without really having a clear understanding of where the liability for payment of it falls.
Yeah, our belief is that professional indemnity insurance is a vital component of ensuring the long-term financial sustainability of the compensation scheme of last resort, because it essentially is a mechanism for reducing the cross-subsidisation effectively of costs across all the market participants in a particular subsector, as against those that are taking the risk. And that's something the professional indemnity underwriters are looking at on an annual basis when the contracts are renewed. And yes, there are complexities there, but it is a funding mechanism that at the moment is providing some degree of compensation to clients, for all those that actually are required or choose to utilise it.
And in that context, it's an important, whether or not product is insurable is an important assessment of the level of risk embedded in it. Should there not therefore be more transparency about the extent to which any particular product is or isn't insured, and the limitations on it, which consumers and even AFCA currently don't have oversight of?
We would certainly believe greater transparency would be desirable, but particularly starting from the regulator's point of view, from ASIC's point of view, following the model for the Tax Practitioners Board, having a more regular and detailed assessment of year-by-year coverage and appropriateness and adequacy, which is the core requirement under the licensing framework for all the licensees.
Thank you, Chair. I did have further questions, but I'm very aware I was interrupting your time.
No, that's okay, Senator Pratt. I'll make sure you get the call. Can I go on to this issue of wholesale investors, the definition of wholesale investors, and the concern of SMSF Association with respect to the definition of wholesale investors and how it impacts on your members?
Yeah, so the rules around wholesale investors, if you have, as an individual, net assets of more than $2.5 million or income of more than $250,000 over the last 2 financial years, you do fit into that definition of a wholesale investor, and therefore you're not subject to the same levels of protection that would apply to other types of investors.
And sorry to interrupt again, Mr. Moroney, but that net asset amount, that includes your principal place of residence?
I believe that's the case.
Yes, it does. Yes.
It does. Okay.
Yeah.
Please continue. Yeah.
So that was the main point I wanted to make. So in relation to self-managed super funds, where the SMSF, so you need to meet that test as an individual trustee of your fund, or where the fund itself has assets of $10 million, net assets of $10 million, that it will meet that definition. So those particular investors will not be covered by this compensation scheme, which is focused on retail investors that don't meet that definition.
So presumably the philosophy underpinning that is the greater your asset base as an individual, the less vulnerable you should be with respect to, and I'm not necessarily saying this is correct, I suspect it's far more complicated from a psychological point of view and many other points of view, But the argument is that the greater your asset base, the greater your wealth, the less vulnerable you should be to making to having investment decisions or interaction with a financial service provider having a devastating impact on your financial capacity and well-being, because you should be able to diversify, you should be able to get the advice you need because you've got the ability to get the advice, and therefore you should have greater capacity to make the decision impacting your financial well-being. So why isn't that a valid philosophy or a valid way of looking at this, bearing in mind that the compensation scheme is going to be a levy across the whole of industry or most subsectors, and we're looking to target it to the most vulnerable?
There's a couple of points there. One, the thresholds themselves are $2.5 million, which are quite low when you consider the growth in house prices across the country. We are on the record as saying that we believe those thresholds do need to be looked at to make sure they are relevant. And the other point I would make is that regardless of whether you are a wholesale investor or not, in our view, and again, this was part of our submission to the Parliamentary Joint Committee on the Trio collapse back in 2011, that you should be afforded compensation if you suffer losses as a result of the misconduct of others, regardless of whether you are wholesale or not.
But someone's got to pay for that, and the submissions that are coming through, for example, and I'll give you a specific example in that regard from the Stockbrokers and Financial Advisors Association. They strongly put the view that look, we realise that there are issues and people have been impacted, and I'll give you a quote from their submission. I'll put this to you just so you can get a feeling for what their perspective is, and this is from page 5 of their submission. They say, essentially, to use an insurance-based example, everyone is paying the same premium for fire insurance, even though some are living in a bushfire-prone area in a timber house and others are living in the middle of a built-up area in a concrete building with fire sprinklers, end quote, which I think is a somewhat useful way to draw out their perspective of, well, okay, maybe wholesale investors have been impacted by, and no doubt have been tragically, by collapses such as the Trio collapse. But in order for them to be compensated, someone's got to pay for it. And say the stockbrokers say, well, why should we be incurring a cost which we've got to pass on to our consumers to compensate another part of the sector that's done the wrong thing? So this comes back to how do we get the right balance here in terms of this scheme? Because I guess it's easy to look at one side of the ledger and expand the scheme to cover more and more products and services and expand it to cover more investors. But that has a consequence on the other side of the ledger in terms of the cost which is being imposed across those in the industry doing the right thing, and the cost of the consumers who bear the cost of those levies indirectly as they're passed through to them. How do we get the right balance in that regard?
You're absolutely correct. It is a balancing act between reducing the cost of compensation payable under the scheme versus making sure that consumers have access to adequate levels of compensation. I guess conceptually it gets back to whether we believe consumers have a right to be compensated or have appropriate options to seek compensation if they suffer misconduct by others. Now, in our view, they should have that right, but I absolutely agree with you. It's about finding that right balance between cost and making sure they have access.
Okay. Thank you for that. Senator Pratt, I might pass the call back to you if you had some additional questions. So I might give you the opportunity, if you like, to ask those additional questions.
Thank you, Chair. I wanted to ask, with respect to your position, sorry, I'm just opening I had a problem downloading my questions for you, but I do have them here.
Senator Pratt, could I perhaps just ask one or two questions while you find them?
Yes, that's fine. My apologies.
Senator McDonald from Far North Queensland. Thank you.
Thank you very much, Chair. Good morning. I just wanted to go back to Senator Scarr's questions about the cost of regulation and the transfer back to, he was making the example of stockbroking clients, but, can you just talk a bit more about how that would potentially apply in your world, particularly to the small superannuation funds?
So in terms of the levies themselves, the bill outlines a broad framework under which levies will be imposed on certain sectors and subsectors. The regulations, which have not yet been released, will prescribe the details in terms of the levies that will be payable by each subsector. Now, the SMSF sector is not one of those, is not classified as a subsector, if you like. So won't directly incur levies under the framework that's being proposed.
So I shouldn't be concerned about, regulatory creep or cost creep onto this sector as a result of this piece of legislation, at least.
Correct.
Terrific.
I've just added that, not in a direct sense, though in an indirect sense. If the cost of financial advice goes up because of increasing regulation and levies on financial advice businesses, a lot of self-managed super funds use those services, so there'll be an indirect increase in costs. And one of the reasons we're suggesting that managed investment schemes should be included in the scope is that at the moment we think quite often there's a greater focus on seeking compensation from the financial advice businesses involved rather than managed investment schemes, even though you've had a mixture of product failure and potentially advice misconduct. And we think broadening the scheme to include both of those would be a fairer way of ensuring that those that are responsible for misconduct and their sectors are sharing the costs, rather than the consultation document from Treasury indicated a very large proportion of the cost would be levied on financial advisors rather than other sectors. So we'd like to see more balancing across those subsectors.
Yes, it doesn't really address my concern, though, that this is, we end up with cost creep for regulation and so long as we've got a really tightly defined link between the additional cost and the greater benefit to consumers. I just look at the cost of regulation right across Australia, and we seem to keep absorbing more and more cost, and not always with a lot of perceptible benefit. So I'll just keep an eye on that. But thank you for that, clarifying that for me. Thanks, Chair. Thanks, Senator Pratt.
Senator Pratt, you have the call.
Thank you. In terms of the benefits to advisors and SMSF members in self-managed funds, in terms of the CSLR, what are those potential benefits? It's not like the compensation scheme will automatically pay out every last resort. There's got to be a determination of misleading conduct so that the level of risk was properly understood by a client, for example.
If we look at managed investment schemes, what we're proposing is that they would, the scheme would cover managed investment schemes as well. So entities that come under the jurisdiction of AFCA. Now, whilst managed investment scheme...
But that would require them to be responsible. I understand that and I support that. What I'm trying to work through then is the burden of paying that out. Then if such a collapse happens, does not just fall on the financial advisors, but also on the pool of managed investment schemes themselves? Are you able to unpack that part of it for me?
So by broadening the scheme, we're also broadening the funding of the scheme. So that's correct. Levies would be imposed on that subsector as well. So we're broadening the funding of the scheme in that way.
And what are the implications of not broadening it in terms of how you choose the impact on managed investment schemes that might be successful, or for self-managed super funds that have a broad portfolio inside them? How do they currently perceive the relative risk of managed investment schemes relative to other investments?
So managed investment schemes, if there is a failure of managed investment scheme due to theft or fraud, SMSF members are not entitled to compensation like other superannuation members may. So Part 23 of the SIS Act enables the Minister to make a grant of compensation to APRA fund members in the event of theft or fraud. That part of the legislation does not apply to self-managed super fund investors. So, and we saw that through the TRIO case, where there were SMSF investors who were not compensated, whilst members of APRA regulated funds were. So by broadening the scheme to include managed investment schemes, those investors would be covered. And we're talking here not just about advised investors, but also unadvised investors who would not be covered.
So who would be covered if it was amended as you're proposing?
Correct. Yeah. If it was amended as we are proposing, unadvised investors would be protected.
Okay. And in terms of things like fraud or misleading and deceptive conduct, how do we prevent that from happening? So as our regulators, in order for this to be sustainable, our regulators will need to be better at picking that up. Surely we can't insure everyone against fraud, otherwise it will happen all the time. I'm just trying to unpack that a little more.
Yeah, there are criminal penalties, as we know, that apply to fraud and theft. So I guess there is a question as to whether those penalties are severe enough. That's probably beyond the scope of us to make comment on that. But I would just make the comment that it is a criminal offence, obviously, for fraud, and there are apply.
And would you agree with Choice in relation to the civil penalties attached to that as well then? And that they are included in the scheme?
So perhaps pick that one. Senator, that was in relation to the financial accountability regime. We haven't addressed those issues in our submission because that is an issue that doesn't really have relevance there. So we haven't really got a position on those issues related to that separate bill.
Could you let the committee know if you've got any estimate on the scale or cost of the problem? I'm assuming from what you're saying, the TRIO collapse comes into the scope of the bill in hindsight. AFCA's got particular rules about timelines, about which claims are in and when you had to lodge them for them to be eligible under the scheme in an existing sense. If we bring managed investment schemes in, are they retrospectively therefore included now for future compensation?
It's our understanding that it's only cases, unpaid determinations since AFCA came into play. So the 1st of November 2018 would be covered.
Yeah.
Our TRIO dates.
So that's helpful, bar the fact that, of course, we bring in managed investment schemes post that. I had some things that I wanted to correct in that context in relation to the sterling collapse, because there's some peculiarities about how people have been knocked out of the scheme in terms of them not applying, having never applied, or having applied but got payouts that were limited because of the level of insurance cover, or were determined but found to be where there were determinations, but that they were appealed and knocked back out. But AFCA has since repaired those kinds of things. Do you know anything about things like the DH Flinders case? Or are they outside your scope in self-managed super funds?
I'm not familiar with that particular case.
Yeah, I've certainly read the information on the AFCA website that that's the one that sort of led to AFCA changing its rules to deal with corporate authorised representatives, and that led to, I think, most of the claimants for AFCA against one of the responsible entities involved there. So it's certainly some quite technical legal points that led to those decisions. I think it does show some of the issues about how the AFCA model works. You have to be a member of AFCA to be eligible for people to lodge a claim, and so anyone that, and I think that subsidiary Theta from memory sort of ceased its AFCA membership early last year, so unless you'd made a claim sort of by that stage. So it is quite complex as to how those things operate, and AFCA is regularly reviewing its rules to try to make sure the rules are as tight as possible, but that's always subject to court judgments. And then similarly in terms of when companies, managed investment schemes and otherwise run into financial difficulties, then what's happening around that process is very complex and challenging. Again, it's not related to our sector, so we haven't looked at it too closely.
It was pretty extraordinary that in that case, the auspicing company that employed these financial advisors claimed in court, well, was successful in court in saying that they had not authorised the sale of those products by their representatives, but nevertheless they were taking a cut, and that advisors were being, like, there was some $20,000 worth of fees, for example, for individual products that they were managing that were that they then deemed that they hadn't authorised the sale of. So I found that pretty extraordinary. Do you think it should be possible to fix that stuff in hindsight?
I think going forward, it's going to depend on how well the distribution and design and distribution obligations that are new requirements on all managed investments and the target market determinations. I think that'll give more focus for ASIC as the regulator there to assess whether or not providers are sort of meeting the terms of their target market and how the design and distribution are working, and that will then feed back into AFCA processes, I think, in terms of demonstrating potential misconduct in those areas.
What are the ramifications of not including managed investment schemes where they have a responsibility for liabilities under this fund, whereas your members will? What will the impact be in terms of the sustainability, I mean, the size of the levies that your members are paying?
For unadvised SMSF investors, if managed investment schemes are not included in the scheme, well, then they won't have access to a last resort compensation scheme like this. So that is a concern for SMSF investors that are unadvised. Those that are advised, it could be that the advice sector is called on to pay what we would claim, we believe, is a disproportionate share of the cost of compensation. Given that we think the spotlight, as I said in my opening remarks, will be on advisors in terms of the allocation of fault. the best interest duty and the advice laws are very complex, as we know. And, you know, if you look hard enough at advice, I'm sure there's always things that you could find the advisor could have done better. And there's those gotcha moments and so forth. So we are concerned that without broadening the funding base to include other sectors like managed investment schemes, that the financial advice sector may incur a disproportionate share of the compensation cost at a time when there's a real focus, of course, on the costs that financial advisors are incurring and levies and so forth.
And how will the exclusion of managed investment schemes investors affect the desirability of financial advisors recommending a managed investment scheme in the suite of products, knowing that, one, the liability will more likely rest with them, but also I'm really a little bit unclear in terms of what consumers will think about investing in something directly or investing in it through an advisor, precisely because it is or isn't covered, particularly when we're also hearing that you won't be able to advertise, you shouldn't be able to advertise that you're actually covered. And how will consumers be able to really pick through the what is a good investment or not if they're really unaware of the extent to which it's insured or not insured based on the type of advice that they do or don't get?
I think if they are included, we're less likely, of course, to see situations like Trio, where clients who suffered substantial losses and who had no avenue for compensation. Including managed investment schemes, in our view, should improve confidence in the overall financial sector, and we think that's an important objective of the last resort compensation scheme itself.
Thank you, Chair.
Thank you, Senator Pratt. Just as a final question, if I could, I just want to tease out this issue of wholesale investors. And you gave us the reference to the net asset test, etc., whereby someone becomes a wholesale investor. But is it, in terms of how this works in practice, if I don't elect to get my accountant to sign off that I've got net assets of X and therefore I meet the wholesale investor test or sophisticated investor test, I will be treated like a retail investor. Isn't that the case?
That's correct.
So to some extent, I've elected, and I don't know if this has any bearing on your logic or the argument, but I just want to put the proposition to you. I've elected to become a wholesale investor. I've gone through a process to become a wholesale investor because that provides me access to a greater range of investments than if I was a retail investor, because the requirements with respect to disclosure, etc., with respect to providers of products are less onerous when they're selling the products to a wholesale investor as opposed to a retail investor. So I've made a positive election to be treated as a wholesale investor. Why isn't it then reasonable that I also take the consequence of having made that election in terms of my access to a compensation scheme of last resort?
It's a good question. It gets back to conceptually whether we believe that consumers do have a right to be compensated as a result of misconduct, and whether you should, for those that have voluntarily opted out, whether they voluntarily opt out of that right. Now, that's in my view. I think all consumers should have access to appropriate levels of compensation or options to seek compensation.
Yep. Okay. No, thanks very much. That was useful just in terms of teasing out the issue from my perspective. I do appreciate that. So thank you for appearing as witnesses today. We do appreciate it, and thank you for being available to come on a few minutes early. That was good. It gave us an opportunity to ask a few additional questions. I would ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on Parliament's website. The committee will now break for 15 minutes and will resume at 10:05 a.m. Thank you very much.
Thank you very much, Chairman, and thank you to the committee.
I would like to get my blurb. The hearing will now resume. I'd like to welcome representatives of CPA Australia, the Financial Planning Association of Australia, and the Association of Financial Advisors. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to the witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. I invite the representatives of each organisation here to make a brief opening statement, should they wish to do so. And for the Hansard record, I ask each of you to please state your name and the capacity in which you appear. So perhaps CPA first.
Thank you. Ketty Waller, Head of Public Practice and SME at CPA Australia.
Okay. Do you have an opening statement, Ms. Waller?
We're doing a joint opening statement that Mr. Vermeer will be reading out today.
Oh, okay. So Mr. Anderson, I might ask you just to introduce yourself before we go to Mr. Vermeer. Are you just on mute, Mr. Anderson? It's a mistake I've made many times.
Thank you, Mr. Chair. My name is Phil Anderson. I'm the Chief Executive Officer of the Association of Financial Advisors.
Okay, thank you. And over to you, Mr. Vermeer.
G'day, my name's Brad Vermeer. I'm the Senior Manager of Government Relations and Policy at the FPA. Mr. Ben Martian, who won't be joining us today, I'll be representing the FPA. Good morning, Mr. Chairman and Senators. Thank you for the opportunity to appear before you this morning. We do not have any specific comments in regard to the financial accountability regime legislation, and rather will limit our comments to the proposed establishment of a compensation scheme of last resort, or CSLR. We appear here on behalf of the Association of Financial Advisors, CPA Australia, and the Financial Planning Association of Australia. Between the three associations, we represent over 14,000 financial advice professionals. The AFA, CPA Australia and FPA are broadly supportive of recommendation 7.1 of the Royal Commission into Misconduct in the Banking, Superannuation and Financial Services Industry, otherwise known as the Hayne Royal Commission, to establish a CSLR. And we particularly support the government's commitment for a broader scheme beyond just financial advice. However, we believe that the legislation introduced to establish such a scheme is too narrow in scope, provides inadequate coverage to consumers, and does not seek to address some of the underlying causes of unpaid determinations, such as strict enforcement and appropriate professional indemnity insurance. The Australian Financial Complaints Authority is a one-stop shop for most complaints concerning insurance, banking, credit provision, superannuation, and financial advice, and provides an alternative to going to court. Importantly, AFCA is empowered by the law to make binding determinations requiring financial firms to compensate consumers. However, the proposed scheme will not apply to all unpaid determinations by financial firms who are a member of AFCA. Rather, it will only apply to personal advice on relevant financial products to retail clients, credit intermediation, securities dealing, credit provision, and insurance product distribution. This means that important segments of the financial services industry, predominantly financial product providers who are members of AFCA, will be excluded under the proposed scheme. We are not suggesting that a CSLR should protect consumers of investment products from poor investment performance. Such a scheme should only come into effect where there has been misconduct, such as misleading and deceptive conduct, misrepresentation or fraud, and consumers have suffered detriment as a result. We acknowledge that there are some concerns around the risks of some products which also need to be addressed. However, we cannot provide support for a scheme which will see consumers of these products unprotected. We are also concerned about a model that is disproportionately funded by financial advisors, the majority of who are themselves small business owners. We question the equity and sustainability of the proposed model. Unfortunately, the Treasury has not been forthcoming with recent data in terms of the number of sectors driving unpaid determinations for at least the past 2 years. The July 2021 proposal paper on the CSLR indicated that financial advisors would pay more than 3/4 of the cost of the scheme, including the establishment costs, capital reserve establishment, and annual administration costs. For this reason, ensuring that the scheme is efficient and effective is very important to us. The July 2021 proposal paper also suggested that the annual administration costs of the scheme would amount to $3.7 million. Whilst it has not been stated, we have deduced from previous statements that there might be only 20 to 25 unpaid determinations every year. This suggests that the cost per unpaid determination could be in the vicinity of $150,000. Based upon a projection of $4.36 million in unpaid determinations each year, administrations of $3.7 million would make up 46% of the total annual cost. This appears excessive, and there must be a better way to design this scheme. We also object to financial advice paying a disproportionate share of the establishment and capital reserve costs, which serve the benefit of all sectors and not just those who have previously been the highest contributors to unpaid determinations. We also support the subsectors responsible for unpaid determinations being charged for these costs directly. While we acknowledge that a CSLR is less likely to be used in the case of prudentially regulated entities, we believe that it is a shared responsibility to lift the confidence and trust in the broader financial services industry, and therefore believe all participants stand to gain by the increased level of consumer confidence in the scheme of the operation of, in the context of the operation of a broad scheme. Effective professional indemnity insurance is also a key pillar to ensuring a sustainable CSLR. We are concerned that currently there is an ineffective oversight and monitoring of this mandatory obligation, and support the government's review into the PII market as part of the implementation of this bill. However, we believe it would be prudent for this review to be completed before the scheme comes into operation. Importantly, each of the bodies represented here today has joined a diverse coalition of 15 professional industry and consumer advocacy bodies who will continue to call for the expansion of the proposed CSLR to include all financial service organisations who are members of AFCA and hence all relevant financial products. In closing, we strongly encourage the government and the Senate to amend the legislation to ensure that the scheme supports and increases consumer confidence in financial services, appropriately protects consumers from misconduct and fraud, and ensures equity by sensibly applying the scheme to all financial services organisations who are members of AFCA and have a responsibility to identify and report misconduct. Once again, thank you, Senators, for the opportunity to appear before the committee, and we look forward to answering any questions you may have. Thank you, Mr. Chairman.
Thank you, Mr. Vermeer. I might kick off if I could. Is it correct to say, Mr. Vermeer, that the Haynes report, Justice Haynes, or is on a Haynes, basically recommended the introduction of a CSLR in accordance with the Ramsay review model that was recommended by the Ramsay panel?
Yes, Mr. Chairman, I would say so. However, we have noted that the government had made a commitment to a scheme that was broadened out to all the financial services in the jurisdiction of AFCA, and the reason why we've landed on this point is because we want to ensure that consumers are adequately protected and that the funding requirements for such a scheme, its establishment, its operation, are shared by all of the financial services industry. And by making sure that the entire financial services industry and those within the jurisdiction of AFCA are included in such a scheme, it provides a level of confidence for investors in the industry and provides a level of protection that we believe is necessary for consumers.
All right. So I appreciate the argument, and it's an argument that's well made in the various submissions made by each of the entities who have representatives during this segment. But it is true to say that Haynes only went so far as to say that the compensation scheme of last resort recommended by the Ramsay panel should be introduced. Is that correct?
Yes, Mr. Chairman. Yeah.
Okay. So then if we go to the
Mr. Chair,
Ramsay panel... Oh, sorry, Mr. Anderson, yes?
Yeah, Mr. Chair, I absolutely agree with you that what Commissioner Haynes said was to support the Ramsay recommendations, excuse me, but the Ramsay recommendations were a review that took place in 2016 with a report in 2017. So our question is whether the drivers of unpaid determinations have changed materially since that point, and whether the recommendation of the Ramsay inquiry remains as appropriate as it was at that time.
Okay, so that's a very good point, Mr. Anderson. And I just want to quote to you a section from the Ramsay panel report, and I'll get your views on this based on what you've seen occur since the introduction of the Ramsay panel recommendations or the release of it. And it's paragraph 4.53 and 4.54, and I'll just quote this. The long-term sustainability of a CSLR is an important factor which must be taken into account when determining which types of claims should be eligible for compensation. The panel's recommendation for the establishment of a CSLR and its recommendations on design elements are made without the benefit of comprehensive modelling and costing. In this context, moving immediately to a CSLR where all types of claims would be eligible for compensation could expose a CSLR to a significant financial liability, which has the potential to undermine the sustainability of a CSLR, particularly where a large number of claims were made on it during its early stages, end quote. So there was a concern that was expressed in the Ramsay panel recommendations with respect to the establishment of a CSLR which was too wide in the context that it might not be sustainable in the long term. And I must say, I'll be open with you, that's a concern I have, especially when we talk about black swan events and large managed investment schemes which fail from time to time and the impulse that would have on a scheme. Could I seek each of you to give your thoughts with respect to that quote from the Ramsay panel report and those concerns with respect to the sustainability of a scheme? Mr. Anderson?
Yeah, thanks, Mr. Chair. I agree that it's an important consideration in the design of the scheme, and the legislation that we have in front of us has put mechanisms in place. There's a cap of 250 million, and there's a mechanism for the contributors to be broadened in the event of a black swan event. Nonetheless, you're absolutely right. Sustainability of the scheme is really important.
Okay. Ms. Waller, can you give me your thoughts in relation to that, those cautionary words, if you like, with respect to the need for us as legislators to consider the sustainability of a CSLR?
So I think there was a couple of key points made in that recommendation that still hold true and that Mr. Anderson referred to before, in that we don't have the insight and the data and access to that information to help understand the drivers behind the current claims and what we could look to in terms of future events. So I think that is a key thing we need to explore and consider. I think another thing to consider is also, in addition to that cap on funding, there is also a cap on the claims that can be paid. So there is a limit on the compensation that would be eligible to consumers for unpaid terminations. And I think the other thing that we need to consider is we're talking about, importantly, the sustainability of the scheme, but we also need to look at the sustainability of the sectors that are funding this scheme. As Mr. Vermeer said in the opening comments, the large proportion of those left in the financial services advice sector are small business owners, and they have faced considerable changes and regulatory costs over the last couple of years, and we're looking at further costs with this scheme being introduced. We need to consider the sustainability of that sector in an environment where we're seeing considerable drop in the numbers. We're now less than 18,000 advisors in financial planning, and we had less than 100 new entrants to the sector. So if we want to look at the sustainability of that scheme, we also need to look at those who are going to be funding it as well. Mr. Vermeer?
So Ms. Waller, can I put it to you that if, and you've made the point about not having access to all the relevant data and material to consider potentially to consider how wide the scheme should be, how it should operate in practice in terms of levies. In that situation where a key stakeholder such as yourself or the organisation you represent has concerns about that, doesn't that put us on even more notice as legislators that as a first step, we need to be prudent with respect to the scope of the scheme and see how it works over the first few years and its sustainability, but before starting off with the broadly based scheme that has a wider ambit and a wider scope?
I would actually say that what we would need to, what we would be looking for is more transparency around those metrics. So some of that data exists, but we actually have not had access to that information. And so, you know, we've made some determinations based on things that we've seen in the past in those consultation papers. So if we had insight into that and agree that is a key consideration that we should all be considering, including yourself as legislators, that should be something we should be reviewing in more detail, especially around the operation and the efficiency of the scheme. I think the other thing to consider is as well the community expectations. We've seen a lot come through in previous inquiries and challenges, and I completely take the point around the risk in some of these sectors and managed investment schemes. But the recommendations we've made in our submission is to align it to AFCA membership. And so you'd be looking at the responsible entities of those managed investment schemes who hold an AFS licence. It wouldn't be extending to all of those individual products directly. It would be the responsible entities of those product providers who then have a responsibility as part of this in marketing their product.
Okay. Mr. Vermeer, could you give me your thoughts with respect to those sections of the Ramsay panel recommendations that I quoted?
Absolutely. I agree entirely with the submissions made by my colleagues, and would say that there hasn't been the modelling done to, you know, the recommendations of the Ramsay Review are in the context of a report from 2017, and we don't have up-to-date figures to indicate to us how it would play out in the present day. I mean, however, you look at some of the figures that are available on the 18th of November, the lead ombudsman for investment advice out of AFCA had stated that only 1.8% of all complaints made to AFCA relate to the advice sector. And of those complaints, 63% of them are found in favour of the advice firm. Now, I know that doesn't indicate necessarily the amount of unpaid determinations that exist. However, the number of complaints that are in relation to the advice sector are substantially lower than what we would have seen under the circumstances contemplated by the Ramsay Review.
Okay. Mr. Vermeer, you made mention of government statements of policy with respect to the scope of the CSLR. So from my perspective, I've had a look at the Ramsay panel recommendations. I've looked at the section of the Hayne report with respect to the compensation scheme of last resort, and both of those were calibrated to a particular scope of the CSLR, being somewhat narrow and more narrow than the financial services which are actually covered by this bill. So there was an expansion of the scope of the CSLR, which is reflected in this bill. Where was this articulation made with respect to the scope of the CSLR that created an expectation in your mind that it was going to cover areas such as the managed investment scheme?
Sorry, thank you, Mr. Chairman. Certainly in the past, I'm happy to find specifics and provide any references on notice, but certainly in the past in our conversations and I guess in the more broader conversations about compensation scheme of last resort, it's certainly been indicated that a wider scheme to ensure that consumers receive adequate protections certainly was the intent of what the introduction of a CSLR would be. I don't know if any of my colleagues wanted to provide some.
So yeah, I'm happy to jump in.
Mr. Anderson?
Yeah.
Where's this commitment from the government?
So the initial commitment from the government to a broader scheme was the statement from the Treasurer in response to the release of the Royal Commission final report back in February of 2019. Now, in that commitment, there was not descriptive terms on the exact extent of the broader scheme, but there was a commitment to a broader scheme.
And this is okay, but just to get this right for the record, this is on my reading, and I've brought a fresh pair of eyes to this and done a lot of reading, and thank you everyone for your submissions. This is a broader scheme than what was suggested by the Ramsay panel, insofar as it does consider other areas of financial advice that were not recommended through the Ramsay panel or reflected in the Hayne report. For example, advice given by brokers to retail customers. So it is a broader scheme than what was originally envisaged. It might not be broad enough for your liking, and you've given your justification for that, but it is fair to say it is a broader scheme than the one which was originally recommended by Ramsay. Isn't that true?
I might just add to say, yes, we acknowledge that it's certainly broader than the initial recommendation. We would also add that as part of the consultation that we've had, as part of the process that we have had conversations with Treasury about this being potentially a broader scheme, and there was a wide range of participants who were engaged in that consultation, so there were discussions around that. And I think the other thing, just to make an observation, we're talking about the changes that we've seen since the Ramsay review in 2017. I think one thing we really need to think about is the different structure of the sector compared to what it was in 2017. 2017, we saw the large banks and institutions really being the largest advice providers. We know that they have all but exited that sector, and we are left in a very different position at the moment. So we do need to think about those future drivers and how this is going to be funded, and also those unpaid determinations.
Okay, fair enough. Well, I understand those arguments, but I'm coming back to this point about what commitments the government made from a policy perspective. As far as I can ascertain from the answers to the questions you've given me, there was a commitment from the government to make it broader, cover more areas of financial services, and the bill is actually broader than what was originally recommended by the Ramsay report. So to that extent, there's a consistency. However, it doesn't go as far as you would like to see as stakeholders from your perspective for the reasons which you're given. Is that a fair summary, Mr. Vermeer?
It is, Mr. Chairman, just noting obviously the points that were made by Mr. Waller and Mr. Anderson in the context that Ramsay and the recommendations of the Ramsay review were made some years ago, and the structure of the industry and circumstances have changed substantially since that point. Hence okay. our differing views on what we would consider a broader base scheme.
Oh, I understand that. I just wanted to get that clear for the record. Senator Pratt or Senator Chisholm, do you have some questions?
I do, Chair. I'm happy to go.
Okay, Senator Chisholm.
Thanks, Chair. These are reasonably broad, so feel free for whoever to jump in, and they probably follow on from the Chair's questionings as well. I've asked most participants today just about the exclusion of managed investment schemes from the CSLR. I was just wondering if anyone wanted to talk about what problems that caused for the advice industry.
I'm happy to jump in, Senator. I think the data that we've seen suggests that managed investment schemes are probably the second largest contributor to unpaid determinations from external dispute resolution schemes. The data we have probably predates AFCA because it comes from a statement from FOS before the establishment of AFCA. But obviously, managed investment schemes are a significant sector of the investment market. Why it's important to advisors is that where advisors have recommended an MIS that subsequently fails, that means that often the advisor is the only party left, and the advisor can end up being subject of a complaint and potentially a determination that could amount to a significant proportion of the money that the client lost. So this is an important issue for us to make sure that where there is responsibility that rests in the conduct of the managed investment scheme, that there's a mechanism for that to be compensated and that advisors are not paying compensation for the misconduct of MISs.
Okay. Did anyone else wish to add any comments about managed investment schemes being excluded?
I'll just make an additional observation that I think we need to consider as well the community expectation and the expectation around there being redress. So we know that a lot of consumers will invest directly in MIS. They may not actually seek professional advice, and we need to consider the scope and the coverage to ensure protection for those individuals.
I'd just like to reinforce the point that Mr. Vermeer made in the opening statement, in that we have never suggested that a CSLR should step in to cover consumer loss on investment performance. Investment performance is not the subject of a determination. It can only be where there's misconduct by the MIS. And we need to be obviously very aware that when consumers are making investment decisions, they need to do that fully informed and prepared to accept that sometimes investments do not perform as they had hoped. So this scheme is not to cover investment losses.
Just moving on to another issue, which is around the proposed CSLR levy, which will increase the costs on financial advisors, which a lot of you represent. I just wanted to get a sense first how much ASIC advisor levies have already increased over the past 3 years.
Well, I'm happy to respond to that, Senator. Until the government stepped in to provide relief, which we're very appreciative of for the 2021 financial year, in advance of that, we took it back to the level of 2 years ago, had been something like a threefold increase in the ASIC funding levy. So, yeah, fortunately for the 2021 year and the 21-22 year, the ASIC funding levy is being pegged at the 2018-19 level of 1,142. But yes, it's been an issue that's one that's really worried us, because it's one of many factors that are driving up the cost of providing financial advice. And that's something that we're very concerned about, because it flows on to what consumers pay for financial advice.
Absolutely. Can I just echo Mr. Anderson's comments there, and also recognise and thank the government for the 2-year industry levy freeze, which has been very welcomed by financial planners. However, there obviously is a concern with relation to what the levy will look like. It is difficult to see given the information that's available. I mean, and I think in the opening statement, and I think Mr. Anderson's expanded on this, that the cost of the administration of the scheme and how much that's actually going to contribute to the levy itself. I don't think anyone necessarily is opposed to providing funding for the redress of unpaid determinations, but I think there's a substantial concern on the substantial cost of the administration of the scheme, which is coming close on some of the figures we've seen to 50% of the actual funding required. So that's just another point that I'd like to make.
Thanks for that. Just a follow-up related question. Is it reasonable to exclude managed investment schemes from these levies?
Sorry, in terms of the question, is it reasonable to exclude them? Obviously, managed investment schemes are covered under the ASIC funding levy. So no, it's not reasonable to exclude them from the ASIC funding levy. More broadly, with the compensation scheme of last resort, our argument is that some of the establishment costs and the annual administration costs should be covered more broadly across the sector, as all stakeholders in the financial services and banking sector benefit from increased consumer trust and confidence that comes from having this scheme.
And I also think it comes down to what is the reasonable expectation of the community and the consumers as far as the breadth of a compensation scheme of last resort, and who would have access to compensation in the case of found misconduct. And I guess from that perspective, we found that we believe that managed investment schemes should be included, and I think to ensure that consumers are adequately protected.
Just to add to Mr. Vermeer's point, I just think it's important that the arguments we're talking about is aligning the unpaid determinations and the scope of AFCA membership, so that there is consistency, and to that point around committing the expectations that if someone is a member of AFCA, that there is a CSLR in place should something happen and they not be awarded their unpaid determination.
Okay. Just a final one from me, Chair. I just wanted to get a sense from those participating what they think the role of ASIC is in preventing misconduct in the industry.
I'm happy to start that if that's okay, and I'm sure my colleagues will have additional comments. I think one of the things we've seen through current inquiries and cases is that there is potentially a misalignment in place, and that's partly because of the legislative framework that's in operation and also understanding the role of ASIC in this sector. So if you look at the current requirements, ASIC are mandated to, for example, to register a scheme if they meet certain requirements and essentially grant them the right to go to market. I think we need to understand and look into this and say, is the role of ASIC to be an administrator around MIS, or is it to be a regulator? And I think that's partly about the legislative settings that we're seeing, also the ASIC intent, and also then thinking about what that community expectation is. And at the moment, I'm not sure that that's actually clear.
I would add to those comments by saying that ASIC is a very important stakeholder in the financial services industry, but we can't necessarily expect that they are going to be able to stop things from going wrong, or they can't. It's more a question of how rapidly they respond to material matters. But things are going to go wrong and clients are going to lose money. It's a question of how well we all respond when that then happens.
I'd just say that I agree with that. I don't have anything further to add than from what Ms. Waller and Mr. Anderson have already said on the subject. They've covered it comprehensively.
Thanks very much. Thanks, Chair.
Thank you, Senator Chisholm. Mr. Anderson, I want to come back to the point you made, which I think is an important one, that from a philosophical point of view, the purpose of the compensation scheme of last resort is not to compensate consumers, retail investors, with respect to an investment which hasn't performed as they would have liked, as opposed to compensating for misleading and deceptive conduct, fraud, dishonesty. That's which should fall within the ambit of the compensation scheme of last resort. Is that the distinction you were making? Do I give justice to the distinction you were making in that regard?
Yes, Mr. Chair, I absolutely agree that investment performance is not something that should be covered by this scheme. And clients need to make decisions as to what they invest in, and there's always the risk of poor market performance, but then there's also a risk of poor relative performance in that their investments underperform the broader market. That's not something that should be covered by this scheme. This scheme should be in place to cover people for misconduct.
And typically, and I don't want to go into the portfolio theory of investment, you would know far more about this than me, but typically where returns are greater, the risk is also greater, isn't it? That's a fair comment?
That's correct.
Right. So one of the issues I'm grappling with is when you get to that point in time when someone is seeking compensation, they're looking at it and their advisors, their lawyers, potentially AFCA, are looking at it in retrospect. So an investment has failed, it may have disastrously failed, and the investment has been lost. And the situation, the circumstances are being looked at in retrospect. So almost the chronology is that the catastrophic losses incurred, and then the lawyers, the retail investor, other stakeholders, understandably, are searching for the misleading or deceptive conduct or the negligence on the part of the financial advisor in retrospect after the loss is incurred. How do we deal with that dynamic that the investment has been made, promises made with respect to certain level of returns, but when the loss is crystallised, everyone's looking to say, well, it was the financial advisor's fault. They didn't give us proper advice, or the PDS wasn't adequate. And invariably, when you're looking at things in retrospect, you can always find something that could have been done better. The advice could have been clearer. The relevant risk could have been accentuated more. And if it had been, I wouldn't have invested. And I'm saying that in retrospect. How do we deal with that phenomenon?
Well, that is a genuine issue that comes into play with many claims that are made to AFCA. And it's not just where we've got unpaid determinations, it's also other losses that may be sustained. That client may argue that their advisor put them in an investment that was above, the risk factor was above and beyond what their risk profile would have indicated. And the job then comes down to the advisor to demonstrate through their records that the advice they provided was appropriate and that the risk of the investments was in alignment with the client's risk profile. So those are existing issues that play out in the AFCA process. The CSLR is just taking it one step further should there be an unpaid determination that eventuates.
So thank you for that. So one of the issues that struck me in the Sterling First situation, and I was sitting on the references committee, and we've done an in-depth look at the Sterling First debacle, tragedy in many respects in terms of retirees who've been just devastated by that situation. And one of the thoughts that occurred to me is it would have been good if more of those investors had have sought financial advice from an independent provider of financial advisory services to actually give them a warts and all advice with respect to the risks associated with that scheme. So isn't it fair that there actually be a distinction between someone who's been in a situation where they've suffered loss, but they've gone to the trouble of getting financial advice and they've incurred the cost of getting financial advice? Because from my perspective as a legislator, I think we should give as much incentive to people to get that financial advice as opposed to someone who's made an investment without getting the benefit of that financial advice from someone who's independent.
Well, we can obviously support what you're saying about the importance of getting financial advice. And from what I've heard of the Sterling scheme, unfortunately, some of the impacted clients did not have an adequately diversified investment portfolio, and they put an excessive proportion of their funds into the one scheme. That is something that you would not expect as an outcome if someone had got advice.
Exactly.
So yes, advice is really important for not just ensuring that people are targeting the right returns, but they are taking the right measures when it comes to risk.
And in fact, one of the recommendations or suggestions that Mr. Tony Delosio provided in the course of giving evidence to an inquiry was that you're never going to be able to make a managed investment scheme readily comprehensible to a retail investor. And because the schemes are so complicated, one policy response might be to actually mandate that independent financial advice has to be provided by the promoters of the scheme, and the cost of that advice is distributed across all participants in the scheme, because you simply can't expect a retail investor, and I say this as someone who looked at the Sterling First PDS, and I found it difficult as an ex-general counsel, company secretary of an ASX company, to understand it myself. you can't expect a retail investor to understand it. They should get advice. Retail investors should get the benefit of advice before investing in such a scheme. What's your view with respect to that suggestion, Mr. Anderson?
Thanks, Mr. Chair. And that's a big call to mandate getting access to financial advice. And obviously, coming from a financial advice association, we would strongly support people getting access to advice, particularly if they're investing in something that is higher risk. The dynamics, the design that you describe in terms of the cost of that advice being shared across other investors is a pretty significant consideration. And obviously, we would argue that clients of financial advisors shouldn't, if they're already paying for that advice, they shouldn't be paying for advice for other investors in the same scheme. But mechanisms need to be looked at to help encourage Australians to understand the risks that they're taking and to consider other forms of protection.
Because from my perspective, Mr. Anderson, we talk about black swan events and failed managed investment schemes, failed investment schemes even before the term managed investment scheme came into being have always occurred. And I think it's a reasonable expectation they always will occur. And there is this, I come back to my initial question, this issue around the sustainability of a compensation scheme of last resort. If you're going to have these repeated black swan events that have to be compensated for or should be compensated for across the whole economy, leading to increased levies on your members, increased charges and costs for consumers. That's the dilemma I see in terms of this policy issue, I guess, from my perspective. Do you have any response to that, Mr. Anderson? I might give you, Ms. Waller and Mr. Vermeer an opportunity just to respond to that point as we close off this session. Mr. Anderson?
Yes, Mr. Chair. Our argument has always been that the impacted subsector that it's responsible for the unpaid determination should pay for those unpaid determinations. And in the ideal model, they're not paying for unpaid determinations from other sectors. In a black swan event, there are powers presumably, within this legislation that might allow the minister to apply a broader funding mechanism. But our original thinking and starting point is that you, as a sector, should only be paying for the unpaid determinations from your sector.
Okay. Ms. Waller?
I'd just like to say I do agree with Mr. Anderson's comments, and I think just a few other things we need to think about are some of the complexities around the products you've been describing. They're really important points, especially if we look at Sterling. There was a misconception that some people were actually investing more around their retirement living as opposed to into a product, and I think that's some of the things we need to think about language and how products marketed to people, especially when they're directly marketed to individuals in that case. I think another thing we need to think about is financial literacy and the important point of trying to upskill more broadly the community to understand what information they're receiving, what they should be looking for, and that will also help encourage seeking professional advice. And I think as a sector, there's a lot of things that we could be doing to actually work together and really improve those sort of mechanisms that together will actually address some of these risks that we're looking at. Thank you.
Okay, thank you, Ms. Waller. And Mr. Vermeer, you have the final word in this segment.
Thank you, Senator. I agree entirely with what Mr. Anderson and Ms. Waller have said, and I think the Treasury discussion paper from, I think it was December 2019, into implementing recommendation 7.1 of the Royal Commission did envisage some of these a broader based CSLR and some of these black swan events, and it has been difficult, I guess, for us to further anticipate some of these things without some of the data that we've been asking for and looking for. But I guess, particularly when it comes to referring to the Sterling inquiry, I remember during some of the evidence that was provided in that, one of the people that appeared at the hearings had actually, it was such a complex scheme, someone had actually sought out legal advice and been told, "Oh, it's all fine," and invested based on that advice. I guess it's not just. I guess it's people accessing the correct advice, not necessarily just seeking advice in one form or another. Obviously, we're very supportive of people accessing financial advice and financial advice being affordable, but ensuring that consumers are adequately protected, particularly when it comes to some of these schemes like Sterling, where it is incredibly complex, I think is important, and it would provide a certain level of confidence in the sector if these kinds of protections are extended across these products.
No, well, that's a very good point. Well made, Mr. Vermeer. I appreciate that. It actually disturbed me quite a bit that some of the victims said they had gotten legal advice, and it was quite concerning. So thank you for making that point. Much appreciated. So thank you all for appearing as witnesses today. It's greatly appreciated. I would ask that you now disconnect from the video conference, and you can continue to observe the hearing should you wish to do so through the live stream on Parliament's website. Thank you very much.
Thank you.
I'd like to now welcome representatives of the Stockbrokers and Financial Advisors Association. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear? Ms. Fox.
Chair, my name's Judith Fox, the CEO of Stockbrokers and Financial Advisors Association, and to the Chair and members of this committee, thank you for inviting us to appear today. Through our principal and practitioner members, we represent close to 8,000 stockbrokers and investment advisors, and they provide stockbroking and investment advice, execution services and equity capital raising for domestic retail investors, domestic and international wholesale investors and companies. SAFA supports a genuine compensation scheme of last resort to address unpaid determinations awarded by AFCA to protect the interests of consumers whose claims against a financial advice firm are not met due to either misconduct or insolvency of the relevant financial firm. However, we do have serious concerns with the design of the scheme, which we raised with Treasury during its consultation on the proposal paper in August 2021. Our particular concern at the time was that under the proposed design, those who had zero unpaid determinations were paying for the scheme, while those most likely to have unpaid determinations were exempted from contributing to the scheme due to the application of the $1,000 minimum levy threshold. And we pointed out at the time that this outcome would result in moral hazard. Unfortunately, the details of who will be levied and for what amounts will be contained in regulations which have not yet been made available. Now, we understand that the process of determining the amounts of levy payable by each subsector will involve mathematical formulas and technical detail that is best included in regulations. But not having those regulations available makes it very difficult to provide feedback because we don't really fully understand the impact of the scheme on our members. We have assumed that the levy arrangements as detailed in the proposal paper are the ones that will apply, and our feedback therefore is based on that. However, we strongly recommend that the bill not be passed until we've been able to provide feedback on the regulations, because the, quote, devil is very much in the detail, which we often say, but in this case, it's absolutely the true. Our key concern is that the design of the scheme is neither actuarially sound nor risk-based. The bill, now Choice said earlier that higher risk sectors will pay, but at this point in time, given that we cannot see how the levies are going to be determined until we see the regulations, that simply is not the case. Certainly it wasn't the case in the proposal paper. So we can't know if a risk-based approach is contemplated until we see those regulations. We've explained the factors in our submission that significantly reduce the risk of unpaid claims being made against market participants. We consider that the lower risk profile of market participants should be factored into the design of the scheme. The scheme currently takes no account of the capital adequacy requirements under the market integrity rules that apply to market participants, that results in the potential for market participants to be unable to pay an award to a client by reason of liquidation. It's extremely unlikely. And AFCA has confirmed to us that no SAFA members have any unpaid determinations. We're also concerned that the rationale behind the design of the scheme is based on the Ramsey review data from 2016-17 and takes no account of recent data, which shows extremely low levels of AFCA complaints against financial advisors in general and stockbrokers in particular. We think that basing the design of the scheme on out-of-date data undermines confidence in the scheme. We're concerned, obviously, about the ability of the Minister to levy additional funds up to $250 million from other subsectors, including those that are not in scope of the scheme. We don't support cross-subsidisation of other subsectors. And finally, we would like to see consultation on the effectiveness of professional indemnity insurance before the scheme is passed, given its importance in clarifying the source of unpaid determinations and reduction of risk to consumers. And we're very happy to take questions, of course.
Okay, thank you, Ms Fox. And you have a colleague with you, I think.
Thank you, Chair. My name's Michelle Huckle and I'm the Policy Manager at SAFA.
Okay, welcome. Thank you for joining us today. Greatly appreciated. Ms Fox, I might kick off. Could you just provide, from the perspective of your association, the number of complaints that actually arise in terms of stockbrokers providing advice to retail investors or executing requests from retail investors to trade in shares and other securities? What's the level of the issue in terms of the members you advise in this or represent in this regard?
Thank you, Chair. Data from the AFCA 2020-21 annual review for the period of 1 July 2020 to the 30th of June 2021 shows that of the 70,510 complaints received during that period, only 6% related to investments and advice. And of that amount, only 490 complaints were made against stockbrokers, which is 0.69% of AFCA's total complaints.
And so that's the number of complaints. What about the quantum of the complaints? So in terms of the amounts claimed. So one way of looking at it is in terms of the number of complaints. The other way of looking at it seems to me is to look at the quantum, which is the subject of each complaint, and work out how much of the proportion of the quantum claimed your industry represents. Have you got any data in that regard?
Chair, I don't. I'm happy to take that one on notice and we can go back to AFCA. I would like to make the point that until the recent Treasury review into AFCA was also exercising its discretion to take complaints from wholesale investors. And obviously, therefore, sometimes those sums were considerable. And so I think they weren't just complaints from retail investors that were being sort of put into the mix, but we're happy to come back to you.
Okay, if you could. And just in relation to that issue of wholesale investors and whether or not a compensation scheme of last resort should be extended to wholesale investors, and some witnesses gave their views on that issue earlier today, what's the view of the Stockbrokers and Financial Advisors Association?
Our view is that investors elect to become a wholesale investor. It's not an automatic process. No one can just put them into that category without their consent. They have to go and get a certificate from the accountant. It's usually because they want access to additional investment opportunities. That certificate expires every 2 years and has to be renewed. If they don't renew it, they fall back into being a retail investor. And so we see that people are actively choosing to be wholesale investors, and that comes with risk which they take on. And in fact, there are significant processes in place within our member firms where it's not just simply the receipt of the certificate that makes someone a wholesale investor. The firms will have often a risk matrix that they apply where they look at the education, the investing experience, and the understanding of the investor to make a decision as to whether they should be in that category. Some firms have a panel which looks at the issue to make sure that that person should be a wholesale investor and has the financial literacy, and they will take into account things like, for example, if you're a director of a public listed company, you have as one of your director's duties the capacity to read and understand financial statements, therefore you have a level of financial literacy. And also, I think importantly, the process goes through the compliance department. It is not the advisor who can put that investor on as a wholesale investor on the register. It has to go through the checks and balances, and ultimately it's the compliance department that will put them on. So I think with all of those rules and checks and balances and risk matrices that are in place, it's quite clear that people are electing to be wholesale, and then there is quite a considerable process about whether in fact they should be in that register. And so we don't think that the compensation scheme of last resort should extend to wholesale investors. They have financial resources to be able to take matters through the court. Again, looking at the Treasury review of AFCA, they made it clear that they think AFCA should in fact be more careful in exercising its discretion to take complaints from wholesale investors, because the system was being gamed to some extent by people who had financial resources to take matters through the court, but who could see that they could go to this free system. And so extending the compensation scheme of last resort, we think, yes, is not a wise idea.
Okay. You've made strong representations in relation to exemptions for participants where the minimum levy needs to be $1,000 for those participants to have to pay the levy. Is that still subject to consideration through the development of the regulations, or is that actually, from your understanding, actually provided for in the legislative scheme that's proposed?
I'll refer to my colleague Michelle. Would you like to take that one?
Yes, thank you, Judith. Chair, thanks for the question. We raised this issue of the $1,000 minimum in our roundtable discussions with Treasury back in August, and the $1,000 minimum was definitely part of the proposal paper at that stage. We put in a submission back in August of last year, raising our concerns in relation to that $1,000 minimum. And we were encouraged to put those points in our submission. They were points that were raised by ourselves and other attendees of those roundtables. Because the makeup of the levy and how the levy is going to be calculated is going to be in regulations, we don't know yet whether or not the $1,000 minimum will be a part of this new scheme, because it's not currently in the bill, because it would, if it were to still be on foot, it would be in the regulations. However, obviously, we've put forward our arguments why we think it gives rise to moral hazard. In the proposal paper that was issued last August, it's interesting, the design of the $1,000 minimum levy, the reason behind it is it didn't want small firms to be leviable. And we would certainly argue that it's the smaller firms we consider who are more likely to give rise to an unpaid AFCA determination than the larger firms who have more resources and more robust PI insurance policies.
So there's a policy tension there, I guess, between on the one hand seeking not to impose an additional financial burden on smaller firms, but on the other hand, recognising that by their very nature, a smaller firm is going to have less capital adequacy and potentially less systems and processes, checks and balances to prevent the loss occurring in the first place. Is that a fair summation of the policy issues?
That's exactly right, Senator. And I'd also raise another issue, and that was when we first had our roundtable discussions with Treasury back in August, there was also raised the issue of administrative efficacy and IT. So it was felt that issuing a small levy, a levy notice for a small amount may in fact cost more money than the levy coming in, and that it would not be just as simple as putting a line item on the ASIC industry funding model levy notice. However, we would certainly like Treasury to look into that because we think that if you can have a broader based levy, the levy amount will be more broadly spread amongst the industry and would hopefully obviously go down and be more manageable for everybody.
And that would also be consistent with the policy that costs should fall where the liability arises. Is that a fair comment?
Yes, Chair, we certainly think so. We're certainly concerned about, say, the smaller firms not being subject to the levy at all, and they being more likely to be unable to pay an AFCA determination.
Okay, thank you. I'll now give the call to Senator Chisholm. Senator Chisholm, do you have any questions?
Yeah, thanks. I got a couple. The Law Council in their submission specifically highlighted that the CSLR would apply to persons dealing in securities, but not interests in managed investment schemes. Does your organisation agree that stockbrokers should be covered by the scheme and required to pay levies, but not managed investment schemes?
Thanks for the question, Senator. Yes, our members support a compensation scheme of last resort. We note that our members who are securities dealers are exempted from the levies because Treasury, in the design of the scheme, has taken into account the existence of the National Guarantee Fund. However, when stockbrokers provide personal advice to retail clients, they fall within another category and they then become leviable. Talking about managed investment schemes, our view is a consideration of whether to include the managed investment schemes in the scheme would require, I think, Treasury to have another look at the design of the scheme. Clearly, it would increase the ambit of claims that could be made, and we think that would be a fair amount of work would need to be done if that proposal was going to be taken up.
Okay.
And if I could just comment further, the National Guarantee Fund, with securities dealers being exempt from the compensation scheme of last resort, if they're not providing personal advice to retail clients, there's $100 million in that fund already. So in other words, our sector already has a compensation scheme that's in place, and it's only those members who provide personal advice to retail clients who would also be part of the compensation scheme of last resort.
Okay. Thanks for that, Chair.
Thank you very much. In the time left, I wanted to tease out this issue, if I could, in terms of professional indemnity insurance that has been the subject of some discussion. So can I please ask what the witnesses' views are with respect to where the role of professional indemnity insurance in this space and what the government needs to be concerned with in that context?
So for market participants, just to sort of go through their requirements, there are minimal capital obligations imposed on them by the market integrity rules. There's a requirement to manage and lodge margin each day with ASX as part of their daily settlement requirements, provision of a monthly liquidity return to ASX, notification to ASX and ASIC of significant professional indemnity claims, and cash flow forecasting to ensure they have sufficient cash to manage their obligations into the future. So in terms of their professional indemnity insurance, as you can imagine, it is significant, but there is recognition that it is a very difficult insurance market at present, and we have members who are finding it extraordinarily difficult to get that professional indemnity insurance. John Trowbridge has recently put out an excellent report for the Insurance Council of Australia on insurance, and makes the point that there's no easy answer at the moment to insurance challenges. He puts forward some sort of suggestions that could be looked at. But given how important insurance is to be able to respond to a claim in the first place, that is why we really would like to see consultation on the effectiveness of professional indemnity insurance and looking at the John Trowbridge report to see if there are things that could be done, because PI insurance sort of is so important in clarifying the source of unpaid determinations and the reduction of risk to consumers. And so it's a missing piece of the puzzle. If we don't understand how that's operating or not operating at present, then we really can't go to a risk-based approach for the compensation scheme of last resort. Michelle, did you have anything further to add there?
Oh, yes, thanks, Judith. I know that there are certainly high deductibles, increasing exclusions, difficulties in obtaining PI insurance, but also very high excesses. So, for example, we recently had a member tell us that their excess was $1 million. So in that particular instance, you're essentially self-insuring. So certainly if you were a firm and you had a case brought against you and you had an AFCA determination, it may very well be that your insurance does not respond, and so you're self-insured for that. So that's why the government review of PI insurance, we think is a very important review.
So that, I mean, it's interesting that example you give of one of your members saying they could only procure professional indemnity insurance with an excess of $1 million, which is well in excess of both the cap that's contained in the compensation scheme under the proposed bill of $150,000. But I mean, that's also well in excess of the cap that applies to compensation claims under AFCA, which I understand is in $542,000 or so. Isn't that correct? So that would mean the excess applicable in that case is well in excess of either cap, wherever you set it. Isn't it? Whether or not you do it under the 150 grand proposed in the bill before us now, or the AFCA cap, isn't that correct?
Yes, that's true. And obviously for larger firms with the financial wherewithal, those claims are essentially self-insured.
Yeah, okay. But Ms. Fox, isn't it the case though that to some extent we're dealing with a moving feast? So there's more regulation coming in all the time in terms of ASIC's product intervention powers, considerable reforms with respect to the professionalisation of the financial advisory sector, continuing regulation on a whole number of fronts. Professional indemnity, the insurance market generally is a moving target with respect to accessibility of terms. If you're going to introduce a reform, you need to do it at some stage. And if you don't, well, you'll always just be looking at how you take advantage or consideration of the moving, shifting environment, and maybe it's better to at least introduce a compensation scheme of last resort and then make it subject to ongoing review. Isn't that a potentially an appropriate policy response?
Chair, I understand completely where you're coming from. I guess what I would say is, first we have to see the regulations to see how the levies are being calculated. Is it actually a risk-based approach or is it not? I do think we need to be looking at a scheme that is modelled on recent data and not out-of-date data. And whilst it might be too optimistic to hope that we could look at PI insurance before the scheme was introduced, I think some of those absolute basics about seeing the regulations, understanding how the levies are being determined, who's in, who's out, who's paying for what, and genuinely getting a handle on whether it's a risk-based scheme or not. I think they are sort of the prime issues and priorities at the moment.
Okay, so there's a real imperative in terms of getting the draft regulations out as soon as possible so the different sectors who are going to be impacted can actually see how the levies are going to be calculated and how that dovetails with the risks associated with each sector. Is that a fair comment?
Absolutely, absolutely. Plus, I think really we should be able to access the data from AFCA around unpaid determinations, which has not been made available, because that will also give us clarity about risk.
Okay. Okay. Thank you, Ms. Fox. So I thank both witnesses for appearing today. It's greatly appreciated, and thank you for the time that was put into your submission, which I found very helpful, and I'm sure other committee members found very helpful. So I would ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. Thank you very much. I'd like to now welcome representatives of the Australian Banking Association. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. I invite you to make a brief opening statement should you wish to do so. And for the Hansard record, could you please state your name and the capacity in which you appear? Thank you.
Good afternoon, Mr. Chairman. My name is Christine Cupit. I'm Executive Director of Policy at the Australian Banking Association, and I would like to make a short opening statement, please.
Yes, please, Ms. Cupit.
Good afternoon, Senators. Thank you for the opportunity to expand on the ABA's submission to this inquiry and discuss the banking industry's support for the financial accountability regime and the compensation scheme of last resort. The ABA supports passage of the Financial Accountability Regime Bill and the Financial Services Compensation Scheme of Last Resort Levy Bill and related bills. The bills are an important element of the government's response to the Royal Commission. Since 2019, the government has legislated and the industry has implemented significant changes to ensure the problems identified by the Royal Commission have been addressed. Banks have changed their remuneration structures to comply with the existing banking executive accountability regime and the recommendations of the Sedgwick Review of Retail Banker Remuneration. Banks are now required by law to design their products with their customers' needs in mind and to sell these products to customers within the target market. Banks are banned from pressure selling extra products and services, and they are required to give customers 4 days before selling add-on insurance products. Banks must report more breaches to ASIC and in a more timely fashion. Banks are also required to resolve customer complaints in a faster and more transparent way. Banks have changed the banking code to include stronger protections for farmers, culturally and linguistically diverse customers, and First Nations customers. The banking code is regularly reviewed and expanded to ensure it continues to deliver benefit to customers. The ABA encourages the committee to consider the cumulative improvements of the Royal Commission reforms already in place as part of reviewing the financial accountability regime and compensation bills. The ABA supports the provisions of the Financial Accountability Regime Bill. We recommend to the committee that the FAR Bill be amended to allow for a start date 9 months after the commencement of the bill. To ensure a successful and sustainable compensation scheme, the ABA supports establishing a scheme that is initially limited to financial advice failures. The scheme should be scalable to potentially include other services where there is clear evidence of continuing unpaid determinations and the potential liability of the scheme is modelled and well understood. This position is consistent with the recommendations of the Ramsay Review, which were endorsed by Commissioner Hayne. The ABA recommends to the committee that the compensation scheme bill be amended to align the scope of the scheme to the Ramsay Review recommendations. The ABA also recommends that the bill be amended to require a parliamentary process for setting the special levies. The ABA also encourages the committee to consider recommendations supporting government action to implement reforms to strengthen professional indemnity insurance requirements and enhance ASIC's powers to take action against entities and individuals with unpaid determinations. The government should also consider that the scheme costs remain efficient and proportionate to the compensation paid out by the scheme. I'm happy to take your questions.
Okay, thank you very much, Ms. Cupit. I'm going to put to you a number of propositions that were received in a submission from Choice and a number of other consumer advocacy organisations. Have you had an opportunity to read their submission?
Yes, Senator.
Okay, So I'm interested in your views. I did put a few questions to them earlier in the day based on my experience dealing with senior executive remuneration, which comes from my background as being an ex-company secretary of an ASX listed company. So I have that background, but I really want to get your view with respect to some of these propositions. The first is that civil penalties should be levied against individual executives, or individual executives with certain senior accountabilities should be liable to suffer the impost of civil penalties in the event that they don't discharge their duties. What's the ABA's view with respect to that?
So our view is that the regime doesn't need to include civil penalties for breach of the accountability obligations. And the reason is that the regime already includes significant personal consequences for those accountable persons. Obviously, there's the loss of variable remuneration, which can be significant in some cases. And more significantly, there's the ability for APRA to disqualify the executive from being an accountable person at that entity and at other entities in the industry. And this has far-reaching impacts, financial impacts and personal impacts in terms of the person's career prospects going forward.
And I guess one of the concerns I had was if you're dealing with a senior executive in that position, they will seek indemnification or insurance to cover them for that risk. And if they can't get that, then they'll seek additional remuneration to cover them for that risk. So it could actually have and this isn't the consequence, of course, intended by the consumer advocates, but it could have the unintended consequence of actually leading to an increase in particular of base remuneration. Is that a fair comment?
Well, APRA requires each bank to develop a remuneration policy, and those policies require the bank to consider the balance between fixed and variable remuneration. So it would be up to each bank, I guess, to assess the mix there, having regard to APRA requirements and the new financial accountability regime.
Okay.
I think one of the points that is important to note, Senator, is that the FAR covers a much greater range of entities than the BEAR did. Our banks have all implemented the BEAR and are already applying the deferred remuneration arrangements and have been for almost 3 years. Whereas we've got newer, smaller financial services entities that are going to be within the regime. And there are potentially competition impacts for those entities in terms of being able to attract senior executives when they're effectively competing with Amazon, Google, other non-financial services sector organisations for that executive talent. So we are concerned about the competition impact of having civil liability provisions in the regime for those smaller entities that are now being brought into the FAR fold.
Okay. So the choice submission, the Consumer Advocates submission also proposes that a greater proportion of variable remuneration should be subject to deferral, and such deferral should be over a longer period of time. And they give examples or reference to the situation in the United Kingdom as being a model which they're attracted to. Does the ABA have any response to those arguments from the consumer advocates?
Yes. So I think the important point to make is that the FAR prescribes a minimum of 40%, and it is open to financial services entities through their remuneration policies to have a greater percentage and a longer duration if that meets their risk appetite. Importantly, though, we sort of brought back to this competition issue around the impact on smaller entities and more nascent entities like fintechs and new entrants who are competing for that executive talent with entities that aren't subject to the FAR. And greater than 40% or a longer than 4-year period might start to tip the balance for those executives to stay out of those smaller financial services entities.
Okay. Is the ABA aware of how the system works in the United Kingdom and how the sector deals with how Choice summarises the application in the United Kingdom? Because presumably the same issues would apply in that jurisdiction.
So I think probably one of the issues that is brought out is the concept of needing to further defer remuneration where a regulatory investigation has not been completed. Is that one of the scenarios you're referring to,
Correct.
Senator?
Yeah.
I think what we would like to see is the ability for those regulatory investigations to be completed in a really timely way, so that the resolution can be determined and the action taken by the regulator. And that is why we think that the recommendation and the arrangements put in place for banks and entities to cooperate more fully with APRA and ASIC is important, so that those kinds of regulatory investigations can be concluded as quickly as possible.
Okay. And from your perspective, the concept of cooperation and being open and transparent with the regulator, I was reflecting on this last night. I was reading the submissions. Is that, from your perspective, how your members are currently dealing with the regulators? So there's no change in terms of practically how you deal with the regulator now, contained in the principles contained in the bill?
I wouldn't say that there's a substantial change that's imminent. That substantial change has already occurred in the wake of the Royal Commission. So we've had much more comprehensive breach reporting obligations introduced in terms of reporting breaches to ASIC. The notification obligations to APRA in the BEAR are very significant and have been complied with for some 3 years now. And I think you'll find, having read APRA's submission as well, that APRA talked specifically to the BEAR being a key regulatory lever for APRA, and that understanding the accountability maps has been a key part of their day-to-day supervision of the industry.
Okay. The Choice submission and the submission from the consumer advocate organisations puts the view that the FAR scheme, remuneration scheme, should be extended to include senior managers. So it should move down a level, if you like, from accountable person to the next level down of manager. What's your view with respect to that proposal?
So our view is that the accountability should be concentrated with the most senior executives, and that is consistent with the intention of the BEAR and now the FAR, which is to be able to readily identify who's responsible. If you start to create a more diffuse set of accountable people, then there's the risk that, if everyone's accountable, no one's accountable. And that's exactly what the FAR is trying to avoid. The other thing that I would say in relation to senior managers is that the banking industry in 2017 put in place a reference checking protocol, which was overseen by an independent review by Ian McPhee, who's the former Auditor General. And that reference checking protocol requires banks to exchange information about employees and why they left the bank. So senior managers are subject to that reference checking protocol.
How do you deal with privacy issues in that context?
It was a very significant process to develop the protocol, and the 2 key risks. One was defamation. So the design of the reference check is very specific and fact-based and goes to, whether the person had been dismissed because of a range of different conduct issues. And in terms of privacy, it's based on consent. So the employee and the prospective employee needs to give consent for that reference to be provided.
And so I suppose that that scheme dovetails with the point you made earlier in relation to the need for civil penalties to be extended to individual executives. If you've got that scheme in process, then there is going to be detriment suffered by an individual executive if their employment's terminated with a financial institution, because the reason for that termination is going to be known to other players in the market. Is that a fair comment?
Yes, it is.
Okay, all right. Senator Chisholm, do you have some questions?
I do, thanks, Chair. The ABA indicated that it would like to see concurrent reforms to regulatory requirements in conjunction with the establishment of the CSLR in order to reduce claims being made against the CSLR. What concurrent reforms would the ABA like to see in place?
So there's a couple of reforms which have been touched on already by other witnesses. The key one is a review and some reform around ASIC in monitoring and supervision around the adequacy of professional indemnity insurance. So having adequate compensation arrangements is a condition someone's licence. As part of the annual return to ASIC, the licensee needs to confirm that they have professional indemnity insurance in place, but there isn't a more qualitative process to assess whether that professional indemnity insurance is adequate. And that goes to things like assessing how big the excess or the deductible is, what kind of reinstatements there are in the policy, and whether the licensee would indeed be able to fund the excess, particularly if there are a number of claims to be drawn. So we would like to see a review done and potentially more powers for ASIC to be able to conduct that review of PI. We also think that there should be another review conducted of the financial resources required for AFS licensees. Again, it's a condition of the licence that a licensee has adequate financial resources, but these are not and shouldn't be anywhere near as significant as the capital requirements on banks, but it does mean that in some cases the financial requirements are held very low. So we would like to see more scrutiny of the financial requirements of licensees. And then we would like to make sure that ASIC has appropriate enforcement powers to take action against licensees that have unpaid determinations and prevent those persons from establishing a new financial services or credit assistance business.
And in terms of these reforms that the ABA would like to see, what would be the consequences? So do you see, for example, that these reforms could see less claims against the CSLR?
That's a potential outcome. I mean, certainly it would reduce the risk of those claims or the number of claims. And these proposals are not sort of the ABA's idea. They've come from initially the report by Richard St John, which was released in 2012, and were endorsed by the Ramsay Review. So I think it's about trying to put all fingers in the dam around reducing the risk that the scheme is needed to be used or drawn on.
Okay, and can you quantify, like, how much do you think those reforms could save in terms of claims against the CSLR?
Not in a dollar figure, Senator. AFCA may have some sort of greater insight into that, or the professional indemnity insurers themselves. We've just sort of, I guess, making this point from a first principles point of view of how do you avoid the scheme being necessary or it being necessary to draw on the scheme, and having adequate professional indemnity insurance is one way that you could do that.
Okay. The ABA submission is supportive of the scalability of the CSLR. If the CSLR was expanded, for example, to cover managed investment schemes, are there other reforms the ABA would propose to reduce the chance of future claims against CSLR?
Well, I think it's probably worth addressing what would be necessary in order for us or for the industry to support the scheme being scaled up. And that comes down to the data, to having the necessary information around the quantum of unpaid determinations and the potential risk going forward, so that we could understand the potential liability of the scheme and make sure that it is properly and equitably funded. I think most of the witnesses today have been all on the same. We're all on the same side, different sides of the same coin in terms of wanting a successful and sustainable scheme. And our view is that in order to have a successful and sustainable scheme, you would need to have that data and understand that potential exposure before expanding the scheme. But to your question, Senator, around other mechanisms, we haven't turned our mind to that explicitly in this submission, but some of the issues that we have raised more generally are around financial capability. We're very big supporters of ASIC Money Smart website, and increasing that financial capability and also the accessibility of affordable financial advice would be a big part of reducing that risk going forward.
Okay. Thanks, Chair. That's it from me.
Is Senator Pratt here? I've got a quick one, if that's
possible.
possible.
Over to you, Senator Pratt. You've got the call, and we've got another 10 minutes with this witness, so feel free to use the balance of the time.
May I ask, please, if the scheme were extended to cover managed investment schemes, what liability, if any, would banks have in that context?
Well, we support the sort of principle that the industry subsectors should generally be levied to pay the unpaid determinations of, their own subsector. But what we can anticipate around managed investment scheme failures is that if they were systemic and significant, you would very quickly exceed the financial resources of the scheme. And the powers for the minister or potentially the parliament would then be triggered around an additional levy. As it stands, the additional levy can be levied on particular participants. And I think it would be reasonable to anticipate that banks and therefore the customers and shareholders of banks would be drawn on to fund the scheme and fund the unpaid determinations.
So is that the basis of banks wanting to have that clarity? Now I'm really trying to get my head around the numerous calls to have managed investment schemes included, but given there's no direct liability for banks in the sector-based funding for that to be the case, why the ABA is so reluctant in that regard, particularly when if you've got, for example, in the case of a collapse like Sterling, banks got their money back in terms of loans that they had made within the scheme, for example, to landlords, whereas the retail investors didn't.
Well, the ABA's position on managed investment schemes and having a broader scheme than financial advice more generally is informed by the Ramsay Review and the recommendations of Commissioner Hayne. Both of those processes were extensive. They benefited from a lot of evidence in terms of submissions made, data, evidence from affected customers, and both of those processes concluded that a scheme covering financial advice that was scalable was the appropriate response at this stage. So that really informs our position around having a scheme that is initially limited to financial advice.
Others have said that managed investment schemes are clearly intended to be included by the Ramsay Review and that therefore it should be done. Now, the extent to which we grapple with those issues in terms of how it's that's part of what we're trying to grapple with now.
Well, respectfully, Senator, our reading of the Ramsay Review was that in the first instance, the scheme would cover financial advice failures.
Yes, but it's been, do you not accept that given the Ramsay review was now some time ago, that it's starting to become more difficult we can't string this along forever as far as resolving that goes, given that we're looking at a cohort of unpaid determinations that do exist post the creation of AFCA, the extent to which we can delay implementation of that and properly deal with an assessment of what's in and out, given that the time frame of what's being paid out need to be paid out under a future scheme would go back some years.
Well, I think one of the critical points is that while there is some examples of potential unpaid determinations that have been given to the committee this morning, at this stage we don't have hard data on what the quantum of the unpaid determinations is. We don't have modelling on what that would mean in terms of needing to fund the scheme and how that funding would be levied. And we're also operating in an environment where there's significant financial innovation, and managed investment schemes are being used to do things that they weren't previously used for. So managed investment schemes are the basis of a number of peer-to-peer lending offerings. They, are the basis of some new crypto funds that are emerging. So we're dealing with unknown in terms of the quantity of or quantum of unpaid determinations, unknown in terms of the impact of the scheme, and then unknown in terms of financial innovation and what potential black swan events might occur in the future.
Is there another way of working out how we look at some of, if for example cryptocurrencies are going to be registered with AFCA, and they will need to comply with all of those other attributes in relation to insurance, etc. If that were the case, do we need to have a look at what's really included in managed investment schemes in that context?
Well, it's certainly true that the government is considering quite holistically the regulation of the crypto environment, but those reforms haven't been determined and certainly aren't in place at this stage. But I guess I would just sort of bring us back to, the ABA's position, which is that we support the recommendations of two very comprehensive reviews that were informed by a lot of data and evidence. And for us to be supportive of expanding the scheme to managed investment schemes, it would be responsible to have the modelling and the data to understand what the impact is on the scheme. And at the end of the day, we want the scheme to be successful and sustainable and improve consumer trust and confidence.
Thank you, Chair. I'm just trying to understand that answer. So you're simply unclear. Did you get any feedback on the basis on which government says those issues are still to be resolved for the purpose of the draft and how it was managed in those consultation processes?
I'm sorry, Senator Pratt, do you mean the extent to which other products did?
Well, it seems to me that it was put to government that these products should be included when the draft was being consulted on by Treasury. I'm just really trying to work out what Treasury needs to be asked about the proper consideration of those issues?
Well, the Treasury didn't provide to industry its most recent data in terms of unpaid determinations or modelling. So we're not, and other witnesses have explained the same thing, that we're not sort of privy to what information the Treasury might have around including a broader set of products.
Is it possible, do you think, really, to model that, given the broader changes in managed investment schemes in relation to them also needing to be, fit for purpose for particular cohorts of consumers? How do you think, will our regulators therefore push schemes out that don't meet that, or is there going to be greater focus, in your view, on those kinds of problems within a scheme, within AFCA's determinations itself? I guess the issue being that ASIC will have these new rules, but the extent to which it can prevent, for example, products that are misleading or unsuitable from coming to market will be material to the extent to which any losses then might be realised further down the track for retail consumers. Does that?
Yes.
Because I can't really get my head around how to model that, given there's the legacy of payments in managed investment schemes since AFCA was first created that would be eligible. But then there's also the issue of, well, if we say that these schemes are in, or whose job is it to push the schemes that shouldn't be recognised, or that have problems with them, to make sure that they don't come before AFCA at all, in terms of not having offered to the market in the first place?
Senator, you've raised a really good point around the change in the risk environment and the regulatory environment. There have been some very significant reforms introduced in terms of the design and distribution obligation, which means that products need to be marketed and sold within a market for whom those products are appropriate. We've also got ASIC with a new product intervention power, which means that it can take action to prevent the distribution of products or require a change to the design of a product. We've also got the professionalisation of financial advice and the very significant reforms and steps that the profession has taken to ensure that misconduct is stamped out. So there has been some really genuine changes in the risk environment. But I guess that still leaves us with the question about whether products should be introduced into the scheme. And our position is that until we can effectively model that, it wouldn't be responsible to include them.
So in that context, do you mean that because at the moment, the legacy is that in introducing this scheme, unpaid determinations, irrespective of whether they're from a managed investment scheme or not, well, those who aren't from a managed investment scheme, prior determinations for collapses in terms of last resort would get paid out. If you're saying that managed investment schemes should not be included until we've got the modelling for the future, what do we do with the payment legacy of current unpaid determinations? Do they never get paid out, or do we wait and see what the accumulated cost is going to be? That's going to make the issue much worse as far as sustainability. Or are you simply saying that those consumers who've had losses to date will never be compensated?
So the government committed $30 million as part of its response to the Royal Commission to pay the unpaid financial ombudsman scheme determinations. In terms of unpaid AFCA determinations, the industry doesn't have that information. So we can't make an assessment about what would be required to fund those.
Yes, but are you therefore saying that those people will never get paid, or you're not considering that issue at all in the context of the point in time in which managed investment schemes come in or may come in?
Well, ultimately, that would be a matter for the government in deciding whether any expansion of the scheme was retroactive.
But if it was done along the same model as now, it would be retroactive, but it gets harder and harder to make it retrospective if the longer the amount of time that passes, I would think.
Well, I guess that's an option for the committee to perhaps make a recommendation that the government should conduct a review and some potential modelling about what the exposure might be.
Based on the current determinations, perhaps we can find out what that exposure does look like in the course of this inquiry now. Thank you.
Thank you, Senator.
Thank you, Senator Pratt. And Ms. Cooper, if I can thank you for appearing as a witness today. It's much appreciated. I would ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on Parliament's website. The committee will now break for 1 hour for lunch and reconvene at 2:10 p.m. Thank you very much.
Thank you, Mr. Chairman.
Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions on notice should be sent to the Secretariat by close of business Thursday, 3 February 2022. And I invite our witnesses, if they would like, to make a brief opening statement. And for the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senator. Blake Briggs, Acting CEO of the Financial Services Council.
Thank you, Mr. Briggs.
Hello, Senator. Bianca Richardson, Policy Director for Investments and Global Markets at the Financial Services Council.
Welcome, Ms. Richardson.
Hi, Senator. My name is Ashley Davies, Legal Policy Manager at the FSC.
Excellent. Thank you very much. Mr. Briggs, do you have an opening statement or do we move straight to questions?
Thank you, yes, Senator. I do have a short one, but I will keep it brief. The Financial Services Council welcomes the opportunity to appear before the committee and into the proposed compensation scheme of last resort and the financial executive accountability regime. It's important to note that these reforms are a few of the final Royal Commission recommendations, which does not mark the end of the Royal Commission journey for the industry, as it's incumbent upon our sector to ensure the reforms are a success. But it's an important landmark as the Commission process moves on from inquiry and legislation to implementation of stronger consumer protections. The FSC is broadly supportive of both the proposed regimes, but note there are some flaws to their design. On balance, we recommend the committee pass the respective bills as it strikes the correct balance between protecting consumers without burdening the industry and consumers of well-run organisations that have done nothing wrong with additional cost. On the accountability regime, the government has faithfully implemented the recommendations of the Royal Commission. We do have some concerns, such as the potential inappropriate application to certain foreign entities and how the regime's reach applies to accountable persons. But on balance, these are technical issues and should not disrupt passage of the bill. On the compensation scheme, so I'll briefly deal with the compensation scheme if you don't mind, Senator. On the compensation scheme, our submission is that the regime could be improved to make it true to label, that is, a genuinely last resort scheme. The proposed scheme will compensate consumers, particularly in the advice sector, which is the primary source of unpaid determinations, that have experienced poor, non-compliant advice and experienced loss as a result. The current regulatory framework, however, does not have a strong capital requirement for the finance sector, the financial advice sector, and there has not been effective enforcement of the existing requirement to hold adequate capital. The FSC recommends strengthening capital obligations so that well-resourced and effectively managed advice businesses are not left underwriting the poor practices of their competitors. Similarly, we support strengthening the professional indemnity insurance requirements for the advice sector to provide a first line of defence for consumers seeking compensation, and proof of the insurance cover should be provided to ASIC to enable the regulator to coordinate spot checks. The professional indemnity market in Australia is problematic, but the solution to that should not be pushing the cost onto other market participants. Strong insurance arrangements, as well as effective ASIC oversight, would allow the scheme administrator to identify and claim on insurance where there is an unpaid determination before moving the cost onto the industry more broadly. Together, these improvements to the regime will ensure it is genuinely a last resort compensation scheme rather than a first resort. Thank you again for the opportunity to appear, and I'm happy to answer any questions you may have.
Thank you, Mr. Briggs. I will be sharing the call with my colleagues, but in terms of my initial set of questions, I want to try and traverse as quickly as possible the recommendations and suggestions from the Financial Services Council. Many, I think, are very important to make sure we get this regime right from the outset. The first issue which is raised is that in relation to uncertainty and or unintended consequences for foreign entities. So could someone please, a member of your team, speak to that and what we need to be taking into account there, please?
I might hand to my colleague Ashley on this one, who's the expert in the executive accountability regime.
Mr. Davies, you've been referred to as an expert, so that's a big introduction.
I'll try and live up to it. So I think the foreign entities issue really is a technical one of drafting in terms of what we look at in the bill, particularly with regards to RSE licensees. And the fact that a significant related entity of an RSE licensee can be a connected entity, and they use the definition from the SIS Act of connected entity. So the RSE licensee, as the accountable entity, is then, in theory, potentially accountable for a parent, for example, or a sister company. And the issue really is that while it's an accountable entity, in practice and in law, it often will not be able to account for the parent or sister entity's actions because it cannot control the entity, the parent or the sister. So in a nutshell, that's what we feel is the problem with the definition there, particularly as it applies to RSE licensees. And if you look at the definition of significant related entity of an RSE licensee, we feel it's inconsistent that that definition, which uses the definition of connected entity, does not align with the definition of significant related entity as it applies to insurers and banks, where, of course, there is no bringing in of this definition of connected entity. So you have this sort of mismatch of two potential definitions there, one which applies to the super business and one which applies to insurers and banks. So it's not clear on the face of it why there are these two definitions, but then it's also not clear why the intent under the bill seems to be to capture parents and sister entities. And this can be particularly problematic where you're talking about members of a group where the sister or parent entity concerned has nothing to do with financial services. So, you might have a standalone, in-house super fund, if you like, as part of a big international group where the parent is involved in telecoms and the sister is involved in aviation, to use a couple of examples from this morning. So, why are those other parts of the group potentially caught by FAR, which of course has the consequence then of accountable persons potentially within those other entities having to sign on and be subject to deferred remuneration provisions, penalties, and the like. So we're not sure, but we think that this could be fixed with relatively quick drafting changes to the definitions there.
Okay, understood. So we'll certainly ventilate that issue with Treasury when they appear before us later today. But as you say, it could well be an unintended consequence or uncertainty arising from trying to draft for quite a complicated issue. Can I move to the next one, which is the enhanced notification threshold? So just to summarise, so I understand the issue. The issue is if you set an asset amount as the trigger to take you into the enhanced obligation or notification threshold territory, it could well be that an entity is above that amount of net assets for a particular period in time and then falls below it. So they're in and then they're out, they're in, they're out. So there needs to be some give in the system. Is that the issue?
Yeah, I think that's one of the concerns, really. I think we'll use the word having in a buffer, building in a buffer, so that if suddenly you are in, then you should be given a little bit of time because it might be unexpected that you're suddenly within the definition. So there might be some merit in having flexibility in terms of a time buffer to allow people to have time to prepare. And then, as you say, they might then fall out of the definition as well. And then the other concern, I suppose, related.
And just sorry to interrupt, Mr. Davies, but I will do this a few times just because I want to tease out the evidence in the limited time. It seems to me the buffer could cut both ways then. So you might be above and then fall below, but probably should continue to comply for at least a certain period of time whilst you're in that buffer zone. Is that a fair comment?
Well, we haven't considered, I suppose, falling out, but rather we've been looking at falling into the definition. But yeah, as a matter of logic, that does seem to be, you could fall in unexpectedly and require time to prepare, but then equally you could fall out of the definition, again, with relatively little timing notice.
Okay. The issue in relation to the breadth of the concept of accountable persons, is it, what's the particular concern there that you can't look at the bill itself and be totally satisfied that someone might become an accountable person through regulation or through some other means, and therefore there's uncertainty as to who is or is not going to be an accountable person? Or is it the actual ambit of that term or that category of person in the bill itself?
I think it's both. Potentially, yes. I suppose in terms of the prescribed position and prescribed responsibilities issue, that is, of course, subject to ministerial rules. And there is uncertainty in terms of what those rules are going to say. And so in terms of being aware, in terms of preparing for FAR, it would be helpful to have early sight of draft rules, of course, and greater certainty as to the ambit of prescribed positions and prescribed responsibilities.
Sorry to interrupt again, Mr. Davies. Do you accept the proposition, though, that one of the things we must be careful of in terms of legislation is to make sure that there are no gaps, there are no lacunas, so there is at least one accountable person with respect to each relevant part of the business, and we don't get into a situation where the definitions work in such a way that parts of the business aren't covered?
Yeah, I mean, I think the spirit of the legislation is accepted in that regard. I think it's more having early sight of what is specifically intended in terms of prescribed positions and prescribed responsibilities. That's one aspect of it. And then the other aspect of it is the definition, the first limb of the definition, if you like, of accountable person, which is somebody who has actual or effective responsibility. Members would prefer some further guidance on issues of what is the actual or effective managerial responsibility we're talking about, with some further examples of that, if possible, in the guidance before the bill becomes effective itself.
Okay. Some of the issues which you've raised have been raised by other submissions, so I'm not necessarily going to touch on those where I think they speak for themselves. But one issue which I don't think we've canvassed so far today is this concept of reasonable steps. And the council recommends, and to quote from recommendation 5, recommends that the legislation be clarified to provide that the reasonable steps obligation will be assessed in relation to an accountable person's position, the circumstances at the time, and the person's prescribed responsibility and level of expertise, end quote. When I looked at that and I looked at the section, I thought, aren't those matters which would just as a matter of course would be considered as part of whoever's making the determination, determining whether or not the steps undertaken were reasonable? We need to. I guess let me put it the other way. It seems to me if you overly define things, then you might be excluding other things unintentionally, right? So what's reasonable is objective assessment in terms of what's reasonable at that particular point in time, I would have thought. But I'm just wary that if we're too prescriptive, we might be excluding things which should be considered as part of the test. Do you understand the concern?
Yeah, and I think that's a fair comment. I mean, I think that the specific language we proposed we thought might be helpful to make the actual wording clearer. But I take your point that issues as to timing of when somebody is judged to be reasonable or not, and that will typically be a judgment based on all the circumstances at a particular time. These are concepts that logically would be imported and applied. I think the wording there was an attempt to try to clarify, be helpful in terms of the drafting. And I suppose one option is to, again, if it's not something that can be changed in the bill, to provide further clarity in the regulatory guidance that would go with the bill.
Yeah, okay, that's a good point actually. This concept of end-to-end product responsibility, this is an issue which we haven't dealt with during the course of today. So I'm keen to understand what's driving the concern in that respect.
I think the main issue there is potential duplication and overlap in the context of proposed positions and responsibilities that were released in the policy paper. Certainly some of our members were particularly concerned with the potential overlap with compliance function or even IT function, where I think the end-to-end product responsibility function potentially might overlap with those other responsibilities. That was one concern. And then the other concern was with the definition of, I think in the explanatory memorandum, there's a statement along the lines of two or more people will not be held jointly responsible, dependent on whether they're responsible for the same product. And then there were concerns as to, well, what do we mean by the same product in any particular business or circumstance? And so, again, I think the feeling was this is potential for some lack of clarity and duplication. And you might even have people artificially trying to engineer the definition of a product in particular business lines to make sure that they're not both responsible for the same product, for example. So I think that's the gist of the points we were trying to make.
Okay, understood. The impact for third-party service providers. So the concern the council has is to make it clear that the scope of the bill doesn't exceed or doesn't extend to capture contractors and independent service providers who hold a position relating to the accountable entity. Is that correct?
Yes, I mean, essentially, again, in terms of who is an accountable person, and given a statement in the explanatory memorandum, we wanted to clarify whether a particular third party would be intended to fall within the scope of the definition of accountable person or not, depending on the particular circumstance. So again, I think that was a point where maybe some consideration could be given to either in the guidance notes or in the drafting, just making a little bit clearer what the intention is, and perhaps a couple of examples might be helpful to illustrate where a third party may or may not fall within the definition.
Yeah, okay. I'll move on to the compensation scheme of last resort. And an area, again, I'm just focusing on areas which haven't been canvassed in detail so far today. So recommendation 3.27, if I can quote, there needs to be a further focus to reduce the administrative costs of the CSLR, which have been estimated to cost 46% of levies raised, whilst only 54% of levies are estimated to pay out consumers for unpaid determinations, end quote. Where's the source of that split between the 46% and the 54%? So 46% for administration, 54% for payouts. Where's that split come from?
Thank you, Senator Scarr. That comes from a Treasury discussion paper that was released last August, which included some modelling around what the potential cost of the scheme could be in its first year.
So does the 54%, sorry, the 46%, which is said to be administrative costs, does that include the capital reserve?
I don't believe it's the capital reserve. I believe it's the cost of the first year. The 5 million capital reserve, I believe, is intended to be collected over a few years. So
Right.
That will vary depending on what how that reserve is collected.
Right. It does. I mean, I must say, on the face of it, I'm looking at the figures, and it does raise some questions in my mind. Has there been any explanation given as to why the percentage of levies required for administrative costs needs to be that high? What's the basis for that? So what makes up that total cost figure? Are there any particular elements of that aggregate figure which you think we should be focusing on in terms of breaking that down?
I think it's difficult to actually identify a line by line item in terms of which areas were estimated to cost the greatest amount in terms of the overall administration. I suppose the point that we wanted to make in relation to this is that the whole purpose of the CSLR is intended to compensate consumers. And we are very mindful that in establishing a scheme that there is prudent oversight around how the scheme is run and including just overall in terms of resources and everything else that goes into running a scheme such as this, because we're also mindful, for example, from the ASIC levy experience, that oftentimes fees can increase over time, and we just want to ensure that there is prudential or really careful oversight over how the administrative body is set up, and that's efficient and effective, so that really we are achieving the intended effect of the scheme, which is primary purpose is to pay our consumers, not to set up another administrative body.
A couple of observations I might share, Senator, are that the Treasury discussion paper was in relation to a proposed design. And so we wouldn't have final numbers on the amount or the proportion that goes to the cost of this finalised design that's currently before Parliament. So it may be higher, it may be lower. In practice, it's probably less than what was proposed in the original Treasury scheme in the Treasury paper. However, there were features of that proposed scheme which were overly complex. And just a simple example is, I think the original proposal included a board to oversee the operation of the compensation scheme, whilst at the end of the day, the AFCA process has already assessed someone's claim. It's found that a determination should be paid. The only ones this scheme needs to deal with are those where the organisation has gone under, and so it's an unpaid scheme. In practice, it shouldn't be more complex than effectively cutting the cheque then and paying it out and administering the levies from time to time in conjunction with ASIC. We really struggle to see how that should eat up 46% of annual cost of running the scheme. And so we made a range of proposals to try to make the scheme simpler I think some of those were picked up, but not all of them, for example. So we would hope that it could become more efficient than it is. But at the end of the day, the one before Parliament is the one where we have.
So Mr. Briggs, what are some examples of some of the suggestions the Financial Services Council made to increase the efficiency of the scheme that have not thus far been picked up? Have you got? Give me your three big cost-saving measures.
There were one or two that come to mind, but Bianca, feel free to step in if there are others that I'm missing. One was this point around not needing a board to oversee the operation of what should be a relatively simple administrative process. In conjunction to that, the process should be rolled into Treasury as opposed to setting up a standalone organisation to administer this, because establishment costs are quite expensive for these sorts of groups. And the other, I believe, was streamlining some of the processes with ASIC's annual levy collection in order to simplify the process. Bianca, were there others that I'm missing? Or were they the main ones?
They were the key ones.
Okay. All right. That's good. Very good. Okay. I'll open the call now to my colleague. Senator Pratt, are you there? Or Senator Chisholm?
I am here. I apologise for the delay in unmuting myself.
I would never delay in unmuting myself, Senator Pratt.
Yes, I'd be happy to ask some questions. I just need to find. I was a bit delayed in hopping on. Is it the Law Council we've got before us at the moment, or the witnesses before?
I wish I was as illustrious as the Law Council, Senator,
right,
but we are the Financial Services Council.
They're going to be, don't be offended, Mr. Briggs, by being accused of being a lawyer.
Now by the,
I'm more of the Bush lawyer type, Senator.
Thank you. We've got some of those in our party room. Go on, Senator Pratt.
I'm the same. You've noted the importance of concurrent reforms alongside the CSLR implementation to reduce the chance of calls upon it, the product intervention power, design and distribution obligations, and that's useful in relation to situations such as Sterling. Now that those reforms are in place, isn't it appropriate to include similar schemes in the CSLR? What's your argument for not including managed investment schemes?
Well, quite simply, if there's a robust regulatory framework in place that wasn't previously there when there were other issues in the market, then those laws should be allowed to work, and the regulator should use the powers that it now has to ensure there aren't problems in the future. I mean, sorry, go ahead.
Having sat through, and Senator Scarr might like to weigh in on this, ASIC did not see that these reforms that have been implemented would necessarily play that role.
Look, I struggle to reach the same conclusion. I can explain why if it helps.
That's from the regulator itself.
Well, let's work through the operation of the regulations. So the DDO regime requires an operator or a product manufacturer to identify a target market. It requires regular reporting from advisors and from its own staff into whether or not clients that have sold the product are within the target market or not. It then requires that information to be handed on to ASIC in a timely fashion. And so not only does the advisor know the needs of the client, the product manufacturer knows whether or not clients are within the target market determination.
Yeah.
And then the regulator also knows whether or not this product is being sold to people inside or outside of the target market. And so you would hope that the combination of those protections mean that people pick up pretty quickly whether or not a product is A, risky, and B, whether or not it's being missold. And so you'd hope a situation like Sterling doesn't arise under that regime.
But the findings in terms of the cases before Sterling, it's not so much just the collapse, it was also the finding of deceptive and misleading conduct. And ASIC says it doesn't really have the resources to do anything other than register a managed investment scheme. I know it has these other powers, but if it says that it's limited, it says it doesn't examine product disclosure statements. So again, we'd be relying on self-assessment from companies as to the extent to which they tick those boxes. And in the case of being misleading, they've already found to have been misleading and deceptive in relation to their existing target market.
So a couple of points I'd make on that. One is that the regulator gets to determine how it allocates its resources as to what its priorities are. Certainly from a FSC perspective, and you know, I don't intend to mince words around this, a number of our members have been subject to significant ASIC regulatory enforcement action, and that has been expensive. It has been sometimes successful for ASIC, sometimes it hasn't. But the net result is, you know, ASIC had adequate resources to pursue those matters. Now, in a number of instances, ASIC needs to choose where it is going to allocate its resources, and if its view is there are risky, smaller schemes such as these that aren't being adequately picked up, it's for ASIC to determine whether or not it would be a better use of its resources than necessarily going after larger, well-capitalised, well-governed organisations. And so that might, I suppose that's a question for ASIC, not a question for the FSC necessarily, but it does go to priorities.
I am not necessarily, I don't take the same level of comfort in the fact that you have said it's ASIC's problem, but we still haven't found, you know, ASIC has not said that these reforms resolve these issues as far as
and if I could make a point, which I think, sorry, Sarah.
It goes to the extent to which a product is insurable and or a product is independently assessed, as the extent to which Delosio said, who is taking a detailed look at these products and their suitability. If it was found to be false and misleading, it clearly showed that the PDS did not match the marketing or the risk profile that was attached to the product. ASIC is saying it's not its job to do that.
So let's put yourselves in the shoes of the consumer. So there are a number of gates here, I suppose, intended to try to protect people that should be cleared before we start saying, okay, we therefore need to underwrite risky products.
I know that the oversight needs to be tightened, because otherwise it's incentive for misleading conduct to take
and mis-selling products. I mean, you would hope that a good advisor, and 99% of them are, sit down with their client and understand their client's needs and say, here is a suitable product based on your personal circumstances. Now, that a good advisor would be able to look at things like the way that the Sterling Trust products were described and either say, look, you're a low income or a low net wealth person, you really don't want to put all your eggs in this one basket, because if something were to go wrong, it's high risk and you would be left in a very dire financial position. And terribly, that's the situation we've seen a lot of people end up in. But if these products are being missold through advice, then that's an issue and it should get picked up by FOFA and dealt with to the full extent of the law. Or if there has been misleading and deceptive conduct, then ASIC should step in and prosecute the scheme operators for their breaches of the Corps Act.
So, Mr. Briggs, if I can, with your indulgence, Senator Pratt, one of the issues is the time lag, right? So your promoters, they've devised this scheme, they're out there promoting it. They're using high-profile individuals, household names to go out and promote it with them. Every week there's a few dozen people sign up, and before long there's 100 people signed up, and then it gets on ASIC's radar, and then ASIC can consider, I think it would consider at least whether or not it can use those powers, but it will consider that very carefully, and ASIC has made that clear to us because it recognises the exercise of its powers can have consequences upon the whole scheme and its viability. So simply exercising its powers of itself can have an impact on the scheme. So as time progresses, more people are signing up to the scheme. So even if ASIC moves as quickly as it can, there is going to be that time lag where people have signed up to a managed investment scheme, a complicated one of the nature which you described how ASIC described it. And many of those people, and we heard their stories, and obviously I commend the Financial Services Council for being across the case. Many of them thought that they were simply getting a life residential tenancy, and they were doing exactly what they should be doing as a responsible person, as a retiree, and didn't even realise the swamp that they'd entered into until it all fell apart, by which time it was all too late. So there is this issue that ASIC, even with the relevant powers, arrives at the scene of the car wreck after the damage has been done to a certain extent. And some of these intervention powers might mean it arrives earlier than it did, but there's still this time lag. How do we address that time lag, or do you accept there is that issue?
So that's a really important point. So the issue should be minimising the time lag to the greatest extent possible. Our submission is it shouldn't be using the well-governed, well-capitalised part of the industry to underwrite the riskiness of other operators. Now, we can get on to discussions around mold hazard and issues like that later if you'd like to, but things like the DDO regime, which are new and were not in place at the time, require much more frequent reporting about product design and target markets and who the consumers and clients are in those products. So ASIC should be able to get there before the car crash occurs. And it has a product intervention power to say, you are mis-selling this product, or this product is poorly designed. We require changes of the product to prevent the car wreck from occurring. Now, I don't know when ASIC became aware of things like the Sterling case. I mean, with reporting things like the Melissa Caddick situation, that ASIC was notified of Melissa Caddick's going on. I mean, she wasn't in managed investment scheme, she was just straight out fraud. But there needs to be a proactive approach to identifying this sort of behaviour and these sorts of products when they're arising, to get in early to prevent the sort of consumer harm that we're talking about.
Can I ask, in that context, when insurers look at these products, who other than ASIC and the advisor that's selling it, and it's them on the line if it goes pear-shaped, insurance companies, it's getting harder to insure some products, but it might be a good thing if the onus is also on those the insurability liability, so that insurers will they will also be making judgments about the extent to which a product might fail some of those new powers or new tests, which therefore should also mean that we're weeding them out, and they therefore can be included in the scheme rather than automatically excluded. I still don't see if it's working in the way that you describe, surely that's an argument for bringing it in, because it is going to contain those liabilities and costs.
Well, the unfortunate situation is this legislation is being progressed almost immediately after the DDO regime has commenced. And so we've done an enormous amount of work to try to bring DDO to fruition and have it as an effective regime. What we're saying is this is the way that it should work now that it has commenced. I think it was October last year. whether or not we then need a compensation scheme to underwrite perceived gaps in the DDO regime, if they are there, is unfortunately it's still academic, because the examples of misconduct we're talking about were pre-DDO. And I feel like I'm sorry. Go ahead, Senator.
What would the liabilities be for your members, as far as you're aware, from the existing determinations of AFCA? You know, is that at the core of the issue that you're in terms of those costs?
We represent 4 different sectors in the financial services industry: financial advice licensees, which are caught within the compensation scheme arrangements, fund managers, operators who manage investment schemes, part of the superannuation industry, and life insurance companies. Now, as you'd be aware, the design of the scheme allows that if there were large failures and significant costs that exceeded any individual cap in a year, then all the sectors that we represent could be brought into the scheme to fund these black swan style events. So it's not true to say, as I think some are, that we are excluded from the regime, particularly as we do cover part of the advice industry as well. But I think what we're particularly nervous about is that I'm not aware of any unpaid determinations against any FSC member, regardless of the sectors that we represent. And so what you'd be effectively asking FSC members is, you are large, well-capitalised, reliable organisations, trade on your reputations, very valuable brands that have been built up over long periods of time. We would like you to underwrite the fly-by-nighters, the small schemes, often unregistered, high risk, potentially in breach, missold. We would like you to underwrite their risky conduct, and, you know, thank you very much. Now, we obviously, there's all sorts of arguments why that isn't appropriate market incentives to be in introducing to the financial services industry. But at the end of the day, I also just don't think it passes the fairness test. But
surely there's a role, you know, how do consumers know which ones are not, you know, I guess it's part of what you get paid for, which is part of why people don't realise how risky some of these products could be for their particular circumstances. And I fear very greatly that these kinds of situations will continue because there's not enough information in the marketplace that tells people the extent of the risk that they're taking in this context. You're not necessarily.
Yeah, I agree with you. The unfortunate truth of the matter is, you put out a lot of information and consumers' eyes glaze over because they can't digest the inherent complexity of financial services products. And so long product disclosure statements are often seen to be counterproductive. Short amounts of information are often high level, and consumers don't necessarily get all the information they need to make an informed decision. Now, in a lot of ways, I think the regulator formed the view that disclosure was ineffective, and that's why we see things like the DDO regime and product intervention powers that are much more proactive regulation as opposed to relying on disclosure and consumer engagement. And I'm going to be a little bit cheesy here, but at the end of the day, you need good quality financial advice. If you're making large investment decisions, such as the clients of Sterling did, you need to find a accredited, reliable financial advisor. Check with your professional association like the AFA and the FPA as to their, you know, they are quality. Check the ASIC advisor register to make sure that they don't have misconduct against them. And then you can rely on the advice they're giving. And I'm pretty sure that the incidence of those high quality advisors recommending things like those high risk products to people who can't afford them would be extremely low.
Oh, absolutely it would. But in that context, surely if you've got a managed investment scheme that's seeking to attract investment above a certain level, as Delosio raised, surely it should have independent financial advice attached to it.
Yeah, and this is the issue of wholesale retail investors, isn't it?
as a prerequisite for being able to get to be registered, so that someone is having a look at whether a PDS is likely to be misleading or deceptive for particular consumer cohorts. It could be individualised financial advice, or it could simply be who is going to take a look at those DDO type provisions and say the risk profile of this product does not match this particular cohort. ASIC does not, they simply don't want to do it. They don't want to do it. They say it's their job to do it.
Yeah, well, the FSC agrees with, I think the fundamental principle here is that the definition of a wholesale investor isn't fit for purpose in the current period. The current definition was based on something set 20 odd years ago, or at least hasn't been reviewed in 20 odd years. I think it may have been set even longer than that. Now, to us, the most glaring issue is the fact that the $2.5 million threshold for accountant certification is, I live in Sydney, and, the average house will get you most of the way to 2.5 million, unfortunately. And so most people are potentially treatable as a wholesale client, regardless of their financial sophistication if they're over that threshold. Now, for us, that we feel that's inappropriate. We're on the record supporting lifting at least that threshold to 5 million, but potentially even getting to an assessment of financial literacy, which is more subjective based on a person's knowledge and circumstances. I understand that's actually pretty consistent with the opposition's view of the world as well, that we need to revisit this definition. And I note the government has also included that in the draft terms of reference for the financial advice review. So I think that is something that needs to be looked at, because we don't want people with more modest savings being treated as sophisticated when they're clearly not.
Well, I don't think anyone who had big savings and, was a sophisticated investor would have put their money into a scheme like this.
Well, no, exactly. Yes, I agree.
So what obligation should your members have to helping drive these products out of the market?
Our members develop and design high quality investment products. If we're talking MISs in particular, high quality investment products. To be frank, not all of them will go up all the time. Financial markets both generate positive and negative returns over different time periods and different asset classes. We should be very careful not trying to regulate against investment losses, because I don't think anyone wants to end up in that sort of space. But it's our responsibility, and certainly as the FSC, as the association for that sector, to be trying to lead on best practice, both in terms of product design and also consumer engagement. And you would probably note that a lot of the sort of organisations that we're talking about that have failed at some time in the past were never members of the FSC. And we don't represent those small, high-risk players. We try to lead by example, and our hope is that more of those players that aspire to behave like our members, the better.
Senator Pratt, do you have any more questions? Senator McDonald has a quick question.
Thank you, Chair.
Senator McDonald, are you there?
Yes, thank you, Chair. Look, thank you for your evidence today. My approach is diametrically opposed to Senator Pratt's, where I'm concerned about proportional regulation. You've spoken a lot about regulation for, these well-resourced, appropriate, large financial instruments and bodies, but I'm worried about how do you ever become one if the proportionality of the regulation is I'm interested to understand how you could have this kind of very rigorous oversight of the big players who can well afford to go and put on another risk manager and, you know, a whole lot of additional staff to comply with your regulatory requirements. But how, if you're a smaller player, do you ever get access if that's ASIC's approach?
I appreciate where you're coming from, Senator. There are probably two ways to skin this one. One is we either design the scheme in such a way that there are next to no incidences of unpaid determinations. So the cost of the scheme to large and small players is negligible. So it doesn't become a dead weight on the industry, particularly advice industry. We know that there's been a large migration of advisors away from the large aligned institutions to set up small advice businesses. And it's certainly not our objective here to put additional cost on them to make them unable to compete in the marketplace. I think the ship sailed on that one, and no one's trying to turn back the clock. Our proposed way of achieving the right balance is Corps Act already requires advice businesses to have an adequate level of capital. We think the Act should specify what that is so that when there is a failure in the advice sector, there is capital to draw on to make consumers whole, rather than relying on a compensation scheme and relying on other advisors to bail out their counterparts. And the other one is addressing the fairly poor performance of the professional indemnity insurance market. We know that market is problematic, but what we would like to see is an obligation on advice businesses to have a minimum level of insurance coverage, and for them to upload their insurance coverage with ASIC so that ASIC can do spot checks and identify who the, for want of a better term, who the fly-by-night kind of operations are, so that you can claim on insurance before you have to go and tip your hand into other people's pockets.
Thank you. That's a really comprehensive answer. Thank you. Thanks, Chair.
Thank you, Senator McDonald. Mr. Davies, as our resident expert, as you're referred to by Mr. Briggs, could I give you some homework? Would you mind if I give you some homework? So King & Wood Mallisons made a submission to this inquiry, and they touched on many of the issues I think you touched upon. It would be helpful from my perspective in terms of bringing our report together if you could run through their proposals and just identify any differences perhaps between what they're suggesting and what the Financial Services Council is suggesting, and to what extent you agree with their recommendations. Is that possible?
Yep. No, that sounds an interesting task. Try.
That's an interesting adjective you use. So I'd like to, if I can thank all of our witnesses for appearing today. Mr. Briggs, you did refer to Sydney property prices. Can I just suggest to you, if you do want to make a new life for yourself in the wonderful state of Queensland, Senators McDonald and I would warmly welcome you. You would see you could buy a great deal in our wonderful state with what you pay for a house in Queensland. So feel free to contact me later if you're interested in making a move. It'll be the best thing.
Don't tempt me, Senator. I am also a surf lifesaver, so I would actually love to live up on the beaches up there.
Oh, it sounds like my suggestion has found a fertile field. Thank you all for appearing as witnesses today. I would ask that you now disconnect from the video conference, but you can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. Thank you very much. I now welcome representatives from the Law Council of Australia. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I would also like to advise you that any questions or notice should be sent to the Secretariat by close of business Wednesday, 3 February 2022. I invite the Law Council of Australia to make a brief opening statement should you wish to do so. And I should say I do note that we've certainly received a copy of your opening statement. I hope that's been circulated to all members of the committee. For the Hansard record, could I ask you to please state your name and the capacities in which you appear?
Thank you, Committee Chair. I'm Rebecca Maslin-Stage, appearing for the Law Council of Australia, and I'll leave it to my two colleagues to introduce themselves just after my comments. We would like to make this opening statement. We thank the committee for the opportunity to provide evidence today. Transparency and accountability across the financial, insurance and superannuation industries are essential to ensuring that Australians have trust and confidence in these sectors. To this end, the Law Council generally supports the intent of the bill. However, we consider that this intent would best be achieved by extending the existing Banking Executive Accountability Regime, or BEAR, set out in Part 2A of the Banking Act, to other types of entities which are regulated by the Australian Prudential Regulation Authority, or APRA, and to registrable superannuation entities, or RSEs, rather than by repealing that regime and introducing the different approach proposed in the Financial Accountability Regime. The Law Council's preferred approach would be more consistent with the recommendations made by the Royal Commission into Misconduct in the Banking, Superannuation and Financial Services industry. BEAR has had a significant impact in improving personal accountability in the financial services sphere since it was introduced in 2018, and extending the application of BEAR instead of introducing the new FAR regime would have the dual benefits of personal accountability and economic efficiency. Banks, which have already implemented BEAR to their ADI operations, could effectively use their established policies and systems developed under BEAR and roll them out to other regulated entities in their corporate groups. And other regulated entities which are not currently subject to BEAR could use those established blueprints developed during BEAR and with which legal and accounting advisors are already familiar. Both market participants and regulators could look to the BEAR precedents to minimise uncertainty and inefficiency. Those efficiency benefits are particularly important in the context of the current challenges for Australia, as with other countries, as we seek to maintain strong economies in the face of the ongoing impacts of the pandemic. And this would be consistent with the government's deregulatory agenda. If that primary submission is not accepted, the next best alternative would be to remove aspects of the proposals which would add cost and divert effort from growth and job creation, but without a proportionate regulatory benefit. And specifically, the most onerous new aspect of FAR is the individual accountability obligation to take reasonable steps in conducting the responsibilities of their position as an accountable person to comply with a long list of laws, including all the financial services laws and any regulations, other instruments, directions or other orders made under each of them. Regulated entities are already obliged to comply with those laws and regulations, not just to take reasonable steps to comply. They need complex and costly processes in place to do that. This new obligation will increase complexity and compliance costs by also requiring each accountable person to demonstrate that they took reasonable steps, leading to potential duplication and inefficiency without necessarily enhancing actual compliance outcomes. It also represents an increased barrier to new industry entrants. In the Law Council's view, we submit that should not be included in the bill. The bill also imposes new self-reporting regime in addition to the existing regimes, and in circumstances where the Corporations Act self-reporting regime has just been substantially extended. So introducing a new separate reporting regime with respect to the same conduct increases cost and complexity without a net regulatory benefit. Section 81 creates a civil penalty provision that's similar in effect to the existing accessory penalty provision, the Regulatory Power Standard Provisions Act. The Law Council considers it preferable to cross-refer to that rather than creating a new penalty, and suggests that if there is to be a new penalty of this type in the legislation, then consistent with the usual convention, the individual penalty amount should be 1/5 of the penalty which applies to a body corporate. And finally, with respect to the superannuation specific provisions of the bill, the Law Council would welcome greater acknowledgement of the pre-existing accountability obligations of those RSEs with a view to avoiding overlap, as well as reconsideration of the scope of the definition of significant related entities as it applies to superannuation entities. We thank you again for the opportunity to appear. I'll just leave it to my two colleagues to briefly introduce themselves, and then we're happy to answer any questions.
Thank you. Dr. Beattie.
Good afternoon, everyone. I'm Dr. Lisa Butler Beattie, and obviously representing the Law Council. Thank you.
Good afternoon. I'm Dr. Natasha Malt. I'm the Director of Policy of the Law Council's Policy Division.
Okay, welcome everyone. I might kick off with the questions, and I certainly understand the argument in terms of why aren't we, as the legislature, extending BEAR rather than introducing a new scheme. So I understand the basis for that submission. I'll certainly be putting that question to Treasury when they appear later today. I'd like to ask you about this question of the new individual accountability obligation. I guess I'm asking this question. I was a general counsel of a mining company, and absolutely fundamental to say the mining industry, obligations on individuals in terms of mine health and safety, being responsible, being a site senior executive, being responsible for everything on the site, and having to be across a whole raft of laws. And it seems to me, as you were speaking, I was thinking, well, isn't it the case if in terms of discharging your individual responsibility as an accountable person, you would be entitled to say, well, the organisation which I'm working for, the company I'm working for, my colleagues as a company, as a commercial entity, we have a whole range of checks and balances, governance systems, risk management systems to ensure that we are discharging our obligations. And so it's maybe less of a case of my having to replicate and duplicate everything that's already in existence on a personal basis, but rather it being reasonable for me to rely upon the systems and processes and procedures which the commercial entity has in place. Doesn't that in practice address the question? Let me put it another way, maybe to sharpen the question. What additional things do you think I would have to do as an accountable person because of this test that I shouldn't have to do?
Senate Chair, in the BEAR regime, for example, there's already the obligation to act with due skill, care and diligence. And we think that the system you've described is exactly appropriate to fulfil that duty. Of course, you need to get across the law that's relevant to you and make sure that as an organisation, the relevant requirements are being met. And you can rely on the systems of the broader institution to do that. The concern with how this new duty is expressed is that the individual, every individual who's an accountable person, is required to take reasonable steps with respect to the compliance with those laws. And so what they would have to do differently, and what we're seeing in practice even under BEAR, where an accountable person has accountability for something, is that person's very nervous that one day if something goes wrong, they'll be asked in a witness box or by a regulator, what are the steps you took to ensure that those laws were complied with? And what are the processes you undertook to make sure that that was done? And the concern is it's not sufficient to say, well, I know we've got a great legal department, a great compliance department, we've got processes, but because it's a very specific obligation to take reasonable steps with respect to the compliance with those laws, they would need to go through a process of understanding from this long list of laws what applies to my own area, what is being done in relation to them, and to document that and to keep up to date with it. So you've got the institution as a whole in hopefully an efficient manner dealing with all those obligations, but then you've got this separate overlay of every individual who's an accountable person, and there might be 15 of them, plus the board, having to have their own documented process as to how they have gone through and ensured that there's reasonable steps.
And when you were giving that answer, it took me back to some mining warden inquiries I've been involved in, where you've got the company that's represented, and also the senior site executive who's appearing, and they're both potentially liable. And those sort of questions are put to the senior site executive. Well, it's not enough just to say the procedure we have in place is X, Y, Z. Well, what did you do as the site senior executive to walk through the workplace and make sure everything was being done as it should have been done? You can't just sit in your office. You've got to be proactive in terms of making sure that the culture's right and that the things are actually being done in practice. Don't we need to do that to make sure that the things which need to be done, some of the horrendous issues that were uncovered through the Hayne Royal Commission, right, which occurred within companies which, to be frank, all had all the systems and processes you referred to in your answer, but they weren't actually being done in practice. Isn't there a policy argument that you actually need to sharpen the pencil and put that pressure on the accountable person to make sure they actually do take additional steps to make sure that things are being done and the culture in the organisation is such that some of those awful things that were uncovered in the Hayne Royal Commission don't occur?
Chair, we agree with what you said. That's very important in the Royal Commission. This was clearly a real issue. We see the duty of skill, care and diligence as the obligation that those accountable persons can only comply with if something's a real risk in their area, in their zone of responsibility. Of course, they have to be getting on top of it and making sure that the law is complied with. The way that this new duty is expressed, it requires them to take reasonable steps with respect to a long list of things, some of which will have a lot less relevance to them, and to have gone through a process of ensuring that they've tested whether they're applicable. So perhaps taking focus away from what the real risks are, where they should absolutely be putting their effort and making sure that the right culture is established. We say that the duty of skill, care and diligence requires that already.
So I'm still struggling. I'm sympathetic to the point you're making, but I'm trying to work out in practice what you think this accountable person is going to be spending their time doing in order to comply with the reasonable step test, which they wouldn't do in order to comply with their duty of diligence and discharging their obligations. I hear what you say about, okay, you've got to comply with this long list of acts, but by the same token, if they have a legal department, you expect that they'll be consulting with the legal department in relation to what those obligations are and be obtaining advice. And you do expect that your accountable person should be across the material aspects of the law. Do you really think it's going to make that much of a difference in terms of what the accountable person needs to do in practice?
I think based on our experience of how we have seen accountable persons act during their nervousness about the personal liability, which is a good thing at many levels, right? Because that's the objective of the regime. But what I would expect is we're going to get a whole lot of requests to provide legal advice on every one of those obligations to each of the accountable persons, and an assessment of to what extent do these apply to you, and encouraged to capture exactly what they are doing to comply with them and to refresh that every year. And that includes the wasted effort is really on the ones that shouldn't be their area of focus because they're not particularly relevant to that accountable person's role. And that is not a significant risk that accountable person should be focused on. But those less material in the context of their responsibility, obligations, going through process, seeking sign-offs, seeking advice on them, just to be able to basically tick the box that they have taken reasonable steps in relation to those.
Okay, so it's really the concern that this obligation is going to drive accountable persons to delve into the weeds, into the minutiae to such an extent that it's going to divert their attention and focus from the bigger issues, the more material issues, which they should really be focusing on. And to that extent, it could actually drive behaviour which is contrary to the legislative intent. Is that to sum it up?
That's correct. And in circumstances where a lot of these senior people in these roles have already got a lot of process that they need to comply with, as well as some really important responsibilities to make sure that we don't get the sorts of behaviour that occurred or outcomes that occurred that were the subject of the Royal Commission.
Okay. I wanted to ask a question about this this concept of the obligations in relation to liaising with the regulator in an open, I forget what it's open, constructive, and there's a third element to it, which cooperative manner. Yeah. And that makes sense, and presumably many of the companies and organisations which the members of the Law Council represent have been endeavouring to do that. What are the boundaries around that, or what should be the boundaries around that, and are they appropriately defined? So just to give you two examples, legal professional privilege in terms of whether or not that obligation would require a compromising of legal professional privilege, and secondly, the right against self-incrimination. What from the Law Council's perspective, is that defined well enough in the bill, or could that be made clearer?
Look, we'd love it to be made clearer that it doesn't require any waiver of privilege or anyone to self-incriminate. These have been concerns under BEAR as well, because that is an obligation under BEAR. In practice, I think it's been working tolerably well. I think there was a real apprehension early on that...
Sorry, what was the adjective you used? Tolerably?
Yes. I think it's been going, in practice, it has not had as much... it hasn't caused as much angst as probably the apprehension, because we haven't seen regulators saying this means you need to waive privilege or incriminate yourself. And so that seems to have been okay. I think there is a lot more apprehension with ASIC as a regulator that it would be good to have additional clarity in relation to that than with APRA, and it's probably because there has been an encouragement by ASIC of waiver of privilege, for example, in the context of the Royal Commission and related conduct. And so perhaps there is greater concern that ASIC may put pressure on people, but having said that, I don't, it's not yet in place, so who knows. For that reason, it would be very helpful if it was made express in the law that this does not, however, require waiver of privilege or self-incrimination.
Okay. All right, I'm going to open the call up to some of my colleagues. So Senator Pratt or Senator Chisholm, do you have some questions?
Thank you, Chair. I'm here. I'm having some trouble with my audio. Can you hear me?
I can hear you, Senator Pratt, loud and clear.
Thank you. Can I ask the Law Council, in terms of managed investment schemes being included in the scheme, and therefore existing AFCA determinations being paid out, what would the ramifications be of delaying bringing in scheme into the scheme in terms of access to to justice for those who have existing determinations of having been victims of misleading or deceptive conduct?
Senator, part of our submission is that there's a reference in the draft legislation to securities that we believe should extend to managed investment schemes. That would have the effect that where the conduct related to dealings in securities, that would include dealings in managed investment schemes, and that's on the basis. First, we wonder if it's a bit of an anomaly because there are two definitions of securities in the Corporations Act, and the interpretation provision applies the narrow one rather than the broader one. The broader one would include managed investment schemes, but the other is in practice. We see a lot of similarity between how managed investment schemes operate and companies, and don't think that investors necessarily appreciate the difference. I have heard some of the earlier evidence today, and I did wonder if there might be a
Sorry to interrupt. Senator Pratt, we're getting some feedback.
Yeah, no, I'm going to hang up, Lynn, because I can't hear you. So,
okay.
Thanks.
All right. So just while Senator Pratt does that, I've got just a few questions on superannuation, and if there's a concern in terms of overlap, is there, in relation to the bill that's being considered by this committee and the SIS Act in particular, and is that a matter which can be dealt with through regulatory clarification by the relevant regulators, or does that need amendment of the bill? What's the Law Council's view in that respect?
Thank you, Senator. Yes, we are of the view that there is significant regulatory overlap for superannuation funds and their directors and officers. If you have a look at the regulation for superannuation funds, there's extensive obligations on both RSE licensees and their directors under the SIS Act itself. And those obligations are personal obligations, both for trustees and for directors. Unusually, the SIS Act imposes obligations directly on directors, such that those obligations are owed directly to members. Added to that, of course, you have the Corporations Act and the director and officer obligations, as well as the AFSL obligations. And adding to that is FAR. And so that you can see that for many breaches, actually, one action or conduct could be a breach under each of those pieces of legislation, particularly where it relates to care, skill and diligence. It would be a breach under the SIS Act, it would be a breach under the AFSL obligations, and it would be a breach under the accountability obligations for FAR. So we see that there is significant regulatory overlap. It can lead to, of course, if you like, triple the penalty. Now, it doesn't always, because a regulator, and certainly from what I have seen, will, if you like choose which obligation to take action under. But it is, of course, possible. I guess the other point is, I guess, extending the point that was made earlier, that when there's regulatory overlap, there's also duplication in terms of processes and duplication in terms of cost for no, net regulatory gain in terms of the obligations and the accountability that applies to those funds and their directors and executive officers.
Okay, and just one other question I've got in the superannuation context before I come back to you, Senator Pratt, is, whoever came up with this term, I'd like to congratulate you. It's the most interesting term I've read in hundreds of pages in preparation for this committee. Transitional disapplication. So you're seeking transitional disapplication of the regime. And I'm going to try and use that phrase in the Senate and get it on Hansard. Can you explain to me the imperative for this committee to look at transitional disapplication?
Yes, it's in the superannuation fund merger space. So I'm sure you're well aware, and APRA no doubt can attest to the fact that there are a number of mergers that have occurred. There are a number of discussions on foot, and in fact, we are expecting huge consolidation in the industry over the next few years. You can imagine that during the transitional period, for a fund that is intending to merge and has decided that it is in the best financial interests of their members that they actually consolidate with another fund, the added regulatory burden of, if you like, complying with the FAR obligations adds probably a necessary cost, and that cost is ultimately borne by members. And so the suggestion is that there be a power to, if you like, exempt certain funds who have firm plans for merger or successor fund transfer. And the suggestion is that that could be approved by APRA, because APRA would be well aware of the discussions of those funds and how far they are progressed, and would have a view on whether the merger is potentially in the best financial interests of members.
Okay, well, that makes sense to me. Senator Pratt, you with us?
Yes, thank you very much. How would you go
Over
about
to you.
Yes, I am here. Thank you, Chair. Can you hear me?
Yes, I can.
Can you hear me? Great. How would you go about amending the legislation to include managed investment schemes? And I also want to ask you if you've got any background on the DH Flinders case. And also, there's a bunch of technicalities. If you bring managed investment schemes in, the compensation scheme of last resort is supposed to pay in that context for existing determinations. And in this case, there are some related to managed investment schemes, but the rules currently say you can't apply for a new determination if you've already had one. But in this case, the rules for that determination would be different because previous determinations have been paid out from insurance only, whereas a proper compensation scheme of last resort would look at those underlying excesses, as well as the DH Flinders case whereby, and I don't know if anyone in the Law Council is familiar with it, the AFCA's rules have since been amended so this can't arise, but the financial advice company won the case in court to say they're not liable for these determinations with AFCA because they hadn't approved their salespeople and their advisors for sale of this product. This is despite the fact that they were accepting fees for that product, and they were to the tune of about $20,000. And nevertheless, it was determined that the company involved did not have to answer to, that AFCA didn't have jurisdiction. How could we go about fixing that that particular issue, or do you think perhaps it should have been appealed to the High Court?
Senator, I'm afraid I'm not familiar with the detail of that case. I can say in our submission we have suggested that using the other definition of securities in the Corporations Act, which would pick up managed investment schemes, would extend the relevant provision to cover managed investment schemes in that context. As I have heard some of the evidence today, I heard some of an earlier session. It struck me that some of the discussion around managed investment schemes may be assuming a far broader scope than would apply just by virtue of that fix, and that would require more fundamental changes, I suspect.
Sorry, can you unpack that for me a little? I'm not quite sure what you mean in terms of the extent to which amending the bill according to your scope fixes or doesn't fix those issues.
So our proposed amendment is where the last resort scheme would apply if there's been an AFCA award, if it's within a certain category. If it relates to a dealing in securities at the moment, that excludes managed investment schemes. But if it extended by virtue of using the other definition of securities to managed investment schemes, then a financial services body undertaking a securities dealing or a dealing in managed investment scheme interests for a retail client would be covered. I thought that some of the discussion on this was not relating to the form of dealings that is covered there, which excludes issue of products, because it seemed that perhaps some of it related to issues of managed investment scheme interests. And if those were to be covered, I suspect that more detailed changes might be required.
Okay, could you have a look in particular at the DH Linda's case? I don't really know which category of those two potential solutions it falls into.
That's fine, Senator. We're happy to take that one on notice.
Thank you. And in terms of the time limits that AFCA's put on in place, does the Law Council have any view, in bringing managed investment schemes in? There's a sense that, do you have any sense of what the unpaid determinations AFCA currently has for products that aren't managed investment schemes?
Senator, no, we don't have data on that, unfortunately.
Yeah. I'll find that out from the department. I'm just trying to work out what are the ramifications and how to go logically about in bringing management investment schemes in. ASIC and others said for a long time to victims of things like the Sterling financial collapse, they said, please make an application to AFCA. And some people have done just that, but now, whereas others did not, but whether their claims would be met under this new scheme depends on how we go about amending it. And I'm just not sure if there are other consumers in different categories of products that are affected by the same kinds of issues. Do you see that as a substantive issue in terms of the access to justice for problems in financial services prior to this scheme coming in place in terms of those legacy issues?
Certainly, we've seen situations where there have been collapses, and it's been very unfortunate that there has not been compensation available for retail investors who had suffered. Going beyond that into specific data, I think we would need information that we just don't have to give a more educated view on it.
Okay. I guess I am keen to unpack the idea that many people have been told that this was coming and now they're being excluded at the 11th hour. And, aside from a technical legal argument, it's around effective administration and access to justice for these victims who have been led to believe by politicians and ASIC that such a scheme would be forthcoming.
Senator, what we could do is check with our relevant committee whether they are aware of cases in the cusp or transition like that, and if so, could provide with our response in relation to the DH Linda's case, that information.
There's certainly a bunch in the Sterling financial collapse that are caught up in those various technicalities. So I would be very grateful if you're able to take a look at those issues. And there is some Hansard from the inquiry into the Sterling collapse that's also been done by this committee. Thank you.
Oh, thank you. Sorry, Senator Pratt, have you finished your questions now?
I just wanted to ask, you've argued that ASIC should not be required to cancel the licence of a licensee who has had determinations paid out under the CSLR. Why shouldn't ASIC cancel the licence? I've certainly seen, I guess, a lack of action coming from ASIC, where you've had, for example, directors associated with things like the Sterling collapse who've had previous collapses associated with them. And ASIC's pretty much said, well, people should fight to live another day and be able to put new products into the market. But in this case, it's seen yet another cohort of people who couldn't afford to lose money. What's behind you saying that they shouldn't have their licence cancelled?
Senator, we're very comfortable with ASIC having the power, as it already does, in various provisions to cancel licences of a financial services representative who is not meeting their expectations. Our concern in the draft legislation is it's just too blunt an instrument. It actually requires ASIC on a mandatory basis to cancel the AFSL without an ability to take into account the specific circumstances. So, of course, we'd be concerned if the party was able to just continue detrimentally affecting consumers. However, we just say the facts should all be taken into account at the time if that's the appropriate response, well and good, because there will, of course, be a number of other clients of that organisation as well who may be detrimentally affected depending on the circumstances if that licence is cancelled and potentially... Sure.
It should perhaps be that ASIC have an obligation to consider cancelling the licence because, you know, in many cases I've seen that, yes, they do have these powers, but they don't seem to want to use them.
That would be preferable to the current position in the draft where ASIC must cancel.
Thank you. And do you have a view about how the scheme pays out, how it operates to pay out determinations made against firms that are still operating? And, you know, I guess that's linked to this issue as well. How can it be last resort if the scheme is still operating?
It's a good question. I think we probably just need our relevant committee again to give us any practical experiences in relation to that, Senator. So if we could include that in what we take on notice.
Thank you. That's helpful, and thank you to the Chair and thank you to the Law Council for your very useful evidence.
Thank you, Senator Pratt. Just two last points from me. Section 40, the Register of Accountable Persons. So the Law Council is concerned that if there is the publication of a register with the names of accountable persons, that could lead to some issues for those individuals. I guess I would have thought that some of the accountable persons are going to be of such a seniority that their names are on companies' websites or they're in remuneration reports as key management personnel. Aren't their names going to be out there anyway? Isn't it? Aren't there going to be quicker ways to find their names than searching through the Register of Accountable Persons?
Chair, yes, our practical concern with this is that it could be misunderstood by upset consumers who are very upset with an institution, you know, in circumstances where that might be completely valid, exactly how accountabilities work, and they could end up targeting a person on the basis of perhaps not fully understanding who is accountable. It's included in our submission as a concern for that reason. We completely accept that anyone on the board or anyone in senior management may be subject to being targeted, and perhaps on a broad basis that's not as much concern. But you can have situations where a person who's not really the person who had accountability could easily be misunderstood, who had, if it was just something published on a website. That's our concern.
So what's the contrary argument in favour of publication? Obviously, it's necessary for the regulators to know, for APRA and ASIC to know. That's clear, but they will obviously know. They'll have their own register. Are there any reasons why bona fide as to why other entities dealing with the company or the organisation need to know who the accountable person is? So taking it out of the realm of the disgruntled customer who misconceives how the organisation works and then seeks to target someone, and that's a legitimate concern. I note that, but by the same token, aren't there reasonable circumstances where a third party other than the regulator really does need to know who the accountable person is, and they might want to make a search?
It's hard to see that with a sophisticated counterparty. I mean, they're going to deal with their counterparties at the organisation, and I think that these days, again, in the improved BEAR environment, the major financial institutions at least are pretty clear about who you should contact if you've got complaints, and they've got senior managers who have got a customer focus, so that's relatively clear. I would have thought if there was a public interest type argument, it's more just about transparency generally and giving confidence to consumers that there is transparency and accountability. We'd say it's outweighed by the risk of personal targeting of individuals, but that to me would be the strongest counter argument.
Okay. Now, can I ask you to take something on notice?
Sure.
Don't say yes. Don't say yes until I tell you what it is. So reserve your position. But King & Wood Mallison's made a submission where they outlined about 5 points, which I found very useful. Ms. Nicholson, Mr. Bednall and Ms. Williams. It would be useful. I think they touch upon many of the issues that the Law Council of Australia has raised, which is unsurprising, but it would be useful from my perspective, just in terms of collating all the concerns. And I ask the Financial Services Council to do the same thing. If the Law Council could go through those points and just cross-refer to how it's covered in your submission, or if it isn't, just whether or not you share the particular concern or are willing to support the particular recommendation. Is that possible?
Yes, that's fine, Chair. It doesn't sound too onerous. Very happy to take that one on notice.
Okay, that's very helpful for me. Thank you, or for the committee, I should say. So thank you very much for appearing as witnesses today. I would ask that you now disconnect from the video conference, and you can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. Thank you very much.
Thank you.
Thank you.
I now welcome representatives from the Australian Securities and Investments Commission, ASIC, and the Australian Prudential Regulation Authority, APRA. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions on notice should be sent to the Secretariat by close of business Wednesday, 3 February 2022. I invite you to make a brief opening statement should you wish to do so, or should each of APRA and ASIC wish to do so. And for the Hansard, could you please each state your name and the capacity in which you appear? So if we could start with perhaps with ASIC.
So if I might, apologies, Chair, would sort of built on our opening statement, so that kind of one follows the other. If it's okay, if APRA went first.
It is more than okay, Mr. Carmody. I'm impressed by your preparation. So over to you first.
Thank you very much. I might just do a quick round of introductions and then I'll start with our opening statement. So I'm Sean Carmody, Executive Director for APRA in our cross-industry division, and I'll hand over to Raman to introduce herself.
I'm Raman Sandhu. I'm General Manager, Accountability Regime, APRA.
And over to ASIC to introduce himself.
Thanks, Sean. I'm Greg Kirk. I'm Executive Director of the Strategy Group.
I'm Kim Devant, the Acting Senior Executive Leader in the Governance team.
Thank you. Well, I'll briefly open. APRA welcomes the opportunity to appear before this committee to assist in the inquiry into the FAR bill. APRA has also made a submission to the inquiry setting out our experience with the Banking Executive Accountability Regime, so the BEAR, and also the preparatory work undertaken by both ASIC and APRA in anticipation of the introduction of the new FAR legislation. As the committee would be well aware, the BEAR established certain obligations for authorised deposit-taking institutions, so ADIs as we call them, and their senior executives and directors. The BEAR commenced on the 1st of July 2018 for large ADIs and the 1st of July 2019 for all other ADIs. It was designed to improve risk and governance cultures of ADIs by imposing a strengthened responsibility and accountability framework for those institutions, their directors, and the most senior and influential executives, so-called accountable persons. We found BEAR to be a key regulatory lever for APRA to drive action by ADIs through the identified accountable persons, and thereby to transform governance, risk culture, remuneration, and accountability outcomes across the banking industry. APRA uses the BEAR in its day-to-day supervision to influence preventative or remedial action to be taken by ADIs and accountable persons well before there's a threat to the ADI's financial viability. APRA has seen positive outcomes from the BEAR and therefore supports the broadening of the regime to all APRA-regulated entities. This will extend the coverage of an accountability regime aimed at improving risk and governance cultures from 143 ADIs currently under the BEAR to around 435 entities under the FAR. And also, as the committee is also aware, the FAR is to be jointly administered by APRA and ASIC. So that's a change from the BEAR. And this will require, importantly, coordination and cooperation to ensure that the FAR's objectives are achieved efficiently without imposing unnecessary regulatory burden. And to this end, APRA and ASIC have been working together closely to develop the joint administration framework and infrastructure in preparation for the anticipated implementation of the FAR. These efforts build on activities already being undertaken across areas where the two regulators have been working together more closely and on the memorandum of understanding we have in place between the two regulators. And one of the key pieces of preparatory work underway is the development of a public joint administration agreement, which sets out the high-level principles of cooperation and arrangements for the joint administration. This agreement will cover areas such as oversight of the arrangements, exercising powers, industry communication, information sharing, and enforcement and investigations. So with those opening remarks, we're happy to take questions, but I might hand over to Greg first for the ASIC statement, if that suits.
Thank you, Sean, and good afternoon, Chair, and to the members of the committee. Because we're very much on the same page as APRA here, I'll keep my remarks very short. We understand that this draft legislation to establish the financial accountability regime is designed to improve risk and governance cultures of entities in banking, insurance, and superannuation. We support the objectives of the regime, and more generally, we support greater executive accountability for poor conduct in the firms that we regulate. We agree with APRA's opening remarks just now about the way in which our two organisations have been working closely together. In addition to the development of the Joint Administration Agreement, we're also working together to prepare to engage with industry and ensure our systems are ready for the commencement of these laws should they pass the Parliament. We're looking forward to continuing to work with APRA to implement the new requirements. Finally, just in respect of the legislation to establish a compensation scheme of last resort, I note that ASIC's role under the proposed scheme is twofold, involving the collection of levies from industry and oversight of the scheme. Questions about the CSLR's design and policy, including scope and funding, are matters for the government and not ones for ASIC. But with that, we're happy to take the questions from the committee.
Okay, thank you very much, Mr. Kirk and Mr. Carmody, for those introductory statements. Can I ask you, in relation to the Joint Administration Agreement, one of the themes that's coming through the evidence from various stakeholders is they want it to be clear who's responsible for what as this legislative regime is rolled out, assuming it's passed. And you referred to the Joint Administration Agreement containing high-level principles. Will it also be made clear whether or not through that administration agreement or through some other guidance or information available to industry from a practical level, who's responsible for what, and how the stakeholders who are going to be subject to regulation are to engage with each of the regulators in which situation, etc.
Well, I might jump in first, and then others can pipe up. So I think getting to those practical questions, one of the things that we are intending to do is to provide some sort of operational and administrative guidance to industry. So we're looking to release some information sheets on those practical operational matters. As a matter of process, the way we're envisaging that, assuming that the FAR is passed in something like the form of the current legislation, whereby the transition to the FAR would occur for banks, so for ADIs first, and then subsequently for the other industries. Then on that basis, we'd be providing an information on transition for ADIs, so that transition on a practical basis is going to be much less significant for them, because so much of the new regime will be familiar to them because of their experience with BEAR. But there are some differences in terms of some, the fact that it's jointly administered and so on. So we'll be providing practical information on that transition, and then there'll be a separate sort of cross-industry information sheet that covers all industries, in particular for insurance and superannuation who aren't already familiar with that. So that's important. A couple of other things just to note is we're very conscious that there's a certain amount of information that industry has to provide as part of complying with the FAR. There's information about who the accountable persons are. If you're one of the enhanced entities, there's information about more detail on accountability statements and maps and so on. Also about changes, information about breaches potentially and so on. And we clearly don't want to have a regime where there's having to be sort of duplicate reporting to multiple agencies. So we're making it very clear that there's a single portal for provision of all that information, which will be a recently implemented system called APRA Connect that we've implemented last year for collection of a wide range of data, not just for FAR. So that'll be the single portal. So we're going to make that very clear. And then we've got processes behind that system that automatically have that information disseminated through to ASIC as well, so that we're both receiving the same information at essentially the same time. So there's some of the things that we've been working through. So some of that detail isn't in those high-level joint administration agreement. That's more in those information materials we're providing. But we've been really trying to design a process whereby that joint administration is as practical as possible. And then probably the last thing I'd say before seeing if anyone else wants to add things is, case by case, when specific matters arise, there may need to be discussions between the two agencies as to, who would take the lead, what's most relevant. But the sort of broad thrust would be prudential matters would still sit with APRA, and conduct kind of related matters would still sit with ASIC. But there can always be matters that will blur and sit between the two. And so we're making it clear that there'll be appropriate communication and coordination so that we don't make those sort of overlapping areas unduly. Anything anyone else could add? But I think that covers the thrust of it.
Just to add,
Go ahead.
sorry, Greg. Just to add that to support that joint administration agreement, APRA and ASIC, we are working on end-to-end operational frameworks and processes. And as Greg mentioned and Sean mentioned, we are building systems and processes. There will be clearly defined roles and responsibilities, which will be supported by processes and procedures, and also will be providing support and training to our supervisors so that we are undertaking a consistent approach.
Mr. Kirk?
I would only add that I agree with everything that we've been said, and I think in the background would say that both the members of APRA and the commissioners at ASIC are absolutely committed to making it work as smoothly and efficiently as possible and effectively as possible, and that under that umbrella of the real support from the senior members of both organisations, there has been an enormous amount of interaction already, and we continue to very regularly engaged to just make sure that the regime works effectively and efficiently for all.
Okay. One of the concerns that was raised by the Law Council of Australia is if the bills are passed, you could have situations where an accountable person, through a single act or inaction, breaches different laws under different regimes. So to put it another way, there's duplication of obligations that apply, say, under the SIS Act, being duplicated with things under FAR, duplicated under conditions on the AFSL. So which one applies in which circumstance? Do they all apply? How do you deal with that issue where you've got perhaps necessarily some overlapping obligations, so that people, I guess, first know what is the relevant obligation they need to comply with, and second, if there is a breach, that the action taken by the regulator is proportionate and they're not penalised for the same breach or conduct more than once.
I might make a general comment and then hand over to you, Greg, on the more specific nature of the breach. I mean, I think the general issue of whether certain actions or events or incidents can trigger things under multiple legislation, in a sense, is something that we live with today. If you've seen some of the issues with some of the big anti-money laundering breaches and so on, there can be issues of the AML Acts, the Corps Act, so these sorts of things are rarely very cleanly isolated to a single matter, and so there's always a process of saying, well, what's the most appropriate way of pursuing this matter? But Greg, you might want to sort of say something more specifically about how we sort of think through the practical matter of dealing with breaches under FAR.
Yeah, and I think there's, I guess, two types of breaches potentially. One is breach of the requirements in FAR to have internal accountability arrangements, to have designated responsible persons, and to have accountability maps. So that's one type of breach, and they're I guess the newest ones, although again not for the bare entities. And at a second level, there's the obligations within FAR to take reasonable, the various conduct style obligations, but which are mostly within FAR, which are mostly systems based. They're requirement to have systems in place, requirements to take reasonable steps. They're broad requirements. And then there's the kind of underlying conduct rules that might be breached. And it may be, the poor conduct might relate to bad financial advice or whatever. That individual piece of poor conduct, that may raise a FAR issue, or it might not. It might be that they have all the FAR measures in place and they're compliant with them, and this is just an isolated piece of misconduct. And it's not that there's overlap or any sort of complete overlap. It's that the regimes are looking at different things. So the existing conduct laws that we administer are really around the conduct involved, whereas the FAR regime is to have clarity about accountability in the background for conduct, so that people know who's responsible. Most particularly, people know that within the organisation who's responsible and accountable for particular conduct. They have measures in place, including the holdback of remuneration and stuff, to manage that within organisations. But it also means if we're looking at a piece of misconduct, which is about the traditional misconduct, because they have those internal arrangements in place, they have responsible people. It facilitates our examination of why that misconduct occurred. That again, that doesn't necessarily mean there will have been a breach of FAR, but it means we'll be quickly able to identify who in the organisation is responsible for this area of activity and who we need to speak to about it.
Okay, thank you, Mr. Kirk. I'm going to put to you a quote from the Law Council of Australia, and I am aware that I don't want to delve into policy questions, and I'm not seeking you to comment on policy. Sorry, Senator Pratt, you? Yeah, so I'm not looking for you to delve into policy areas where you feel uncomfortable to do so, but I guess I'm more interested in terms of practically how you would look at this issue as a regulator, and whether or not you'll be issuing any guidance to provide some assistance to accountable persons. So I'll give you the quote from the Law Council of Australia opening statement. I quote, "The most onerous new aspect of FAR is the individual accountability obligation to take reasonable steps in conducting the responsibilities of their position as an accountable person to comply with a long list of laws, including all the financial services laws and any regulations, other instruments, directions, or other orders made under each of them. Regulated entities are already obliged to comply with those laws and regulations, not just to take reasonable steps to comply. They need complex and costly processes in place to do that. This new obligation will increase complexity and compliance costs by also requiring each accountable person to demonstrate that they took reasonable steps, leading to potential duplication and inefficiency without necessarily enhancing actual compliance outcomes." End quote. And just to give you a bit more context, when I sought to drill down into what the actual concern was, there was a concern that the accountable person may be dragged down into the minutiae or into the weeds, into a box ticking exercise, and as such be diverted from paying due attention to the more material issues which they need to pay attention to as an accountable person. I'm just wondering if each of you, first perhaps APRA, then ASIC, could give your views as to how you view that obligation from a regulatory aspect.
So I was watching some of that session as well, so I heard some of the conversation, and I suppose my reflection there would be, you Chair, talked through a scenario about how a senior executive or an accountable person or a board member might go about getting comfortable with their accountability. Saying, well, what are the systems and controls and processes the organisation has in place, and maybe tests and challenges from time to time about do we have things in place, how are they being checked, how they're being reviewed. And I must say that in terms of our experience with the oversight of BEAR, that's exactly the sort of thing that we look for and we expect and we're actually seeing in practice. And there was a distinction made in the discussion between the language in BEAR, which talks about the due skill, diligence, and so on, versus the reasonable steps. And it wasn't clear to me what the clear blue water between the two was in a lot of ways. So if I was looking at this from a regulatory and supervisory perspective, if someone as a senior level had gone through, challenge processes and it said, yes, we've got these processes in place, but hadn't gone through a sort of very minute box checking exercise, I'd struggle to see how someone who was just doing the box checking that I as a supervisor would find that a reasonable step, and the more substantive test and challenge wasn't. So I found your description of what you would see to be the more compelling one in that conversation. So that was my reaction to that piece of line of questioning.
Okay, thank you, Mr. Carmody. Mr. Kirk.
Thanks, Senator Scarron. Unfortunately, I haven't had the benefit of hearing this conversation.
You can watch it tonight over a beer or a glass
Indeed.
of wine. It was thrilling stuff.
But I do think the pivotal words are reasonable. Well, the pivotal word is reasonable, and it's reasonable in the circumstances. If you have these responsibilities in a very large entity, there's not an expectation you're down on the shop floor with looking over the shoulder of everyone engaged in the area of activity you're responsible for. That's clearly not possible. That's not a reasonable expectation. It's really about what are the reasonable steps in terms of managing a process from the vantage point, from your vantage point and your position. What are the reasonable steps that would be necessary to manage that activity? And I would, again, I think the regime will sound first in the measures that entities having identified who's responsible for these things and having remuneration holdback where there's big discretionary remuneration involved. They are the front line in terms of making sure people do their jobs properly, and you would think they would expect to know less. You know, if I'm in a very large institution or a large institution paying someone to take responsibility and to be responsible for an area, and I'm paying them appropriately because of that level of responsibility, I would expect they'd take reasonable steps given the resources that I have given to them. And if they think the resources are inadequate, maybe one of their reasonable steps is to say up the line, I think we need to put more resources into this. But if you know the board says no, then I think the person still fulfilled the responsibility that they've done what was reasonable in their position, the level of power they have in the organisation.
Yeah. Okay.
So yeah, I just think that the reasonableness there is the pivotal thing. And I think that's how we will administer the regime.
Mr. Carmody?
Yeah, I might just add one other point. I think you did also ask about whether there'd be guidance. I referred to the sorts of guidance we're going to put out earlier, which was more on those sort of operational administrative aspects. And I think an observation I'd make, an important aspect about this regime and how we're thinking about a lot of our prudential standards is the nature of proportionality, that, you know, what makes sense for a very large organisation may not make sense for the smallest organisations. And I think one of the dangers about trying to be too detailed and prescriptive about how to interpret these terms is that you risk having something that tries to be one size fits all, which just doesn't make sense for the breadth of organisations. So I think, you know, that on that basis, you know, there's actual risks in trying to provide detailed guidance on, you know, what reasonable steps should be. And as Greg said, it should be up to each individual organisation to determine, well, you know, we're ultimately responsible for these issues in our organisation. What do we think ourselves, to form the view themselves as to what they think the reasonable steps would be? And that will necessarily vary industry by industry, entity by entity, size, complexity, and so on.
Okay. Mr. Carmody, my final question before I share the call with my colleagues is in relation to remuneration and the prudential standards around remuneration. A number of stakeholders have raised the issue that the APRA's current prudential standard around remuneration would be inconsistent with what's proposed under FAR. And in particular, I can't remember which is which, but one is forward-looking and the other's backward-looking. And there needs to be an adjustment in that regard. Is that on APRA's radar?
Look, I think, Chair, that thank you for the question. I think possibly a bit of reflection of some of the older versions of that standard. We've been working very hard to ensure that the work we're doing on that prudential standard is as compatible as possible with the FAR legislation, and so that we think that the version that was, you know, recently finalised late last year actually has very good alignment with the wording of FAR. The language won't be exactly the same, but for example, that language that was referred to about forward-looking was a feature of an early draft of that prudential standard. It's since been removed following feedback and consultation. So I suspect to some extent some of those concerns may not be there in our view in the final standard. In terms of review processes, we've got no short-term plans to review that prudential standard. It will be reviewed within a 4-year period. We have a sort of regular cycle of reviews for all of our prudential standards. But as it stands, we feel that, you know, there's actually, you know, unless there's significant changes to the legislation for FAR prior to passage, we think it's actually very closely aligned. Probably another point just to pick up there, which I think one of the other witnesses commented on might have been the ABA, is that importantly, FAR actually sets a minimum baseline, and there are aspects of CPS 511 that quite deliberately go further than FAR in certain respects. So, for example, it talks about overall remuneration arrangements across the whole organisation, not just for accountable people. It can go down to, for example, very significant risk takers in the organisation who might be taking a lot of risk but might not be at the level of an accountable person, maybe sort of traders who are large risk takers, that sort of thing. So it's got issues there. It also talks about things like having material weight given to non-financial measures for outcomes as well. So some of those sorts of things quite deliberately designed to align to sort of international best practice in this space. And also it's got some more onerous arrangements in place for the most significant financial institutions as well. So there are some areas where at that larger extent it actually goes further on things like deferral, whereas the FAR regime itself is really sort of quite narrowly focused on a minimum standard for deferral. So by design, CPS 511 goes further, but where there is common ground, we think it's actually quite consistent already.
Okay, Mr. Cumming, could I just ask you to take on notice, perhaps, if you could just do another check or get someone else to do another check on that, given the concern was raised by a number of stakeholders, and if perhaps you could provide us an answer to that question. The question on notice being, in APRA's view, is the relevant prudential standard consistent with FAR? And I expect your answer is going to canvass that, but I'd just appreciate APRA just taking another look at that and just check whether or not there is that consistency from your perspective.
Very happy to take that one.
Okay, thank you. Senator Pratt.
Thank you, Chair. Can I ask, please, if you can explain the issues around the potential expansion of the scheme, for example, including managed investment schemes? The Law Council and many other submitters have argued there's no real reason for excluding them.
Might point this one to ASIC, since we're not really involved in the compensation scheme.
Thank you, Senator. I think that really goes to the design of the scheme, and certainly the scheme as proposed covers 4 areas of activity: financial advice, securities dealing, credit issuance, and credit intermediation. As proposed, it doesn't cover managed investment schemes and losses associated with them, or unpaid claims before APRA associated with that area of activity. But that's essentially part of the design of the scheme as put forward by the government, and really that's a policy question for the government and in the end the Parliament, whether to include.
Okay, so what would need to happen in order to change the bill to accommodate managed investment schemes from ASIC's point of view?
I think that's largely a drafting question. There's probably a number of different ways it could be done, but that would have to be one of the specified areas.
Well, if I ask you to take on notice how to amend it with that as a specified area, but also to consider insurance and other products, but I've been involved in the Sterling inquiry, and people have been told by ASIC and politicians to make an application to the scheme only to be excluded at the 11th hour. So I want to ask what technically needs to happen to amend it in order to achieve their inclusion.
Senator, I guess we could proffer a suggestion about that, but I think the better entity to ask about that already is Treasury, who have been involved in the designing and the drafting of the legislation.
You're an independent organisation and understand the issues well. Treasury are under the guidance of their Minister. Yes, I could still ask them how to do it, but I'm very keen to hear ASIC's view.
Okay, we're happy to seek to provide something to you, but accepting that we're not parliamentary drafters.
No, that's fine.
So
But
you know,
if
it will
you can
be
give me an overview of what needs to
relatively.
happen
We can
technically at your
identify
end.
the section where the sectors of activity that are covered by the scheme set out.
Can I ask if you've got any breakdown, please, of ASIC's enforcement operations against managed investment scheme operators and financial advisors? How much effort does ASIC apply to the regulation of managed investment schemes?
I certainly don't have that with me now, but we could provide something to you on those.
Are you able to give me, sorry, a general overview of that and the extent to which you think the new provisions, CDO provisions, will prevent collapses, or at the very, well, I think if you don't target these schemes at people who shouldn't be in them with that level of risk, some of them might not exist at all, and it might bring down the level of difficulty in this sector. What's your overview of investors' understanding of risk currently?
Senator, I think it's very difficult to sort of sum up investors as a whole and their level of understanding about risk. I think we would acknowledge that that's one of the difficult things.
Let's not tackle it from the point of view of investors as a whole. Let's try and tackle it from the point of view of retail investors who put all their eggs in one basket, that is a managed investment scheme.
Well, again, even across retail investors, it's hard to make generalizations, but certainly we would counsel retail investors against putting all of their investments in one managed investment scheme, because we're very much, and it's right across all of the material we produce through MoneySmart, strongly advocate the need for diversification of investment if you're going to manage risk at all. If you rely on one investment for everything, it's inherently very risky, and even more so if that one thing is in itself a high risk investment.
One of the issues, Mr. Kirk, if you'll indulge me, Senator Pratt, with Sterling First, was that the investors didn't perceive themselves as investors. They thought they were actually entering into residential tenancies for life, which were guaranteed, in inverted commas, and they tragically found out that their right to occupancy was in fact dependent upon a money stream flowing from the relevant trusts, and it was represented to them that there were no non-recourse provisions, etc. And unfortunately, they just it wasn't a question of them. Well, they just didn't understand or were misled, more particularly with respect to how the scheme worked.
Yes, and certainly, I think ASIC's chair before this inquiry was very quick to acknowledge the complexity and high risk nature of that investment, and the difficulties for those consumers in untangling exactly what they were taking on.
But in that context, it's more than that, because AFCA clearly found deceptive and misleading conduct from the proponents of the scheme. How does ASIC have a meaningful role in intervening or preventing deceptive and misleading conduct from proponents of managed investment schemes?
Senator, yes, we do, and we can take enforcement action in relation to it. And again, as you've probably heard it in much more detail than I have, as having been on that inquiry. But the difficulty in recourse for the affected consumers is that, one, it's necessary to prove some sort of misconduct or failure of legal duty to get some sort of entitlement to compensation. And AVCA is there to facilitate consumers getting access to decisions about that. But if at the end of the day, the entity doesn't have the funds to pay those decisions, then that's problematic for those consumers. That's, again, as Senator Scarr was saying, the whole situation certainly was a tragedy for the consumers involved.
But so what's ASIC's role in preventing that from happening?
Well, ASIC has a role in I think we're possibly getting well away from the legislation that we're here to discuss. But
well, it's not
ASIC
really
obviously has a
away from
role
the
in enforcing the law, which prohibits misleading and deceptive conduct.
Well, it's not away from what we're considering, because if you are effective in preventing it, then the number of determinations that make a call on the funds through the CSLR should managed investment schemes, as ASIC even encourage people to make applications to AFCA about it, might not be as great. Do you accept that?
I think part of the problem is the idea that we can prevent it, and when most of the tools we have are not preventative, they're after the event tools to take action because the law has been breached.
How many consumer complaints do you have about managed investment schemes?
Senator, I can
take
that note and we can provide an answer.
I beg your pardon?
I'll have to take that on notice, but happy to provide an answer.
Okay. The Ramsay review highlighted the need for concurrent reforms to improve the safety of financial products and services, reducing the call on the scheme that we've got before us in this legislation. Is the intent of the product intervention power and design and distribution obligation reforms to improve the safety of financial products and reduce some of the chance of these failures?
Yes, certainly they have a role in reducing the design and distribution obligations in reducing the potential for losses, because it compels the issuers of the products to consider their suitability and to identify the right target market for those products, and to then market them towards that target market rather than market them at large against.
And what will ASIC do to oversight that? Because I'm concerned that the victims in these cases have had findings of misleading and deceptive conduct, and I find it difficult to see how an obligation not to mislead a consumer is going to be any stronger if they have already been found to be misleading, unless the obligation doesn't just rest with the proponents of the scheme, but also in ASIC's oversight to test the products and ensure they're properly tested. So can I ask how ASIC will apply those reforms in relation to managed investment schemes?
We'll certainly be looking, and this doesn't just apply to managed investment scheme, but it's the financial products covered more generally. As part of our surveillance work, we'll be looking at the target market determinations and the distribution guidelines that are developed to make sure those target market determinations are met for their adequacy. And we'll certainly be looking if there starts to be problems with a product, that there's a sense that a high level, perhaps a high level of complaint or a high level of dispute before AVCA about the product. Look at why that's happening, and one of the tools that we would use in doing that is the design and distribution obligation. So, are you targeting this product at the people that it's suitable for? I think whilst misleading, deceptive and conduct is not unrelated to that, it runs in parallel, so that the product could be still well designed and being generally targeted at the right people, but there might still be misleading and deceptive things said in the selling of it, and that would still be problematic and something we need to take action about. So they're not, whilst they operate in parallel, they're not overlapping requirements. And I guess by the same token, you could have a product that was poorly designed and didn't really meet the needs of the people it was being sold to, and you could potentially sell it without any misleading or deceptive conduct. So it's the two working together that are important. So I think that we consider that design and distribution obligations has taken things a lot further, because it's, rather than a negative obligation to avoid doing anything that's misleading, it imposes a positive obligation. Identify the people this product's suitable for and target your marketing of it towards those people.
Senator Pratt, we're sorry, go on.
I just wanted to lastly ask, will you, ASIC has said in the course of Sterling that they don't review PDSs really to see if they're misleading unless there's a specific complaint. But of course, when funds are being moved around and it's a complicated structure, you might not see the extent to which those problems are there. So therefore, you won't get any complaints. Are you really confident that this design and distribution element will be able to proactively get in there to prevent that? Will the design and distribution mean a detailed look at a product disclosure statement and whether risks have been disclosed adequately?
Senator, I think it's a good question. We're confident that it's a significant new tool in our armoury for dealing with problems. But I'm not going to sit here and tell you that means, and it's not a product pre-approval process where before you can sell the product, you've got to get everything approved by ASIC. Entities are still permitted to, and the primary responsibility remains on the entities who are developing, designing, issuing, distributing these products. And that's where the primary obligation lies.
But if they're capable of
we can't,
misleading...
ASIC still won't have the resources to be involved and sit, and look over their shoulder as they do that every step of the way to make sure nothing is done that's wrong. there will still
Okay,
be
if they're capable of being
that's bad
deceptive and
products.
misleading, then how are they capable of meeting the design and distribution obligations? And should that not bring into play really the need for independent assessment and advice that's built into the cost of offering a product like this, whether that's individual advice or an independent assessment under your DDO obligations, as suggested by Mr. Delosio when he gave evidence?
Senator, I guess at the end of the day, whether that was to be introduced is really a matter for government, and it's a significant policy call if that was introduced as a requirement that you had to get personal advice in relation to each one of those investments before they could go forward. Obviously it would be possible to impose such a requirement, but there would be downsides as well in terms of the cost and the reduced availability of investment products. So,
do you think consumers would be
at the end of the
shocked
day, that's a
if they
policy question
realised?
for government.
Do you think consumers would be shocked if they realised how little real assessment there is of the viability of a product before it can be legally offered?
Senator, I think it depends probably on their level of experience. I think there are some products where, and the classic example I always use is, children's nightwear, where there's very prescriptive rules about how that's made, particularly around flammability and issues like that. There's it's a product safety regime. For investment products, we don't have a product safety regime like that, and investments, if we did, the range of investments available would be very narrow. The general setting is that is to allow products to be put on the market and for people to make decisions about them, balancing their own assessment of the risk and reward involved.
Okay, so
that's the setting that's been put in place by Parliament, and that, again, it's, if that were to be changed, it's a matter for.
What can you tell us? And this is my last question, Chair. I do understand we're out of time. I am seeking more detail about the complaints that have been made about managed investment schemes, and whether, as a result of those complaints, how significant they are in terms of the overall structure, the overall environment of managed investment schemes, and indeed reflections on the safety of those products. Thank you, Chair.
Okay.
Thank you, Senator, and we'll put together something for you on that.
Okay, thank you very much, Senator Pratt. Can I thank our witnesses from APRA and ASIC for joining us today. I would ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. I note that we're scheduled to have a quick break. I note our witnesses from AFCA are here, so welcome to you. But we might just have a quick break now for 5 minutes and then resume at the nominated time, which is 4:20 p.m. with our witnesses from AFCA. So if you could bear with us, gentlemen, I'd appreciate it. Thank you. Welcome the representatives from the Australian Financial Complaints Authority, AFCA. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a Department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Wednesday, 3 February 2022. I invite you to make a brief opening statement, should you wish to do so, and for the Hansard record, could you each please state your name and the capacity in which you appear?
Well, good afternoon, Senator, and thank you very much for inviting us to appear today. My name is David Locke. I'm the Chief Executive and Chief Ombudsman at AFCA, the Australian Financial Complaints Authority, and I'm joined by my colleague. Well, let's introduce himself.
Justin Untersteiner, a Chief Operating Officer here at Australian Financial Complaints Authority.
I'm conscious that the committee's time with us is quite limited, and obviously many of the matters have been discussed throughout the course of the day. So in order to maximise our availability to answer questions, we're not proposing to make an opening statement.
Okay, I might just kick off with one question to start. And have you had an opportunity to watch some of the hearing during the course of today?
We've had an opportunity to catch some of it, but we have been in and out of meetings as well, Senator.
Okay, that's understandable. One of the issues that's been raised in relation to the compensation scheme of last resort is where are the complaints being made to AFCA? In what particular area of the financial services spectrum are complaints being made? What is the quantum of those complaints, both in number and also in terms of the value of the complaints being made? And also, where are complaints made, upheld, and then complaints or the financial compensation orders aren't being met? So, and this has been raised in the context that the Ramsay review occurred some time ago, hence the data upon which it was based was collated with respect to some time ago. What information does AFCA have to give this committee some insight in relation to those matters, so we can make a sober assessment as to whether or not the compensation scheme of last resort as proposed is directed in the particular areas where it needs to be directed?
Yeah, we're very happy to do so. Perhaps if I make some introductory remarks regarding the sorts of issues that we deal with and what we're seeing,
yes, please.
And then we'll lead on to an explanation of what we have seen with regard to insolvent firms as well. So AFCA handles about 70,000 complaints a year that come to us. Most of those are from individual consumers. About 5% come from small business owners, but the majority come from individual consumers, ordinary Australians who will have a dispute. About 61% of the complaints we receive relate to banking and finance matters, 23% general insurance, 7% superannuation, about 6% investments and advice, and about 3% life insurance. The majority of matters.
Sorry, could you just walk through those figures slightly for us again, because this is relevant, and I wonder if in each category you could break it down to give us examples of the sorts of matters which. So when you say banking and finance, what are we actually talking about in practice in terms of the nature of the complaints? Just to give us some visibility around what's occurring in practice.
So the banking and finance matters could be related to credit. They could be related to disputes around transaction accounts. So they could be anything from financial hardship and the individual consumer is in financial difficulty, has approached the financial firm for assistance and not being provided with assistance or not being able to reach a resolution. It could be around scams, for example, and we've seen an increased level of activity there. It could be a wide range, really, of transactional or matters with regard to. Most of it relates to credit, either accessing credit or disputes around charges, disputes around variations to contracts and those sorts of matters, or disputes around enforceability of guarantees. So we see probably about a third of all complaints coming to us really relate to the major 4 banks, but the rest will be a wide range of credit providers, and that can be anything through to buy now, pay later providers or payday lenders, or it can be second or third tier credit providers.
Okay, and the total percentage of complaints which fall within that category is, I think you said 61%.
61%, and then we have 23. The second largest area where we have 23% of matters relates to general insurance, and that could be anything from motor vehicle insurance, from property insurance, through to pet insurance or travel insurance. A wide range of general insurance issues, and there may be about refusal of claim, there may be disputes about delay, there may be disputes about case handling, compensation that's being offered, or it may be about issues around disclosure or non-disclosure of pre-existing conditions. We then have about 7% of matters relate to superannuation. And again, that can be a wide range of disputes. Some of that can be about life insurance within superannuation. Some of it may be about death distribution. Some of it will be around fees and charges and administrative errors or allegations of administrative errors. The next area where we have about 6% of matters is investments and advice, and that covers really a wide range, the full spectrum really, of investment and advice activity that you would see. About 900 complaints, so about 1% relate to financial advisors and financial planners, but the rest are everything from contract for difference trading through to managed investment schemes and a wide range of other products. And then the final area I mentioned was life insurance, which accounts for about 3% of disputes.
Okay.
What we find is with most cases, we are able to work with the parties to through conciliation techniques, through negotiation, to resolve disputes. And the vast majority of disputes do get resolved, but in about 6 to 7% of matters, it is impossible to resolve the dispute between the parties. And in those circumstances, we do have a determinative function. So one of our ombudsmen will investigate the matter, look into it, and make a decision based upon what we consider to be fair in all the circumstances of the case, having regard to the legal framework, having regard to codes of industry practice and self-regulatory provisions. And so we're looking at about 5,500 cases a year where one of AFCA's decision makers will make a decision. And the way that the scheme operates is that individual financial firms who are members of AFCA have a contract with AFCA, and a condition of that contract is obviously that they remain members of AFCA, but also that they, where determinations are made against them, that they honour those determinations and make the payments that are due. Now, there's a wide range of resolutions that can be achieved really through the determinations. Actually, we find about 70% of matters that go through to determination actually resolve in favour of the financial firm. So we're looking at about 30% at the moment that go in favour of the consumer. And that's because most of the cases that are resolved are really resolved to the satisfaction of the consumer. So we're really dealing with a small number of intractable matters that have not resolved. When we look at, AFCA's been in operation since the 1st of November 2018. What we find is that the vast majority of determinations that are made in favour of consumers are honoured by financial firms, but that there are a small number of matters where AFCA has made a determination and then the financial firm has gone insolvent. And that can lead to a situation where actually the consumer has gone through a process of IDR, gone to us through a process of EDR, got a determination in their favour, which may be around misconduct, it may be around mis-selling of products or whatever it is, and then they, at the very last minute, are really deprived of any compensation, even though an award's been made. What we have
So
is,
if I could I just interrupt a
Yeah.
little bit? This is really very useful for our purposes, or at least I'm finding it very useful. You talked about 5,500
a year.
Determinations being made a year,
Yep.
and I think you stated that, say, 30% of those were determinations made in favour of the consumer, and the reason for that was that the mediation process, if something's resolved to the satisfaction of a consumer, then the matter's been resolved. So from what I'm understanding from what you're saying, and I just did some quick maths, which is probably entirely inaccurate, but something like 1,600 determinations in favour of consumers a year. Is that accurate?
I think that's approximately the case, yes, Senator.
Okay. So then within that 1,600, you then were saying that a small number of those determinations are not satisfied, and that can well be due to insolvency of the financial service provider. So I'm very interested for us to drill down into that number of determinations which are unsatisfied, and in which finance sector are they occurring?
Absolutely. So I'll give you some of the headline figures on that, and Mr. Untersteiner has got more detail. So we have two classes here, and the figures that we have, Senator, are really from the 1st of November 2018 to date. So I haven't got an annual figure each year, I'm afraid, but I've got a figure which effectively takes us through that period, which is 3 years effectively and a few months. There are two classes. Firstly, there are the matters where we've made the determination in favour of the consumer and then the firm has gone insolvent. And we have 180 of those. So we can talk about, and Justin can provide the breakdown of those. There's then a second group, though, which are cases that have come to AFCA but haven't gone through to that final determination stage. So they're in process, and we've become alert that the financial firm is insolvent. Either there's a formal insolvency or there's a de facto insolvency and they've stopped trading, and it's a zombie organisation effectively going. We have, over that period, 1st November 2018 to date, we have 1,863 matters. So in total, we are talking about over 3 and a bit years, 2,043 matters. Now, of those matters that are paused, we don't know yet whether all of those are in scope. They may not be matters that we can actually deal with. They may be cases that have got no merit. There will be a mixture really in those. And again, we don't know how many of those, if they went through to determination, would be found in favour of the consumer. I've given you the headline figures of what we see on a macro level across the organisation. But that's what we're looking at in terms of numbers that we know over that three-year period. We're talking about a figure of 180, and then we're talking about a wider figure that's actually in the pipeline. Now, many of those matters would not fall within the scope of the CSLR as has been designed, but I'll ask Justin to perhaps provide a little bit more information.
So when you say many of those matters would not fall within the scope of the CSLR as proposed in the bill, the matters you're referring to are the 180 or the 1,863?
So of both. Of the 180, we believe there's 34 matters that we believe would be within scope of the CSLR. And then there's a range of other matters.
So just to give some context, and listening today, I'll call out, I guess, some of the parts that you might be interested in. So of the 1,863 cases that are currently open but paused, we believe 150 of those would fall in scope of the CSLR legislation. Again, going back though to the fact we haven't investigated them, so we don't know anything about their merits. That's just on the surface based on what's been submitted. As Mr. Locke mentioned, we believe there are, of the 180 that are closed, there would be 34 in scope. Important to note though, of all of those cases, of the open cases, the 1,800, 1,162 relate to a single firm, and that is a firm called Union Standard, which is a foreign exchange dealer, so a high-risk derivative dealer, and all the complainants are offshore, right? They're all Taiwanese, Chinese investments. So at this stage, we didn't see that there was any intent of the government to include that in the scope anyway. So that's over 60% of all those complaints. If we break down underneath that, there are 273 open complaints and 62 closed complaints that relate to managed investment schemes. There are 166 open complaints relating to derivative dealers. So again, high risk speculative investment. When you get to financial advisors, there are 118 or personal advice complaints, 118 open and 23 closed. Life insurer, we have 77 complaints, and the majority of those relate to one firm, which is recently one of the ACBF funds that recently went into voluntary administration.
And that is a which provider. Sorry, just excuse me. Which sort of fund?
It's a life insurer, and so this is a ACBF, which is a funeral insurance policy.
It's not actually regulated by ASIC, and it isn't prudentially regulated. But it was one of the case studies, Senator, in the Hayne Royal Commission. It involves the selling of funeral insurance to largely Aboriginal individuals within community.
And I think it's referred to in Choice and the Consumer Advocate submission.
I believe so.
Yeah. Okay, please continue.
And then from there, the numbers really reduce significantly. So we're talking about, and these are in scope of the compensation scheme of last resort at the moment under the bills. The security dealers, we have 12 open complaints. Mortgage brokers, we have 9. Credit providers, 3. Finance brokers, 2, and debt collectors, 2. So just much smaller numbers in those last categories.
Do you have a breakdown to give us an understanding of the quantum claimed within each of those categories?
We can certainly take that on notice. I would say it should be heavily caveated though, Senator, because obviously, as we've said, we haven't looked at the merits of this, and often there may be a big disconnect between what is claimed and what actually may be determined in matters. So certainly it would be a very loose figure, and I think it would need to be very heavily caveated. But in terms of what individual complainants have put on their form when they first submitted to AFCA, then we do have that information. We have provided that through to Treasury as well, so they again would be able to look at that. But it would need to be very.
Provide that to us.
We're happy to take that on notice.
Yeah, if you could take that on notice, and I guess the observation I'd make, I understand how it would be heavily caveated with respect to open matters, but with respect to closed matters which have not been satisfied due to insolvency or perhaps, and I'm interested to know any other reason, is the caveats would apply less so. Is that correct?
Yeah, I mean, that's a figure I'm happy to provide. Of the closed complaints against an insolvent firm, we currently have, of the 180, and again, this isn't broken down into categories, it's just a broad figure. So some of these would be in scope, some would be out of scope. There is about $13.8 million in compensation awarded, 13.8. And that's of the 180 closed complaints against insolvent firms. As Mr. Locke mentioned, of the open, the 1,863, I don't have that figure on me. And again, it's a really difficult one. I mean, we've seen, just to use an extreme, we've seen examples in the past where someone had a, you know, a fee of $50 added to their account, and they've claimed $20 million on their form. You know, so that unfortunately those figures aren't very accurate. But 13.8 million for the closed.
If you look across the piece at an average macro level figure for AFCA in terms of what's awarded, the average compensation award is just under 28,000. But if you look at some of these headline figures, and that can vary greatly though, as Mr. Untersteiner said, these can be small matters that may be significant to the individual consumer, but on an objective level are not high, through to matters that could be up to $500,000. So it's very variable. But in terms of that 13 million figure that's provided, that is across the 180 closed cases. The CSLR, as designed, covers 34 cases, not 180. So that does need to be factored in.
Yeah, so I'm very interested from my perspective, and I'll be sharing the call with Senator Pratt in a moment, but whatever information you can give us in terms of the 180 closed cases which have not been satisfied, which you can break down in terms of different sectors of the financial services industry, so we can gain an appreciation of the nature of the claims which are unsatisfied, so we can determine what would be covered. I mean, you've given us the number that would be covered under the CSLR, but it'd be interesting to know with respect to those which currently aren't, what category do they fall in, including managed investment schemes, obviously, which is a contentious issue in terms of this bill, and other categories, so we can get a bit of transparency in terms of what the experience has been since 1 November 2018. Is that possible, practical?
Yes, Senator.
Okay. Can I ask you, I guess the other issue we need to be cognizant of is if, say, the responsible entity of a managed investment scheme went belly up, went into liquidation, then it could well be people aren't making claims because they think, well, there's no point making a claim because the responsible entity or the promoter has gone into liquidation, so I'm not going to be able to get it satisfied in any event, so I won't bother making a claim. Is that something we need to be aware of too?
Absolutely. I mean, we can only provide information on what has come to us, Senator. So we don't have any indication of what else may be out there.
If someone's in that situation, and obviously you're aware of the Sterling First situation, and someone contacts you as a consumer and says, look, I want to explore making a claim in relation to Sterling First, do you engage with them and say, well, okay, understand, but be aware the responsible entity is in liquidation, so it might be you might not ultimately get anything from the work involved in terms of putting in an application, or do you still invite them to make an application so it's on the books? How do you approach that situation?
Yeah, sure. So if you go back in time, the predecessor schemes in AFCA when we commenced, if there was an insolvent firm, we wouldn't accept future complaints. So we would close them because there was no prospect of compensation, because there was no firm on the other end, right? And there was no point taking them through that process for that reason. However, when the government announced that it was intending to implement a compensation scheme of last resort, we changed that policy. And so we now do accept complaints into our system, but essentially we pause them. We don't do work on them because they're insolvent, and we're waiting essentially for the scope to be confirmed of a compensation scheme of last resort. We don't actively promote that though. I mean, if there is a major failure, we may have information on our website to say that they're insolvent, and it's open for consumers to lodge complaints, but we certainly won't go out looking for that. That would be for a consumer to find on our website or to be advised from our representative.
And then the last question I have before I give the call to Senator Pratt is, we've heard evidence from numerous stakeholders with respect to the availability of professional indemnity insurance.
Yep.
And the application, say, of excess amounts or exemptions, exclusions, which may decrease the utility of the professional indemnity insurance in terms of being a source for compensation. Does AFCA have any information or data with respect to professional indemnity insurance and its the success of claimants to actually receive compensation out of professional indemnity insurance or not?
Sure. So we don't have data. I mean, from an AFCA perspective, we typically don't get access to information about the insurer. There's no requirement to provide that to us. Anecdotally, what we see in here is that many financial firms choose to pay compensation out of their operating accounts rather than through the insurer. The reasons can vary. It could be the excess, it could be the scope of the policy. There are lots of different reasons for that. We've seen some instances, and we know of because we've been told by consumers, where a policy has paid out to a consumer but with a large excess. So we saw one, in fact, related to the Sterling matter, where there was a $100,000 excess involved. But typically we are not aware of that. We don't have visibility of that. And again, the information we have is very anecdotal.
And professional indemnity firms are not required to be members of AFCA, so we have no jurisdiction with regard to professional indemnity firms either.
Okay, and just my last question, I might phrase this in general terms, giving you an indication of what I'm interested in, and then perhaps request you to reflect maybe on how you can provide it. But one of the issues that's been raised with us today is some sectors of the financial services industry, including, for example, stockbrokers, say, well, there are no situations where we haven't met a judgment or a determination for compensation in favour of our retail customers, and the Australian Financial Services Council also made similar statements. So it'd be interesting from our perspective to know, whilst we're focusing on where judgments, where the matter's been closed and it's unsatisfied, also having an indication where determinations have been made against certain categories of Australian financial service provider where they have been satisfied. So, for example, information that perhaps indicated, for example, that 99.5% of claims that were successful against stockbrokers were satisfied, only this small percentage weren't satisfied. And that goes to the issue of the concern that's been raised around cross-subsidisation. Is there any data you can provide us in that respect?
There's probably very little, insofar as our role is as the independent arbiter here to to do our utmost to try and resolve the dispute between the parties. And if we can't make the determination, obviously we then will notify the parties of the determination, and it's then up to the AFCA member, the financial firm, to compensate if that's what's been awarded. If we become aware that compensation hasn't been paid, then obviously we will contact the financial firm, and we would then report the matter through to ASIC, who, as the conduct regulator, may take action in that space. But we don't, keep statistics across the piece, other than on that sort of exceptional basis, really, on where we are aware that awards have been made and they haven't been honoured. So I suppose all we have is really data on AFCA for the last 3 years as to what we've seen, and it almost works the other way, Senator. We can tell you where we've got cases that we're aware of that have not been honoured. Really, everything else has been honoured, as far as
I guess, yeah. So I guess so we can apply the corollary, if you like, in the event that you give us the data around closed cases which have not been satisfied. Is that correct?
Yes, and just to flag, I think one of the outcomes that could play out if a firm wasn't to pay the determination is that the consumer may come back to us, we report it to ASIC, and the risk is that they actually lose their license. So, I think the reality is in the vast majority of cases where a determination hasn't been paid, it's because the firm is insolvent.
But we're talking about the situation at a point in time based upon information we've got over the last 3 years. Obviously, we don't know what might happen tomorrow or next year with regard to those. So it may be the case that there hasn't been any in the last 3 years, but that isn't necessarily the same as an accurate assessment of where there may be risk of future non-payment, I suppose. But we'll certainly provide everything we can, Senator.
Yeah, if you could, and if on notice, you could provide us a definitive document, if you like, that summarises all those very useful statistics that you provided during the course of your testimony. That would be that'd be very useful as well. Is that possible?
Yes, of course.
Okay, yeah. Thank you very much. Senator Pratt, you have the call.
Thank you very much, Chair. It appears from the data you've given us that the bill before us doesn't fix very much of the problem, if it's 34 out of 180 of the current determinations.
Well, all I can do is tell you what the number of determinations we've got and what we understand is covered by the scope. But yeah, really, the issue about what's covered, the scope and design, is really a matter for government. So that would be something for Treasury.
I understand that, but if the Royal Commission recommended a compensation scheme of last resort, and I need to judge the extent to which this bill before us is effective in implementing a solution to the problem.
What I would say, Senator, is, yeah, I was just going to say, Senator, if I may, just out of the 180, 128 relate to Union Standard, which Mr. Untersteiner has talked about, which is the very high risk trading activity.
No, and I agree that they shouldn't be brought in. But even so, how many of the complaints of those 180, I think you told us how many are managed investment schemes?
62, Senator.
That's right. And how many of those relate to sterling?
Only a couple. I think possibly 2.
Most of the sterling matters were impacted by the DH Flinders case.
Or they're still open.
So that is only the matters that are closed where there has been a determination and the firm has gone insolvent and the determination's been unpaid. So only a couple of those would be sterling first.
Okay, so in terms of if it's the will of the Parliament to bring managed investment schemes in, I'm keen to understand the quantum of the liability, but also to understand technically how to bring them in under your jurisdiction, and how to fix the DH Flinders issue, and indeed for determinations you've already paid but were only paid partially. That your rules mean that you can't hear something again. If they were brought in, would the excess in the case of, for example, Mr. Fardo get paid, or would it require a new case? And how do we technically resolve those issues?
Well, Senator, for a matter to be paid under the compensation scheme of last resort, firstly, you would need to have a situation where AFCA has got jurisdiction to consider a matter, it has made a determination in favour of the consumer, and then the financial firm has failed to pay, been unable or unwilling to pay. And so you've gone through that process and you're in a situation where it really is a last resort.
I understand.
So that's what's
required. How does the Parliament amend your jurisdiction in the case of DH lenders and managed investment schemes more broadly?
That really is a matter for Treasury. I mean, it's a matter for government and Parliament to determine what the scope of this is.
I'm asking you as a legislator for your advice on the technical side of that. Yes, government will make up its own mind, but if I want to amend the bill, I need to understand how to go about doing that.
I understand, Senator, but it isn't.
Government bodies won't preclude me from getting the right advice to be able to do that.
Senator, we're the independent arbiter, the EDR scheme that applies in this space. We're not in a position to advise. We're not experts. We don't know. We're not in a position to advise on how to amend government legislation. That really is a matter for others to advise on. All we will do, we've been asked by government to assist with the establishment of a CSLR, and we have confirmed that we would be happy to do so. But the decisions about the scope, the decisions about I know, but the question that you are asking relates to amendment to the legislation. That isn't something that we are qualified to advise on, nor is it our role, I'm afraid.
So just to assist. Just to assist Senator Pratt, as I'm understanding the position you're putting to us, it's AFCA doesn't typically engage in the drafting exercise of legislation. Absolutely. So it's really a case of you not wanting to provide assistance. It's just you don't have the expertise of being drafters of Parliament of legislation. Is that the point really you're making?
Absolutely. We have no experience in that matter. It isn't our remit, and it isn't something that we're qualified to advise on. So we're not seeking to be unhelpful. We're just not the right party to advise on that. What I would say with regard to the Sterling First matters is that the challenge firstly is AFCA would have to have jurisdiction to be able to determine a matter, and then there would need to be a determination that fell within the scope. So even if the legislation were to be amended by Parliament to include managed investment schemes, if AFCA does not have jurisdiction to consider a particular matter, and in the case of the Sterling First matters, that may be as a result of the DH Flinders decision, then we wouldn't be able to make the determination, Senator, that even if the scope were extended. So that is the challenge with those particular cases.
Okay, so in terms of the DH Flinders case, why was it found to be outside your jurisdiction, and why did you not appeal that at the time?
Sure. So the best way to kind of to explain this is I might just use a hypothetical here, Senator, if that's okay. If I'm a license holder, a responsible entity, I can make you an authorised representative. So, Senator Pratt, let's pretend I've made you an authorised representative. When I do that, I have to define the scope of your authority. And so, if we just pretend that the scope I give you is to do activities A and B, okay? Now, let's just imagine that instead of doing activity A and B, you actually go and undertake activity C, which I never gave you authority to do. And in doing so, let's pretend you broke the law and you have caused consumer loss. Now, under the Corporations Act, me as a licensee can still be held accountable for your conduct, even though you did something that I never gave you authority to do, okay? Now, we have always, and our predecessor schemes, and I believe Treasury and ASIC were of the same view, believe that our jurisdiction within our rules were consistent with the Corporations Act. In 2019, the DH Flinders case was actually a challenge of that exact situation, right? And the court read down our rules very narrowly and determined that, in fact, if you were to be acting outside of your authority there, I can't be held as the licensee liable. And so because of that, we very quickly worked with ASIC and with Treasury and have amended our rules. That is no longer a problem. However, there is a small window there where it is a problem, and that specifically relates to the Libertas matters, as you're aware. So what that essentially means is we don't even have jurisdiction under our contractual agreement, our tripartite contractual agreement within our rules, to hear a complaint in that situation. And that's the problem that we have.
It, but then my question is how to legislate to overcome that, because the common understanding of that was well established, and indeed I know that vast sums of money were paid out in fees to the company for whom these advisors, etc., worked. So they took the money, which I would have thought should have also added to the assumption that the appropriate licensing and permissions were in place. How can you take money for a product that you haven't given permission to your representatives to sell?
Yeah, so look, unfortunately, No, I understand. Look, I absolutely understand where you're coming from, and we understand the issue, and we also sympathise as well. We understand the challenges this has caused. It's been a horrible matter. Unfortunately, though, we are bound by the court's decision. We're in a...
I know you're bound by the court.
Yeah.
I understand you're bound by the court's decision, but my actions in Parliament are not bound by the court's decision.
No, I understood, and I would be...
I need to understand the problem well enough to be able to fix it should...
No, I understand.
I'd be able to convince enough people in Parliament to do that.
Yeah, look, my response will be the same as Mr. Lofts, which is that's really a question for Treasury when they appear. It's a policy question, and I don't have the answer. We don't have the answer about how you overcome that through a legislative amendment or change.
Okay. All things being equal, if they hadn't been, if that court ruling hadn't been made, how would the circumstances of people who made that investment by that company be materially different in terms of their eligibility before the CSLR?
I guess in a hypothetical, if there was no DH Flinders case, so that decision wasn't made and our rules weren't read that way, and managed investment schemes were appropriately defined within the CSLR bill, they could possibly be included. But again, that would be a matter for government and for Treasury.
AFCA would be able to, if that were not the court's reading and the judgment, AFCA would be able to consider those matters and make determinations. And if we made a determination in favour of consumers in those matters and it fell within the scope of the CSLR, then they would be entitled to compensation under the CSLR, Senator. So that's really, that's really how that could play out in a hypothetical situation. But at the moment, as we've said, the matters that are covered by the CSLR are personal financial advice to retail clients, as you're aware, credit intermediation, credit provision and securities dealing. So it wouldn't cover managed investment schemes, as you're aware, as it's currently before Parliament.
Senator Pratt, our time, schedule is indicating that we need to move on to Treasury. In fact, we've exceeded our time with AFCA. Do you have any last few questions you want to ask?
I think they can probably go on notice. I guess I'm just interested in, we've gone through the quantum of money that might be sitting there liable. In terms of the information you've handed on to Treasury that's meant that managed investment schemes are currently out but others are in, is there a materially different assessment of being of liability? I probably have to ask this question of Treasury, but the other sectors are concerned about needing to pay for managed investment schemes, and I need to be able to ask Treasury about the extent to which those fears are founded or can simply not be determined, when I know a lot of the information they're basing those decisions on is the information that AFCA will have provided to them.
Yes. So I think we took on notice to provide any information that we've got about the quantum, and so we're happy to provide that to this committee.
If we could have the same information that you've given Treasury, that would be terrific.
We're happy to provide all the information we're able to do so. Obviously, you know, government has made decisions on the scope of the scheme, and that is for a matter for government and for Parliament. But certainly in terms of the information that we have on what we've seen and what we are aware of, both in terms of closed and open cases which are potential, we're happy to provide that, Senator.
Thank you. Thanks very much, Jen.
Thank you.
Thank you.
Thank you. Thank you. Thank you, Senator. We're all thanking each other. That's good. Thank you, Senator Pratt. Can I thank you both for appearing as witnesses today. I would ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on the Parliament's website. Thank you very much.
Thank you.
I now welcome representatives from Treasury. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I would also like to advise you that any questions on notice should be sent to the Secretariat by close of business Wednesday, 3 February 2022. I invite our officials from Treasury, if they'd like, to make a brief opening statement. And for the Hansard record, could you please each state your name and the capacity in which you appear, please?
Nahida Zahid, Assistant Secretary, Financial Systems Division. Thank you, Chair. We won't have an opening statement, but happy to kind of go with questions, but we'll let my colleagues introduce themselves for the Hansard purposes.
Okay, thank you, Ms. Zahid.
Lee Reeve from the Treasury. I'm the Director of the Regulatory Powers and Accountability Unit.
Thank you, Ms. Reeve.
Chris Lyon from the Treasury. I'm the Director of the Redress Unit and Financial System Division.
Thank you, Mr. Lyon.
And Brian Healy, Director, Treasury Law.
Mr. Healy. Okay, excellent. Thank you, Mr. Healy. So thank you all for joining us today. I might start with about 5 minutes of questions and then I'll hand over to my colleague, Senator Pratt, for some questions. So there's a few matters that have been, Ms. Zahid, that have been raised during the course of today. Have you been watching today's proceedings, the best show in town?
It has been a good show. Chair, I've caught most of it, but unfortunately have had to drop in and out for other meetings that couldn't be avoided.
Okay, all right. We'll take that, we'll accept that excuse. Thank you very much. One of the issues that was raised by the Law Council of Australia was the question of, instead of introducing the FAR, why don't we just extend the BEAR to cover more areas and more financial services institutions? And the argument is that the BEAR has been bedded down by ADIs and they know what it means, they know how to apply it. So wouldn't it be easier to stay with what we know and just extend that to more institutions? What's your answer to that proposal?
Thanks, Chair. I did catch the Law Council's evidence in relation to that. So it's a pragmatic one. So the Banking Act applies to banks and ADIs. It does not apply to insurers. It does not apply to superannuation trustees. It's also not administered by ASIC. So from a Treasury perspective, one of the things we try and aim for, we don't always succeed, is to have laws that are accessible, that are, where possible, contained in one spot, so entities engaging with the law have a chance to understand what the law says. In terms of the approach that's been taken, it's been designed obviously with the Office of Parliamentary Counsel. It's not from a legal, without going into the minutiae of how the various legal constructs work, but the Banking Act simply just does not apply to the other sectors, and it would be incredibly messy to try and replicate. So you'd have pretty much the same provisions in 4 different acts, and then you'd have to think about how do you give ASIC powers to administer the right parts of the acts, and any changes Parliament wants to make to the acts would then mean you're changing 4 different bits of acts, and if there's a transcription error, the law falls out of alignment. So in terms of extending the BEAR, it has been necessary to do it in from a law design perspective on having laws that are accessible and future-proof, to try and do it in the way we have. One of the key principles that we have adopted as we've gone through is consistency with the BEAR. So changes that have been made to the legislation between the BEAR and the FAR reflect changes that are necessary to reflect the changes in policy, but we've sought to avoid any unnecessary changes to reduce the cost to industry and reduce that implementation burden. But personally, just a slightly different view to Law Council that in terms of the legal complexity that would arise. It may be simpler for those banks that have complied, but for everyone else and the future of that legislation, it would be really complex to maintain.
Okay. Just my next question, and then I'll pass over to you, Senator Pratt. And this might be you, Mr. Healy, but the Financial Services Council, Law Council of Australia, King & Wood Mallesons raised a collection of issues which were quite technical, I think, in nature, with respect to matters such as application of the law to foreign entities, significant related entities, third-party service providers, etc. Are those matters which are under active consideration by Treasury in terms of potentially preparing draft amendments to the bill to resolve some of those uncertainties?
Chair, I might throw that to Ms. Reeve.
Ms. Reeve.
Yes, Chair. So, yes, these issues were raised with Treasury, and the legislation, as Ms. Zahid has said, that we've really very much tried to stick to the BEAR. However, there have been some modifications, and we had to make a lot of those modifications, I guess, in respect of the superannuation sector, where they have quite a diverse range of complex entities. And I understand King & Wood Mallesons and others have raised some concerns around the concept of significant related entity and how it works with super. So we are aware of those. We have, since the explanatory memorandum that was consulted earlier this year, it did take into account some of that feedback, and where we have been able to, we've sort of addressed those in the explanatory memorandum to try and provide that greater clarification. But having said that, I think there is some level of uncertainty just because this is a very broad regime. It's trying to cater for a diverse range of structures, and so we can't be too prescriptive. And I think you mentioned this, we're trying to make sure that it's neutral across all structures. So for that reason, the law does have some general application and some uncertainty, I guess, does still persist.
Senator Scarr, have we lost you? Can our witnesses still hear us?
We can hear you. I couldn't hear the chair. I could see him speaking, but I couldn't hear him just before.
I might just check. I'm assuming he.
Sorry, so you've got. Sorry about that, Senator Pratt. You've got the call.
Okay, I was just trying to make most of the time while you seem to have dropped out.
Sorry about that. Thank you.
No, that's more than fine. I put a question on notice that was due for answer. I think we were hoping for an answer by the 20th of this month in relation to. I've just got to pull it out so that so that I can see it. It says, if the proposed legislation is passed in its current form, would further changes to CSLR eligibility in relation to a relevant AFCA determination, for example, for the products and services listed in the proposed subsection 1065(2) require subsequent legislative amendment, or could eligibility be changed by regulation?
Senator, so I will throw to my colleague Brian Healy on this. My understanding is for those matters to be covered within the scope of the CSLR, it is the subsectors are currently prescribed in the legislation that's before Parliament, and it would require changes to those legislations. But Mr. Healy, I might just throw to you.
Have you?
Thanks, Mr. Head. That is correct.
Okay. Have you looked at how to amend the legislation to bring those aspects back in? And in order to bring them in, do we just need to delete the subsection that prescribed them, or do we need to be more explicit about that? I appreciate that's outside the scope of what government has recommended, but as a legislator, I need to seek answers as to how to go about doing that, should Parliament want to.
Sure. Senator, so it will depend on exactly what the scope needs to be in terms of how best to do it, and we would work with the Office of Parliamentary Counsel to settle that. I think you heard the evidence from AFCA just before. There's a very broad set of subsectors that fall within AFCA's scope. So if you'll take a slightly different approach depending on how broad the CSLR scheme would be, it would really depend on, are we talking about bringing one subsector in? Is that subsector well defined in existing legislation? If not, then we may need to think about how best to define it. Generally, the approach Treasury takes is we work with the Office of Parliamentary Counsel, who hold the pen on legislation to figure out what's the most effective way to give effect to that. Again, Mr. Healy,
okay, so
not sure if you've thought more about it.
No, but I understand you would do that if that was the government's position. I understand it's not the government's position currently, but if the weight of numbers in the Senate indicate that we should wish to amend the legislation to bring those things within scope, are you at the ready? What information do you need to fix to bring those things back into scope?
Senator, so if the Parliament and if the government instructed Treasury if we had a settled policy position that was different to the current bill, we would, as we ordinarily do, issue drafting instructions to OPC and have revised legislation. There's obviously different processes in place in terms of how legislation gets changed once it's been in Parliament. But ultimately, if there was a decision taken to amend the legislation, there are obviously existing processes in place once the legislation's been introduced.
Okay, so I put to you that there's a reasonable likelihood that there would be a cohort of numbers there to see the legislation amended. What are you able to tell me about how to go about doing that in the context of not just bringing managed investment schemes in, but also addressing things like the DH Flinders issue, where the company that took payment for financial services, then argued in court that they were nevertheless not responsible because they hadn't given authority to their officers and advisors.
So, Senator, there's probably two slightly different answers. To start with the first part of your answer, what would be the process to bring in a subsector like managed investment schemes, for example, and issuing products in the managed investment schemes? Obviously, if it's advice in relation to managed investment schemes, that's already in scope. We would then work with OPC around the existing definitions that exist with Corporations Act and look at how best to incorporate that into the existing structure of the legislation. The question on DH Flinders is a bit different. That is one around retrospective application of how things worked within AFCA. AFCA isn't a government body. It operates by contract between it and its members. That's a much more complicated question because it has two elements. One is it's kind of contractual agreements between AFCA and its counterparty. The government is not a part to that contract. The second part of that is it's talking about retrospective application of jurisdiction and change, and that gets really complex and legally technical. And we would need to really work that through in terms of what is feasible and how to do that. So that one is a much more difficult answer. And obviously, once a court has taken a decision around an interpretation of a contract, you get into the all sorts of, and I'm not a lawyer, so I'm not going to profess a view around contracts law and how the Parliament should go about amending contracts law contract retrospectively.
I would, if possible, like you to take that question on notice so that we can be advised about how to do that, noting that it was, of course, the assumption as to how those contracts would, while it looks retrospective, it was always assumed that this was the way that the Act worked. And in addition, the company that it then argued they weren't responsible was nevertheless receiving significant sums of money for the provision of those services, which I think does shed a different light on when it might be just or unjust to have something changed retrospectively.
Senator, again, the court has looked at these matters. It's kind of issued its statements. Happy to take it on notice, but it's probably one where we're not going to be able to come back with something particularly helpful to the committee in the time. As I've said, we're getting into complex areas of contracts law, and it's unlikely that we're going to be able to. Happy to take it on notice and look at what we can provide, but I just want, I don't want to sit here and say we'll take it on notice and come back with something unhelpful.
And what was, does the government think that the current bill really equips what has been asked for in the Royal Commission and in the other reviews as far as the compensation scheme of last resort goes? I note that of the determinations that there's some 180, while a large proportion of those are for foreign investors. There's still a very large cohort of people in managed investment schemes and others who've been waiting for this compensation scheme to be delivered. So in that context, I want to ask the government, can we amend this legislation quickly so that it is fit for purpose along the lines of what has been discussed? Clearly, you've reviewed it. There's been decisions made that have seen some things out of scope, but you have clearly weighed up all the issues. I don't want to see the legislation unduly delayed in the pursuit of what were amendments that should have been on the table and part of the scheme from the outset.
Senator, I'm not sure I'm in a position to answer whether the government thinks it's the right bill, but I would say obviously the bill represents the views of government based on advice and based on submissions, and it's what the government's decided the policy settings are to be. And I think we've just talked about what would need to happen if the bill was to be amended, just not in a position to kind of speak to what government's thinking is.
Okay, and in terms of the decision to not include managed investment schemes or funeral insurance and, the other prescribed categories, can you provide access to us of the modelling of the liabilities that government thought would exist under those categories that led to this decision not to include them?
Senator, we can take that on notice and provide provide information in that respect. I mean, a couple of the things I'll say is in looking at these issues in our advice to government, and again, you've just heard from AFCA, a lot of the data isn't fully available, so AFCA hasn't assessed the complaints and can't yet make a decision as to whether those figures that the complainants have put in are valid complaints, whether the compensation amounts are coherent. So we have taken into account the decision, the information that AFCA has had available. We've looked at historic claims. We've also looked at, in some cases, what are the categories and what are the principles. So you've heard from AFCA about there are some really risky products that fall within AFCA's jurisdictions. You've got contracts of difference, you've got derivative products that I don't particularly understand myself. So those are all factors that went into our advice in terms of, you know, how do you weigh up what the pros and cons are of a very, very broad scheme versus a more targeted scheme, and the government has landed on the subsectors where it's very much in that trusted relationship with the financial services sector, so financial advisors, mortgage brokers, consumer credit. So that's the decision government's taken, but we can take that on notice and look at and AFCA's already taken on notice to provide you with some data as well.
What did the managed investment scheme community, in terms of those who run and manage those schemes, say about being included in the scheme?
So I might start, Senator, and pass on to my colleague, Mr. Lyon, who's, so the managed investment scheme is a very, very broad community. So unlike banks and insurers, they're not represented by one industry body. So you heard from the Financial Services Council today, who represent a small subsect of the managed investment scheme. Managed investment schemes include anything from litigation funders to timeshare providers to any number of investment structures. So it's not a sector where there is a unified voice, where there is a sort of coherent industry body. I think the feedback we've received have been quite mixed, depending on whether you're talking to the Financial Services Council and, but Ms. Lyon, is there more that we can kind of add in terms of the colour of feedback we've received?
Thank you. So in terms of feedback we've received, because in relation to the proposal that was put out for consultation in July, we were not proposing to include managed investment schemes. The sectors have not actively responded. The bodies involved haven't necessarily actively responded, but those that have responded have generally not supported the inclusion of managed investment schemes in the compensation scheme of last resort. And the reason why they've not supported inclusion is because they know that the policy approach the government's taking in respect to the scheme is that the sector, for a sector that's included, the licensees in that sector will be levied to pay for claims in the sector.
Yes, I understand that, but I also can't reconcile the high levels of consumer detriment that can exist with the sector unless it is included, and the extent to which things like the DDO requirements might start to change some of those parameters to take risky products out of the marketplace. What's your assessment of the design and distribution obligations in terms of their impact on potential claims under a CSLR should it include managed investment schemes, or did you simply not assess that?
So the DDO obligations came into effect 1 October last year, so 1 October 2021. So it is quite early days yet to understand how that will play out in terms of evidence and lived experience. So in terms of the consumer protection measures that have been put into the system to prevent misconduct across the financial services spaces, DDO is a really strong measure. There's the product intervention power that went through at the similar time, which allows ASIC to proactively stop the sale and distribution of products that have or is likely to cause significant consumer detriment. So there are strong measures that have been put into the system. The ASIC's used the product intervention powers a couple of times, not in a managed investment scheme, much more in the derivatives space. But it has used it in the consumer credit space in relation to Signode. It's a little bit early for us to have the evidence to be able to say this is the shape of the claims we expect out of the managed investment scheme because of DDO. Obviously, the intent of the legislation is to limit misconduct, to limit distribution to consumers who should not be sold those products. We've probably got a little way to go before we see the effectiveness of that in terms of evidence.
When was the policy decision made to exclude managed investment schemes from the bill?
Senator, I don't have exact dates on me. We consulted in 2019 on a broad, in late 2018, we released a consultation paper which had a few different models, which was for consultation. We took advice from that. There was lots of engagement with government, and obviously prior to the introduction of the bill, the decision was made by government to exclude or not to include managed investment schemes. I don't have an exact date off the top of my head.
Okay, are you aware, of course, that ASIC and politicians and were being actively advised to lodge their claims with AFCA right throughout this period, up until the pause?
Yes, Senator, I think in the Sterling hearing into Sterling, we discussed this briefly. So initially, until those decisions had been made, the way AFCA's rules operate is a complaint must be lodged with AFCA at a time where a financial firm is a member of AFCA. So advice was provided through ASIC. It was provided through ASIC and AFCA to say you should lodge a complaint with AFCA that ensured that if the firm then stopped being a member of AFCA.
I understand that, but all of that was nevertheless still contingent on there being a compensation of scheme of last resort ultimately in place. Can I ask, did Treasury estimate how many additional people would have their determinations paid if management investment schemes were included in the CFLR?
We use...
Yeah.
Sorry
for interrupting.
It's all good. I think I've got a little bit of a lag on my system. Apologies. So, Senator, we took the figures we had from AFCA. There is a paucity of data in this space for a number of reasons. One is, and I think AFCA touched on this, is prior to AFCA's commencement, the Financial Ombudsman Scheme had a different approach, which was if the firm was insolvent, they wouldn't accept the complaint in the first place. Subsequently, AFCA has been accepting complaints but putting them on hold. So there is a lack of data in this space because the data is necessarily incomplete, so we don't know how many there are. There's also been a number of competing pieces of advice, class actions where people have been advised to go through a class action route versus going through AFCA. So it's actually been really difficult for us to have an estimate for the number of complaints. Obviously, AFCA shared some of the numbers that it has in relation to those complaints that's been lodged with AFCA. So they've been numbers we've had access to advise government on, but it has been really difficult for us to do what you would call any sort of robust modelling around what would be the impact because a lot of those figures aren't necessarily available to us.
Who should take responsibility for the lack of that data in the context that a pause was put in place and, you know, it sent a lot of messages about, if you like, not lodging and also meant that the existing claims in there haven't been properly assessed? Who needs to take responsibility for that lack of paucity of data?
So, Senator, I think part of it is the system and where we are in the system in terms of landing the final policy decisions and having legislation passed in Parliament. The decision to pause the handling of the complaints was made by AFCA. AFCA is a industry-funded ombudsman service, so it's usually the firms that have complaints against them that pays for their complaint handling. And obviously, if a firm is insolvent, then they're not able to pay those pay the fees for handling those complaints. So, until the decisions are made and until Parliament settles on the scope of the CSLR, it's an understandable decision on AFCA's behalf. I think the data question is a bit more complex because we have a very complex financial system. There are courts, there are tribunals, and there are individual decisions, and not all consumers have the same level of understanding to navigate the process. So I think there's a few things that flow into the lack of data in that space.
Okay. I'm very mindful of the time. We've canvassed some of this, but I wanted to understand consideration that was given to including debt management firms and a breakdown of the unpaid determinations against the sectors covered and not covered by the CSLR currently. And the estimate of the annual cost in terms of levies of the current proposed CSLR. How much of that cost can be attributed to each specific sector included, and how that cost will be distributed across firms? And did Treasury estimate how those costs would change with the inclusion of other sectors?
So, Senator, I might just throw to my colleague, Mr. Lyon, to just talk through debt management firms. I think there might be some slight confusion in the treatment of debt management firms, and then we can come back to the other points you've just raised.
Thank you very much. I know I've put a lot of things in one, but I'm trying to manage time.
So, Senator, to respond to your questions about debt management firms, so counter to the information that was provided to the committee by the consumer groups earlier today, debt management firms are actually captured within the scheme, that they are within scope. And the reason that is because from 1 July 2021, debt management firms have been required to have an Australian credit licence, and as an Australian credit licensee, they are classified as being as undertaking credit activities that's not credit provision. So effectively, they're treated the same in the purposes of CSLR as mortgage brokers, for example. They're put in the same category.
No, that's helpful. Thank you. Unpaid determinations against sectors not covered. Well, covered and not covered.
So I believe AFCA's agreed to provide, I don't have those figures with me or on top of my head, but I believe AFCA's agreed to provide that on notice. The figures we have in relation to current stock of unpaid would have come from AFCA. So I think that's probably the most effective way to get that information to you.
Are you able to provide us with documentation around how Treasury analysed those figures and how you interpreted them for the purpose of setting the scope of this scheme?
So, Senator, effectively, as I kind of touched on previously, we've taken figures that AFCA has provided. We've also looked at some historic claims and what, it's not, we've worked, we've had the assistance of the Australian Government Actuary, but there isn't a significant amount of data here to build any what you would call robust models. So we've taken the data that AFCA has and we've looked at some of the historic claims and really worked off that as an indication or as an analysis tool. There isn't, like a lot of the data that Treasury works with, we don't have the luxury of having time series data or lots of kind of robust data sets that we can work on. But I think AFCA's agreed to provide the current stock, where the data is probably a little bit more robust, noting that the compensation figures aren't credible until AFCA's gone through their process. People often either overclaim or underclaim because it's very hard to understand how much of it is misconduct and how much of it is I've actually just made a poor investment decision. But I think I'm not trying to be unhelpful, but there isn't a huge amount more that's been available to us, and it's not for the want of trying.
Well, particularly without the determinations. So, for example, deceptive and misleading conduct, which was seen in the case of Sterling, I would be interested to know how, if managed investment schemes are brought in, where, and I know you can't lodge a claim twice, AFCA said, well, we need the Parliament to change our rules, and therefore you'll need to ask Treasury how to do this. If someone's had a determination that was made, but it wasn't fully paid out because of limits on insurance, how will a claim need to, can the remainder of the determination be paid out under the scheme?
Thanks, Senator. I think there's two parts to your questions. One is around can AFCA hear a matter that it has already made a determination on, and AFCA's rules preclude AFCA from hearing a matter that either a court has made a decision on or that has been previously determined, and that's just to avoid people continuously going through the loop. Your question on partial payments is a slightly separate question. It's around what happens if I got part of the funding, part of my compensation. Assume I was awarded 100,000, I was given 50,000 by the firm, but there's 50,000 outstanding. Ms. Lyon, did you want to respond to the current treatment around partial payment in the CSLR context?
Thank you, Mr. Zahid. So, Senator, a partial payment like that, the remaining portion, assuming it's still under the cap of 150,000, would be payable by the scheme.
Okay, that's helpful. It's one less thing to have to pursue. What can you tell us about access and legal access to insurance that could reduce liabilities for the broader industry when a firm becomes insolvent? Because I know it's a requirement to have insurance in order to be registered. The extent to which those insurances will come into play when a company's insolvent, I imagine that'll all start to get written out of the policies, particularly because, as AFCA finds, they don't have much access or oversight of those policies when making determinations. I can understand why, but in the context of to properly assess how much this scheme will cost, the quality of the insurance products that sit behind it is very important.
So, Senator, the government's announced that Treasury will be undertaking further work on the professional indemnity insurance. So, alongside introduction of the CSLR legislation, the government has tasked Treasury to do further work on the professional indemnity insurance, and in particular with the focus on its responsiveness to the compensation scheme of last resort. That work has kicked off. We've had some discussions with industry around the key kind of challenges. It's not a new issue. We're also looking at issues around what rights can the compensation scheme of last resort have against the professional indemnity insurance. What are the contract terms that may preclude things like that? Ultimately, the professional indemnity insurance is a private market. Australia, in the context of the global market, is a small market. Globally, there's been a lot of pressure on profitability for professional indemnity insurance market, which has meant that supply has reduced. It's similar to a number of other professional insurance lines. So there is a professional insurance market dynamic that's playing out in the background, and insurers obviously look at which segments of the market aren't profitable. We've done some work, and we've actually had some work done for us to look at profitability in the sector, and some of the things that are driving insurers not wanting to insure certain providers is that context around profitability for its sector. But Treasury is currently doing further work in the space.
Managed investment schemes are nevertheless part of that review, even though they're currently outside the CSLR.
We're looking at professional indemnity insurance. The exact scope obviously will be settled by government. We're in the current phase of doing data general Treasury processes. We look at some of the issues, we gather some data, and then we talk to government about what a very specific scope of that review may be. At the moment, we're looking at the professional indemnity insurance market in Australia for financial services, which includes MISs. It includes also the legal terms in those contracts around what is it that would preclude the compensation scheme of last resort being able to claim against that, against PII policies. Could those be changed? If those things were changed, what does it mean to providers' willingness to provide insurance in the Australian market?
Okay. The question of moral hazard was rejected by the Ramsay review. Did, in relation to this bill, what issues, how did the government assess those issues, and did any stakeholders consider it to be significant?
Ms. Lyon, did you want to start on that one?
So, Senator, a good many stakeholders in response to consultation on the compensation scheme of last resort, both with our discussion paper issued in December 2019 and our proposals paper and draft legislation issued in July 2021, raised significant concerns about moral hazard that would be created by the scheme. And for example, you've seen even to your inquiry, the ABA, for example, has put in a submission where they argued for a narrower scheme than the government has proposed. And one of the bases for that claim is their concern about moral hazard for the sectors that are included in the scheme. So yes, there has been a wide range of industry groups who have objected to the scheme existing at all, or to the scope of the scheme, because of the moral hazard issues that it will create. And the flow-on issue that for industry from that is the suggestion that firms either within the sector or in another sector are being asked to pay for essentially the failure of the firm that's become insolvent and who has left these unpaid determinations for consumers.
And does government consider that the extent to which regulation that prevents failure weeds out some of that moral hazard in terms of the onus for drawing the line in the policy settings here?
So obviously, if you've got stronger regulations, the scope for abusing the system reduces, but it's never kind of removed completely. There are some very risky products in the market that's allowed to be in the market it's part of a diverse financial system. And moral hazard doesn't always take away the risk in all of that.
I understand.
So
but the Ramsay review, in saying there wasn't significant moral hazard, also highlighted the need for concurrent reform to improve the safety of financial products and services, to reduce the call on a compensation scheme. So I need to weigh up the extent to which the product intervention power and design and distribution obligations will be effective in reducing the chance of catastrophic failure, as we've seen.
And Senator, you've got I think you've got a challenging role there, because as I've kind of started off saying, is a year or 2 years from now, it'll be much easier to answer that question because we will have the data, we will have the experience, we'll have the complaints data. It's a scheme, the DDO came in and 1 October last year. So 3 months down the track, it's a little bit hard to know how that's going to play out, how effective it's going to be. One hopes that those mechanisms that have been put in place has significantly strengthened the system. It is a big reform to the financial services sector, as is a number of other things that's been kind of put into the system. I just can't sit here today. Ask me in a year, I'll have a much better answer for you in a year's time, unfortunately.
So, and can Treasury be clear today that if the bill is not amended, that all those existing claims that AFCA has not yet assessed or could not be paid out, there'll never be any justice for those victims unless it's amended now? It's not like if we amend it in 2 years' time, we will still be able to catch up on all those legacy claims. Has Treasury assessed that?
So, Senator, I think that's right. That again, it depends on if the legislation is amended at some time in the future, how it's amended. The current legislation picks up all complaints lodged with AFCA from its inception in 1 November 2018, which was consistent with the government's response. Ultimately, if a subsector is not included with the scope of the CSLR, it would be the existing mechanisms around insolvency proceedings and being a creditor in the insolvency proceedings. Generally, it's expected that not a lot of compensation is available to consumers in those processes. And I think
Can I ask, just lastly, what focus did Treasury have on access to justice for these very worthy victims of these financial collapses where they have been victim to very extreme false and misleading conduct and, if you like, a regulatory failure that didn't prevent these collapses from happening previously?
So, Senator, it's something we do look at. I think it is very unfortunate. The Sterling case is a very good one of where consumers do suffer significant detriment. We look at these issues in our advice to government. Obviously, there is a number of trade-offs that government needs to weigh up in terms of cost to the system, efficiency of the system, fairness and compensation to consumers. And that's a very difficult balancing act for both government and parliament. So, we raise those issues, we provide that input to government as when we provide our policy advice.
And so you accept that in the current policy settings, the interests of those consumers who lost money have been traded off against all those other considerations in the case of those that have been excluded from the scheme?
So yes, Senator. So it's something that the government's obviously had to consider. I wouldn't use the term traded off, but it's a balancing act and it's a very difficult one.
Thank you very much, Chair. I might stick a couple more in on notice, but I realise I've had well and truly a good run and that the hour in the eastern states is very late. Thank you.
Thank you, Senator Pratt. I just have two quick questions to end this session, if I could. I'd like to quote from the Financial Services Council their submission, and I quote, there needs to be a further focus to reduce the administrative costs of the CSLR, which have been estimated to cost 46% of levies raised, whilst only 54% of levies are estimated to pay out customers for unpaid determinations, end quote. And in that context of concern about administrative costs, they did actually make some proposals around how those costs could be decreased. And these included, first, is there really a need to have a board for the CSLR? Second, could the processes undertaken by the CSLR be, and these are their words, rolled into Treasury, end quote. And three, could the processes be streamlined using ASIC? So can I, Ms Zahid, could you or one of your colleagues provide a response to the concerns of the Financial Services Council, please?
Sure. So, Chair, it's definitely issues that have come up through consultations and we take very seriously in terms of the efficiency of the scheme and costs to industry. Unfortunately, I do love the suggestion that Treasury administers. I like the faith that the Financial Services Council has in Treasury.
I have great faith in Treasury, and I've got no doubt that you would like further work and further responsibilities, and you've got all these people waiting to undertake that further work. Isn't that the case, Ms Zahid?
Absolutely. So we did look at options. So when we looked at options on who would be best placed to administer the scheme, the issues that Treasury focused on in our advice to government was very much around efficiency, reducing costs on the system. I mean, one of the reasons the legislation is designed to have ASIC administer the levy and collect the levy is to leverage ASIC's existing industry funding mechanism, so that we didn't have AFCA needing to build its own version of the IFM. So those are decisions that have already gone into deciding how best to have an efficient system. Unfortunately, I'm pretty comfortable in saying if Treasury were to operate the system, given that we only pay the states, we don't really make payments to individuals, it would probably cost us a lot more. We haven't costed it, but it's not something a central agency like Treasury does. Looking at the synergies within the system in terms of what the CSLR would be doing, AFCA on balance was the most efficient sort of setup agency that we could find. We did actually engage a lot with industry to see if there were alternative options. And when Treasury is your next best option, it kind of goes to show that probably not other good ones around.
So do you think that estimate of 46% of levies raised going to administration and 54% of levies estimated to be paid out to consumers, do you think that's accurate, or do you think that, or are you more optimistic?
I think I'm slightly more optimistic. There are a number of fixed costs. I mean, in some senses, it's a bit of a challenge. There are some fixed costs in the system of having staff. If you're lucky, you've had no firms go insolvent and have no compensation through the compensation scheme of last resort. That's the world we are all aspiring to. In that case, it's 100% of operating costs and 0%. So it depends very much on experience, and it's very hard to know until we see the flow come through. There is a reasonable amount of fixed costs in a system like the CSLR in terms of developing the processes in place. It's a bit what the legislation does and various other instruments will do is seek to ensure that there is appropriate checks and balances. In terms of, Chair, you mentioned why does CSLR Co need its independent board? We actually received significant amount of feedback from both members of industry and actually members of AFCA, which supported an independent board. The composition of the board has changed in between what various different versions of consultation. It's a very skinny board at the moment. The rationale.
What's a skinny board, Ms. Zahid? How many board members?
Three. Three's a skinny board. Two's a couple. Two makes it very hard to make decisions.
You need an odd number so you get a majority. Is that right?
That's pretty much it, right? You need an odd number, a sufficiently large number. 6 is manageable, but it wasn't deemed necessary.
Okay.
So those sort of efficiency aspects have been very strongly considered and is reflected in the policy. It is the case that when you're setting up a new scheme, there is upfront costs, and it will take experience to identify if there are any efficiency savings to be had.
Just my last question for the day. So you've successfully navigated through this process. If you can get through my last question. And that is, it was a question that was raised by the Stockbrokers Association in relation to their submission. And I'll quote, our particular concern at the time was that under the proposed design, and this is, sorry, I should go back. However, SAFAA has serious concerns with the design of the CSLR, which we raised with Treasury during its consultation on the CSLR proposal paper in August 2021. Our particular concern at the time was that under the proposed design, those who had zero unpaid determinations were paying for the scheme, while those most likely to have unpaid determinations were exempted from contributing to the cost of the scheme due to the application of the $1,000 minimum levy threshold. SAFAA pointed out at that time that this outcome would result in moral hazard. End quote. Could I give you an opportunity to respond to that concern, please?
So, Senator, I think we got a range of feedbacks on that issue of $1,000 threshold. The government's obviously yet to release its draft regulations, and government's policy positions in relation to that will come through when the regulations are released. But there were two kind of sides to the views that were presented. One set was the SAFA view around the moral hazard. The other issue that was raised is depending in the mortgage broking sector, in the financial advice sector, depending on how you were structured, whether you held your own license or whether you were an authorised representative, you could be paying the fees because your licensee passes that through. Now, again, it's a balancing act between thinking about the costs that are imposed on very small financial advice, financial services licensees, mortgage brokers, because as a system, we want competition. We don't want a system that's just, full of major players and doesn't have small players, and the regulatory costs generally hit the smallest players the hardest. But it's a balancing act between that and ensuring there are sufficient incentives and disincentives in the system for misconduct. So those comments came through quite from a number of subsectors, not just SAFA, and obviously it's something that government will take a position on. Mr. Lyon, I might just check with you. You're much closer to this if there's something else we want to add to that. It's the last question, so it's our chance.
No, I think you've done very well. Thank you.
That's a very wise answer, Mr. Lyon. So there you go. Thank you very much. All right. Thank you, Ms. Zahid, and thank you to all of your colleagues for appearing as witnesses today. We really do appreciate it. I would ask that you now disconnect from the video conference. You can continue to observe the hearing, or you can't actually. That's the end of the hearing. So that's the end of the hearing for today. But thank you very much for appearing as witnesses. Thank you very much.
Thank you, Chair. We'll go catch up on the ones we've missed.
Yeah, you can. It's hours of entertainment, Ms. Zahid. Hours of entertainment. We'll do a highlights reel too. That concludes today's hearing. On behalf of the committee, I'd like to thank all those who have made submissions and sent representatives here today for their cooperation in this inquiry. I'd also like to thank Secretariat and Broadcasting for all of the assistance that you provided, and also my colleagues for their assistance in terms of asking questions. The committee now stands adjourned. Thank you very much.
Our thanks to you, Chair. Good night.